Filipino, do I need to increase my fees? Sorry for the technical glitches. We will be starting shortly. Filipino. Sorry for the technical glitches. We will be starting shortly. A very good morning, everyone. We will be starting very shortly. Sorry for the delay caused, but we will be starting shortly. So,
Yeah. Right.
Okay, thank you, sir. On this very bright Saturday morning, I welcome you all on the fourth International E-Conference on Emerging Issues in Legal Aspect 2023 uh, with the title Implementation of Human Rights, International Perspective, Issues and Solutions. For this conference, we are in collaboration with Indian Research Scholar Association. Dear all, conferences are used to bring people together with a common interest and discuss issues and ideas relating to a specific topic. A conference requires intensive time planning, resources, and brainstorming. The main purpose of a conference is to provide a platform for networking, education, and collaborating among individuals and businesses. For this conference, we have our issue for which we have brainstormed for months is human rights. Nelson Mandela, a very renowned personality in the world, which needs no introduction, who was the first president of post-apartheid South Africa from 1994 to 1999. He was a Nobel Peace Laureate in the year 1993. Has very rightly said, to deny people their human right is to challenge their very humanity. Respected audience, human rights are the basic rights which are available to every individual by the very reason that they are human beings. With this in mind, we shall begin our fourth international e-conference on emerging issues of human rights. But first thing first, we should always take the blessings of the Almighty with the lighting of the lamp ceremony. Now, I would like to request all the dignitaries to kindly come on the stage and light the lamp and start the ceremony. This is a symbolic moment that signifies the dispelling of darkness and igniting of thoughts and enlightenment. We deeply appreciate everyone present, making the auspicious beginning of our proceeding today. Witnessing the lamp being lit, may it inspire us all. The flame upward movement, defying gravity, stand as a symbol for our quest for knowledge, upliftment, and the resolve to rise above all challenges. It stands as a testament to the power of light over darkness, knowledge over ignorance. May the brightness of these diyas light our ceremony. A very heartful thank you to our esteemed guest, for leading these auspicious beginnings. As the lamplight continues to radiate throughout the day, let it remind us of our collective commitment to knowledge, harmony, and progress. With this luminous start, we now officially declare the event open and proceed with our planned schedule. For the 4th International E-Conference, our institute, IPM Law Academy, which needs no introduction in the academic world, we had a very modest beginning in the year 1996 with Management, Computer, Application and Education Department. IPM Law Academy is NAC accredited and affiliated to Chaudhry Charan Singh University, Meerut, and approved by the Bar Council of India. IPM Law Academy offers LLB 3 years, BLLB 5 years, and BCom LLB 5 years courses. For this conference, we have collaborated with Indian Research Scholar Association, which is a platform whose objective is to exchange creative, constructive, promotional, and progressive dialogue with research scholars in all the universities, colleges, and research institutes of India doing research in the subject of social science, arts, and humanity. Now, to throw more light on for today's conference and about IPM Law Academy, the most hardworking faculty in IPM Group of Institutions, I would like to welcome our Dean Academic Sir, Mr. Shashank Chaudhary, to kindly come on the stage and give welcome wishes. Please, sir.
Thanks a lot, Aishna, for the grand introduction. The most hardworking faculty is not like that. We all are hardworking here in IPM under the guidance leadership of our executive Dr. Sugandha Goyal, Director General Finance Malhotra, and we all are a team for the success of the several events like international conference we are organizing today. I, Shashank Chaudhary, on behalf of our patron, Mr. Anand Goyal, G, Director General Finance Malhotra, Executive Director Professor Dr. Sugandha Goyal, the law faculty, staff and students of IPM Law Academy, and honorable speakers and participants. Welcome you all who have joined us on Zoom or YouTube, and wish you a very good morning or appropriate greeting as per the time zone in the area from where you are participating in this 4th International E-Conference on emerging issues in legal aspects, implementation of human rights in international perspective, issues and solutions. We are indeed privileged to welcome our international speakers, Dr. Enrico Bonavio, Leader in Intellectual Property Law, Solicitor of England and Wales, the City Law School, City University of London. Rudy Salam Sillinga, English lecturer and international trainer, multi-international awardee, North Sumatra, Indonesia. Ms. Greta Dasi, Asylum Rights Legal Advisor, Kosovo. We are also privileged to welcome Professor Dr. Geetanjali Chandra, Academic Dean Law, Acropolis Institute of Law. Dr. Monica Naran, Associate Professor, the Law School, University of Jammu. Dr. Ramakrishna Punia, Professor of Law, National Law University, Bangalore. Most importantly, the paper projectors who have submitted their quality research papers for sharing the same at this international conference. We greatly appreciate their efforts. We are very happy to state that there has been an overwhelming response from the academicians, research scholars, practicing professionals for submission of papers, both from India and abroad, across all the continents. We are grateful to all of you for this. We also welcome all those who are attending this international e-conference on this very important and upcoming theme and sub-themes. I'm sure all of us will gain a lot from this international conference. All the papers have been checked for their plagiarism and reviewed by the external review board, and only the selected papers are being presented in the conference. So I request All the participants should please remain connected through Zoom or YouTube, as the case may be, throughout the proceedings of the conference. Now, for the benefit of our international and national participants from other parts of India, let me say a few words about the IPM group of institutions, which is hosting this international conference. The institute is located at Ghaziabad, adjacent to New Delhi, the capital of India, and comes under the National Capital Region, that is NCR. The institute was established by late Dr. P.S. Goel with over 55 years of teaching and academic research experience in 1996, and now we are in the 28th year of our existence. The institute conducts professional UG and PG courses in the areas of management, information technology, education, and law, all with the approval of the confirmed professional bodies and affiliation to the universities. Ever since its inception, the IPM, which is NAC A-grade accredited institute, is known for its student-centric approach in teaching and discipline, and has a very good results and placements, and has thus been ranked among the top few institutes in the NCR. As I mentioned earlier, we at IPM have been holding seminars, conferences, webinars, workshops, FDPs at regular intervals to professional experts. This e-conference is a continuation of the same. Based on our experience of conducting international e-conference in physical form as well as through electronic modes, we feel that the electronic mode is likely to stay as the mode of conducting such conferences in the future. Finally, I would like to once again welcome and convey our best wishes to our honorable international and national speakers, paper presenters, and attendees from across the world, and the convener, the co-convener of this conference, and all those who were behind the scenes for the success of this international. Jai Hind. Thank you.
Thank you so much, sir, for this welcome address. Now, I would like to welcome our principal ma'am to kindly come on the stage and give introduction to this conference. Thank you.
A very good morning to the gathering. I, Dr. Meenakshi Tumar, Principal at IPM Law Academy, feel immense pleasure to welcome you all on the behalf of IPM Law Academy. I offer my deep regards to make the session graceful by your presence. It appears you have been provided information about the 4th International E-Conference on Implementation of Human Rights, International Perspective, Issues and Solutions, organized by IPM Law Academy. The conference aimed to discuss various aspects of human rights and their implementation. So, now I want to introduce the basic structure of the conference. Basically, emerging challenges related to the human rights and emerging challenges in India. The advent of 4th generation of human rights, constitutional and legislative framework of human rights, equal employment opportunities, discrimination, and barriers of people with disabilities. Human rights and technology, the internet and the problem of self-determination. Human rights and technology, new challenges for justice and accountabilities. The impact of human rights in COVID-19, corporate social responsibility and human rights during the pandemic, and human rights issues and United Nations responses, inclusive of UN responses to displaced and stressless person in COVID-19. Maintenance of international labor standard of interstate bonded labor and trafficking. The conference aimed to provide a platform for discussing the latest issues in the field of human rights and exploring best possible solution to these problems. Participants are encouraged to present original thematics papers, case studies, survey, project report, action plan, and best practice related to the specific sub-themes. So, without a further ado, I, in behalf of entire fraternity of IPM Law Academy, offers my best wishes to all the international and national guest speakers and presenters. With this, I conclude by uttering my deep regards. Thank you and welcome you.
Thank you so very much, ma'am. Now we are about to begin our technical session 1 or inaugural session. For this session, now I would like to invite our keynote speaker, Professor Dr. Gitanjali Chandra. Ma'am is an academic dean law in the Acropolis Institute of Law, Indore. Ma'am will address the session in a few minutes. A few introduction about ma'am. Ma'am is a doctorate in law. Ma'am has qualified NET and did corporate law and management from Indian Law Institute. Ma'am is an alumnus of Aligarh Muslim University. She started her career as a research fellow on UGC major project. Professor Chandra has completed her successful stint of more than 20 years of teaching in higher education sector in India and abroad. She has worked with NGO and did court practice.
Good morning. Am I audible to all?
Yes, ma'am, you are audible.
So good morning, all of you. And first of all, I would like to congratulate IPM Law Academy for this wonderful international conference and the gatherings of the legal luminaries for this human right conference of implementation of human rights as international perspective, issues and solutions. So before going to come into the topic related to human rights, I just want to, am I audible? Yes? Yes.
Yes, ma'am, you are very much audible.
Okay. So, see, whenever we were talking about human rights, I will not start with the Human Rights Report 2023, which recently come dictate about and explain about human rights violation in India. I must start that how the human rights originated in India and from how, like in the civilization, if you see the Indus Valley civilization, or if you see there are that when we have a culture of dharma, when we have a culture of civilization, the dharma is the one of the concept which we have to understand nowadays also. If I want to quote Jawaharlal Nehru, that there is an unbroken continuity between the most modern and the most ancient face of Hindu thought extended over 3,000 years. It's not the story of a universal declaration of human rights of 1948. It is a way behind. Because if it is a dharma, when we were talking about dharma, dharma is actually wrongly interpreted in nowadays. Because it's a belief, and no dharma is talk about that to curtail any basic human right which we recognize as a human right, but there is a concept. If I may quote a Gita, he who has no ill will to any being, who is friendly and compassionate, who is free from egoism and self-sense, and who is even minded in pain and pleasure and patience is dear to God. I will explain these things. That means if you want to be near to God, if you want to be in a good books of anyone, either in a good God or either in anyone, you have to understand that you should not ill-treat any person. You should not be create any harm, or you should not create any harm to any person. So the most important part which we were doing nowadays, that we forget that we are human, and this forgive, and it is not forgive, because not in this word, in other word also. That means if we believe that there is an existence of God, so we have to understand, on the name of religion, on the name of other things, on the name of business, we can't violate any fundamental and the basic and inalienable rights of human right. That's one has to understand that this is most important part of our life. If religion is very important part of life, we have to understand every religion is not above than humanity, human rights, that we have to understand. In any civilization, any religion will not ask you that to do something inhuman to someone. So in this life, if you see the Vedic period, if you see the Dharma Shastra, if you studied in the Dharma Shastra, for the international speakers and the international people, I must say, and I want to highlight that it is in our culture. India is known for it. If Gandhi, if I say Gandhi is the one who spread in the whole entire world, that's non-violence. So that the principle is actually, if you name non-violence, the first name which comes to your mind is Gandhi, the father of the nation. So if you understand these things, they're like all the things, all the basic rights, all these things come from a dharma. But because when we were as a legal luminaries, and it is a gathering and galaxy of legal gatherings, you will understand that there is a concept of right. Right means when you have a concept of a welfare state, when you have a culture of a welfare state in India, a country like India and other countries also, like we have to give a social justice to people, social welfare to the people. And it's not that government is not doing that thing. Government is not propagating that CSR activity in the business, because sometimes what happens, business money comes up, and because of that, status and money are the two reasons for it. Status and money. Whenever I'm talking about the status, that means the power. And when it is a power corrupts man. And if you are chasing the power, in this chasing, in this race, the human race will left behind. The human race will left behind. So the most important part is, we, in the race of this money making, in the race of this showing ourselves as at the upper strata, we should not forget that the human rights are very important. And the government, just I want to upload the government. The government is, what they are doing is the corporate social responsibility concept, the environmental, the cleaning drive, everything they are doing. But sometimes what happened? Sometimes the implementation problem is there are armed conflict happening. So you all know that there is the example of Russia, Ukraine, armed conflict. There are several reasons for it, like corruption. If you see the corruption is somehow reduced at the present time in India. But I'm not saying completely that it is actually eradicated in that sense. But the most important part which I want to emphasize in this particular conference, and I want to use this platform just to express my view for the reason that you have to understand the most important part of our life is humanity, which sometime when we are doing some deeds, we forget. We understand religion is not explain us that how to only conduct in a way. It is the way of living, and most of the religion will actually teach us humanity. And all religion, no other religion, sorry, I'm for the word, see, the no religion will allow us to do all this thing. But what is happening now? I'm coming to the Manipur. So if it is Manipur is happening between the two ethnic communities, though I mentioned power corrupts people, but power doesn't mean that you curtail anybody's right. You create obstacle to someone. The equality comes from the power. If you misuse your power, if you balance your power, it never violate any human right. But what we did a create imbalance whenever it's a majority and a minority. Majority and the minority in the complete sense of the word. So everyone wants to shows the power and we wants to be in the majority, and to sustain in that majority always sometime violates minority rights. And this happened in Manipur, which was stated clearly in Human Rights Report of 2023. If you see the data, if you see the record of Human Rights Act of 2023, you will see that there is a clear statement, and which was about Jammu and Kashmir, which was about the two union territories, which was about what happened when the basic human right of freedom of speech and expression was curtailed. It is about the Manipur, what happened in the Manipur with the gender imbalance, that there is a gender violence, and this happened and this was reported, and it is the very sorry matter. It is a very sorry matter for India when these things are reported in that way, that the people will understand and people will come to know that these hatred speech are going to up to that far, because you are online right now. If I'm here, a lot of people are hearing me, but see, the thing is, whenever you are, so we have to spread love, we have to spread humanity, we have to spread not this bad image of India in that way, because of the few people who actually spread this kind of hatred things, and which was actually pursued by the rest of the people. This is something very disturbing, very annoying. Though the Supreme Court has taken a very good step for it, and the Supreme Court, I want to applaud the Supreme Court of India for a many reasons in reference to the human right, like when this sedition, the old sedition law of India, they had put it on the hold and halted the sedition. Second thing, when we were talking about, there are certain like in the Bilkis Banu case, that was not as something which has to be done at the early release of the people. There are certain applauded decision of the Supreme Court, like abortion laws, that like immaterial of the marital status of female. There are certain things, if we whenever we remember, there are certain rights which are necessary. There are certain duties of the state to necessary to curtail certain freedom of speech and expression, like for the not availability for the internet. I understand, do understand the government preventive action is the most important feature and the most important issue into the human rights implementation, because we want to prevent, we promise to prevent, but we fail to prevent. We promise, we fail. So if we fail, if we are not fulfilling our promise to protect every human being, we have to understand that it is not only the government will, it is not only the government will, we have to understand and we have to ponder on these issues, that we have to understand this is me as an individual have to protect and take an oath that I am not going to break any human rights. I'm not going to kill anyone. I'm not going to create any harm to any human person. Then only we can implement in that way. Because see, if the government is implementing, or if the government is not doing in the favor of a particular, because see the thing is, whichever side you stand, whichever side, you will be feeling a kind of, suppose I'm in the side of one side, so I feel that is a atrocities happen. But whenever I come to the other side, I will find these atrocities are the righteous way. That's a justice done for them. So one side it is always, so we government has to always, and that's like, I agree, that's a very sorry affair of Manipur which recently happened, and we actually as an Indian was ashamed for it. And I do agree that, like, I can say in this, right now in front of all of you, the platform, that whatever is happening because of the hatred speech, and government, it is stated in the report that the central government has there is a polarization. I must say that that's words which we have used in that's report is reported. That's a polarization against the Muslim, the minorities and all, and other than the ethnic communities in Manipur. So these are the some of the things which happens. But why it is happening? It's only the government is doing. So government is a representation of the people of the India. So the people of the India, if we want to protect all these things, if we want to curb all these things, if we want to curb and implement these human rights, they have to understand we have laws. It's not that there is no laws in India. I must say that there are very good laws, human right. If you see the fundamental rights of enshrined in part 3rd of the Indian Constitution, all fundamental rights are, and we are the signatory for all convention related to human rights. If all these things have done, so where is that missing puzzle? That missing puzzle is us. We were the one who is not protecting. That's why if you see, it's always a culture, like nowadays the culture of mushrooming growth of startup. Earlier, there is a mushrooming growth of, if 20 years back, the mushrooming growth of NGOs. NGOs did a very good work in, but nowadays everyone, after Corona, after COVID, everyone is actually they have a setback. They have setback in every sense. Means their rights, they have the setback in that they in their businesses, in their education. So this is the high time we have to understand that implementation is possible only law means institutionalization of certain things. Law means an institutionalization of lawmaking is institutionalization, but what we need, internalization. Internalization is most important. And why it is most important? That we have to understand, if we change ourselves, we will committed to not to do any violation of human right of any person. That means if all of us who all are sitting in this conference and listening to me are promised that they will not, obviously they are interested in human rights, that's why they're in the conference, but I want that if they convey this message to 5 people, then in that case, that is spreading, the conference purpose is going to be fulfilled. And the conference purpose is why we are facing the problem related to human rights implementing. Now when it is, I completed the part of India, now I'm coming to the international part. See, the thing is, it is political will is most important part. But when it is happening, when you see the Syrian, when you see the countries which are now no more on the bird map, because of want to be in a religious race, the uppermost community. They want to conquer the world. They want to conquer the territory. And in this race of conquering something, having power. So ultimately, the rest of the people are want to show that power. We are not less than you. We are not less than you. That game of power are actually the root cause of human right violation. And when it is, we know the root cause. See, sometimes we don't know the problem. We know the problem. What is the root cause of? See, end of the day, if something happened to us, religion is important. I'm not saying you should not belong, but religion never teaches that to hurt someone. So one has to understand, follow the religion. How many of you, I never went to temple for like recently, 2 months back I went to Mahakal. But see, think of it, the temple we were going, our belief we are going, but it doesn't mean we have to hurt somebody else feeling. If it is, if we have daughters, if we have wives, if we have son, so other people also have that same, sharing the same relation with other people. So we have to understand, if you want to protect our child, if you want to protect our daughter, if you want to protect our wife, we have to understand, we have to protect. If we are protecting us, so then we have to protect other also. And if everyone is understanding only protecting to ourselves, that doesn't gives any solution to us. So we have to understand basic human rights is, it's not only saving culture, saving children. It's not only political and civil rights. It's about the most important part, the most essence of the human rights. You forget that being a human, we have to save a human. And it is very inhuman when you are doing something wrong to someone. And that doesn't mean that, like, if there is police, if there is other people, then only you can save, and then only they it's their duty. No, it's our duty. We have to understand that human rights are the basic human rights. It is the high time, if we are not protecting, don't follow a particular agenda of some political party. Follow your heart. I must say that if you follow your heart, you are going to do a right thing, and no one hearts will say kill other person. So try to understand, being human is the most important part. Being human, and if you are a human, and if you accept, yeah, if you are expecting the humanity from others, so first you have to start with yourself, with your family, with your society, because individual is a smallest unit, and when individuals start, it will go to the rest of the world. So this is all for today, and my all best wishes to the rest of the participant, the all other fellow speakers. And I must say, if it is, I have hurt anybody's feeling, I must say, I apologize from my bottom of my heart. I want to just convey humanity and the human right has to be, have the top priority of the individual, of the country, of the world. Thank you.
Thank you so very much, ma'am. As you mentioned in your session, that human rights and humanity must be the topmost priority of every individual nation and also in among international communities. Trust me, ma'am, if we invite these messages in our lawmaking institution, the world would be a better place to live in. Thank you, ma'am. Thank you so much for an enlightening session. Thank you so much, ma'am. For the next session, we have among us our international speaker, Miss Greta Darcy. Miss Greta Darcy is an asylum rights legal advisor. She's from Kosovo. Sorry for the delay caused. She's not among us. She might be joining us lately. Next guest speaker for this inaugural session is Dr. Enrico Bonadio. Sir is a reader in intellectual property law, solicitor of England and Wales. the City Law School, University of London. So will be joining us from 11 a.m. I am really sorry for the delay caused. We'll wait for the sir to join our session shortly.
आवाज जाएगी लेकिन वहां पे अनम्यूट मत करो, इसको पहले बंद करो। सर हेलो।
We all are waiting. He's from. Sorry for the technical issues. Sorry for the technical glitches. Dr. Enrico Bonadio, professor in University of London, will be joining us shortly. We all are waiting for him. As soon as he comes, we'll resume our inaugural session. A very good morning, Professor.
Good morning. How are you today?
Great. How are you?
Fine, thank you.
Yeah, we all were waiting for you.
Yes. I will speak around 20, 22, 23 minutes if it's okay, right?
It's very good. Thank you. Shall we begin?
Sorry?
Shall we begin?
Yeah, we can start if it's okay with you. Okay.
Let me introduce you again.
Okay.
Now we have among us Dr. Enrico Bonadio. Sir is a reader in intellectual property law. He's a solicitor of England. Sorry for that. And Wales, the City Law School, University of London. So please.
Okay, thank you. Can I share my screen, please? To show some slides. Okay. Can you see the slides? Can you see the slides? Hello?
Yes, sir, we can see.
Okay, perfect. So in this short presentation, I will focus mainly on the relationship between intellectual property and fundamental rights from a European perspective, right? So first, we will look at how IP IP assets are protected as fundamental rights in Europe. There are specific provisions, for example, in the EU Charter of Fundamental Rights, Article 17.2, paragraph 2, and also Article 1, Protocol 1 of the European Convention on Human Rights, which is not an EU instrument, and protects specifically the right to property, tangible property, but it has been interpreted by the European Court of Human Rights, the watchdog of the convention, as including an also intangible asset, intellectual property, right? The fundamental right to intellectual property. And again, the European Court of Human Rights has said so, has often considered economic aspects of IP as fundamental rights. In a series of cases, for example, in the Anheuser-Busch versus Portugal's case of 2007, the European Court of Human Rights has even acknowledged that trademark applications, not even registrations, must be considered as fundamental rights. And in several other cases, such finding has been reiterated. IP is protected as fundamental right under the European Convention on Human Rights. Then, in other cases, the European Court of Human Rights in Strasbourg has underlined the need to protect, of course, fundamental rights, IP, copyright as fundamental rights, but also at the same time the need to balance such rights with possible conflicting of other fundamental rights, such as the right to free speech. So in this case, for example, Aspects-2023 versus France, the case focused on the criminal proceedings against some photographers who have taken picture of copyrighted works and disseminated such pictures, right? They were convicted, no? Criminal on that under criminal law, but they complained that such conviction would violate their right to free speech, right? Which includes the right to commercial free speech, the right to free speech, including the right to disseminate their photographs in the internet. Well, at the end of the case, the European Court of Human Rights said that the conviction of this photographer was for sure an interference with their right to free speech, but it was justified on the grounds of protecting another fundamental right, which is the copyright, right? A very interesting case. Then you may have heard about this case, the Pirate Bay case versus Sweden. Pirate Bay is that website which allowed downloading, uploading of and exchange of infringing files between peers. Well, again here the balance should have been stricken between two fundamental rights: copyright on the one hand and the free speech on the other. So the conviction on criminal law grounds of the Pirate Bay responsible was clear, right? They were condemned on criminal law, under criminal law, for violating copyright, for allowing people to violate copyright on a large scale. So such conviction was an interference with the right to free speech of these people, but it was, again, justified on the grounds of protection of copyright, another fundamental right. And now let's look at some cases, the evolution of the case law at the level of the Court of Justice of the European Union, right? Which is, as you may know, the top EU judiciary, top EU court. We can distinguish two phases of the case law, of the Court of Justice case law, when it comes to protecting, when it comes to balancing IP with other fundamental rights. In the first phase, until more or less 2007, there is no particular attention in the Court of Justice case law to the intersection between IP and fundamental rights, the balance between these fundamental rights. In the second phase, from 2008 to now, we can say that the Court of Justice has increasingly paid attention to such intersection through judicial activism, I would say. So now we are going to see only some cases. There are many cases, but we focus on some of them. Starting from the first phase, for example, when the Biotech Patent Directive was passed by the European Parliament and Council in 1998, said directive was challenged by the Netherlands on the grounds of protection of human dignity, because such directive included and admitted the patentability of isolated parts of the human body. So the accusation in this case was that such provision reduced the living matter to an end, with the consequence that human dignity could have been violated. The right to human dignity is a fundamental right in the EU. The Court of Justice ended up saying, no, there is no violation of the human right, the human dignity right, because, patent law is neutral. The fact that the patent has been granted over isolated parts of the human body does not mean that patent law disrespects, ignores the right to human dignity. There is nothing which violates human dignity in providing the patentability of isolated parts of the human body. That was the conclusion of the Court of Justice. Then there was another string of cases on copyright, where copyright was considered, again, a fundamental right which is necessary to fight piracy, therefore cannot be limited. In the metronome music case, in the Laserdisc case, again, the right to IP should prevail over, other possible conflicting fundamental rights. And in the second phase, instead, we can see how the Court of Justice is paying increasing attention to other fundamental rights which are in conflict with IP. For example, in the ProMusic versus Telefonica case, this was a case about peer-to-peer file sharing, right? Well, ProMusic is a collecting society, representing the interest of copyright owners. They were annoyed that certain peer-to-peer file shares were, exchanging files illegally between them, so violating copyright. So ProMusica, what they did is to ask the Spanish, it was a Spanish case, the Spanish internet service provider, Telefonica, which provided connectivity to these peer-to-peer file sharers, they asked them the names and details of the downloaders, the file sharers, because, as you know, such people are anonymous. They don't reveal their name and their account. But the Spanish service provider, internet service provider Telefonica, refused to give such addresses, such contact details, on the grounds of privacy protection. The case was referred to the Court of Justice for interpretation, and the Court of Justice said in a very generic way that courts, judges, should strike a balance between these two fundamental rights, copyright on the one hand, and the right to privacy on the other hand, okay? But in a subsequent decision, in the Scarlett Sabam, the Court of Justice went a bit further. There, again, a copyright collecting society tried to impose on internet service providers some sort of filtering mechanisms to be inserted in their platform, right? To intercept, to detect, to find out about copyright infringements committed through that platform. Well, the point was that such filtering mechanisms that were imposed on the internet service provider in Belgium, it was a Belgian case, was considered by the Court of Justice as illegal under EU law, because it was a very invasive filtering mechanism, which would have restricted and identified and jeopardize also the lawful exchange of communications. For example, the exchange of and the sharing of works in the public domain, not only copyrighted works. So the Court of Justice ended up saying that, such filtering system would violate the right of free speech of users, the right of privacy of users, and also the right of the internet service providers to conduct business, which is a fundamental right. Okay, I'm gonna now focus on this case, UPS Telecabel. It was the first time the Court of Justice had to decide on blocking injunction, website blocking injunction. So, well, in the latest 10, 15 years, 12 years, 13, 13 years, these kind of orders have become very, very fashionable. Judges, for example, also in UK, which is now outside the EU, have constantly ordered these injunctions, shutting down websites for which piracy, illegal streaming was conducted. So basically, these are blocking orders against users of copyright infringing websites and are accepted under EU law, said the Court of Justice, provided that the user's right to access information is respected. So again, you can see here how the Court of Justice wants to balance two fundamental rights again, okay? This was a case about parody, the relationship between parody as an exception to copyright rights, the rights given by copyright, and on the other hand, free speech, right? Again, here, the Court of Justice said that parody is allowed under EU copyright law as an exception. So parody normally does not constitute a copyright infringement. For example, if you use a parody if you do a parody of a copyrighted work, you can do that as long as you respect fundamental rights of the authors, of other people, right? Again, there is the need to balance two fundamental rights. Then let me just mention this case of a few years ago, Pilam. That was a case about sound recordings, phonograms. In the field of house music, techno music, what is clearly common is the use of sampling, right? Samples in order to produce new music, right? I mean, hip hop, rap, these music genres are constantly consist constantly of their use of samples, the remix, and so on and so forth. Well, the Court of Justice in this case said that the reproduction of even small samples of sound recordings is permissible as long as they are unrecognizable to the ear. In this case, there was 2 seconds as a continuous background loop throughout the recordings. So the Court of Justice said so, again, stressing the need to balance, on the one hand, copyright protection of sound recordings, which is, again, a fundamental right, and on the other hand, the freedom of arts and free speech of those who practice sampling, right? So the so-called creative sampling is the expression of artistic free speech, right? That was the decision of the court. The objection which is made in this case is that, how can a sampled work in fact be unrecognizable to the ear? Yes. I mean, the average listener may often be capable of recognize the sample in the second recording. So this is a bit the weak point of the decision. And let me then conclude with these cases about human embryonic stem cells in the field of patent. No, in 2011, the Court of Justice said that stem cells that have been obtained by destroying human embryos should be considered unpatentable, right? On morality grounds. No, in the EU Biotech Directive, there are specific provisions which ban the patentability of, for example, human embryos for commercial purposes, right? So morality here should be protected. So this decision, as you can imagine, was quite criticized by the industry, the stem cell industry, because it was considered to be anti-business, anti-science, and the industry complained so strongly that in the following case, very similar case, International Stem Cell Corporation, the Court of Justice corrected a bit its case law in its previous decision by saying, okay, there are morality concerns when it comes to exploiting commercially stem cells that have been obtained by human embryos, by destroying human embryos. But we need to distinguish here the situation where the human embryos in question are capable to develop into a human being. In this case, again, patents should not be granted on morality grounds because, you cannot really destroy human embryos that have the capacity to develop into a human being. But if they don't have that capacity, there are human embryos that do not have that capacity, of developing into a human being. Well, in that case, patents can be obtained even if you destroy the human embryo, because the human embryo will not develop into a human being. So in this case, the Court of Justice has distinguished the previous case. So as you can see from these cases, there has been an evolution, right, in the jurisprudence of the Court of Justice. In the first phase, as I said, the Court of Justice did not pay much attention to possible conflicting fundamental rights, conflicting with IP, right? But in the second phase, such attention has been quite clear. The Court of Justice has increasingly looked at the need to balance IP as fundamental right with other fundamental rights. So that was the end of my presentation. I am, of course, very happy now to answer your question. I have already just 5 minutes. 1 second. How can I do? To stop the.
Do we have any questions? I think from Arun Kumar.
Good morning to all and present here. So the question is that we have such kind of the effective laws at at the international level and the national level. So why we are not able to enforce these rights in a more effective way? Like, what are the problems we are actually facing? Like, we have such kind of the great laws. So why they are still not effective in a much more better way, sir?
Sorry, I couldn't hear clearly. Could you repeat the question?
Sir, am I audible?
Yes, you are, Arun.
Sir, we have such more effective laws at international level and national level, but why we are failed to protect the human rights?
Why? Sorry, the last question was why?
Professor, he's asking.
Sir, why we
Arun, please continue.
Can you, because the audio is not really good, maybe the moderator can repeat the question because I can hear you.
He's asking, we in all the countries in the world, we have effective laws, whether at the national level or international level, but why can't we still protect fundamental rights? Looking at what is happening at the Palestine, Gaza, or moving on to what happened in Russia.
I mean, but this is a question which goes beyond the realm of IP, right? I mean, it's not really an because so I'm not really able to respond. Of course, what is happening in the Middle East now may entail the violation of very important fundamental rights. Some commentators have even spoken about genocide, referring to what is happening in Gaza now. But yeah, there are some concerns, but I'm not really in a position now to expand on this because I'm not an expert in that particular specific field. I read something, but I'm not the right person. I can see a comment from Kriti Dash. Can there be one similar IP law for nations across the world? Would that be beneficial for IP holders? Well, I mean, IP rights are protected as fundamental rights under international conventions as well, such as the UN Declaration on Human Rights of 1948, the 1966 covenants as well protect IP, especially the creative aspect of IP, not the economic, as fundamental rights. So there are international instruments which protect fundamental rights, IP as fundamental rights at global level, not only in Europe. Of course, in my presentations, I focus on Europe, but yes, there are international law provisions, or soft law at least. Okay. Okay. Unfortunately, I need to go, so it has been a pleasure, and I wish you a successful conference. Okay.
Thank you, sir.
Bye.
It was a great having you among us.
Okay. Bye-bye.
Thank
Bye.
you.
Bye.
Now we are heading for our technical session 1. For our technical session 1, sorry for the technical glitches. For our technical session 1, the chair of the session will be by Professor Dr. Krishna Kumar. He is an assistant professor, TAV College for Girls, Yamuna Nagar. Sir, are you there? Am I audible to you? Sir, Professor Dr. Krishna Kumar. So we can, as we can see, you're there in the session, but you're not audible. Professor Dr. Krishna Kumar. So can you hear me? So can you hear me?
Hello.
Yes, sir. Am I audible to you? A very good morning, sir.
Hello. Good morning. I'm
Good
audible.
morning. Yes, sir, you are very much. This is a second, sir.
Can you confirm me that I'm audible? Really?
Sorry for the technical delay, sir. Sir, you?
Hello.
Hello, sir. Am I
Ma'am,
audible?
I'm audible.
Yes, sir,
Can you
are very
confirm
much
me
audible.
that I'm audible because your voice is not coming?
Okay, am I audible now? Am I audible now, sir?
Okay, thank you. So first of all, I would like to express my gratitude towards the IPM Institute organizer, and as this is a first technical session, and in this technical session we have near about 12 participants from different institute and colleges. As in the era of global, we are living with a big type of trajectory tragedies like that Russia and Ukraine war, and recently a crisis, a conflict between Israel and Hamas, Palestine. So these crises also have been affecting the status of human rights, individuals, and as well as a nation, a society. So if we go to the trajectory of development of human rights, so we will find out that the Magna Carta is the foundation of human rights. Later on, the Bill of Rights, American, then Bill of French Revolution, then 1917, the Bill of Bolshevik, and the last but not least, Universal Declaration of Human Rights. This is the trajectory development of human rights. And in these human rights, we can divide in categories. The firstly categories like that, first generation. In this generation, the whole world, the whole scenario of human rights has been focused on the political rights. Then second generation rights come, and this time the human rights related with the social and economic rights. As you know that time the whole world divided between two groups, the capitalist and communist. So that's why the world focused on social and economic rights. Later on, third generation rights, these are the, I think I can say these are the individual rights. So this is the continuously a trajectory development of human rights, and now we are in the era of a contradictory where we have some kind of conflicts. Yes, some kind of implicit regarding the relations between individual and society and state, because the whole literature, whole history of human rights just trying to provide answers of their relations, which place of the human rights, which one place of the society, which one place of the states. So once again, I congratulate the organization. Thanks. So now I would call our first participants of in this conference, and I request to all participants that they have they should precise your papers and your PPT, because in this session we have 12 participants and we will have to finish this session within 60 minutes. So firstly, we have first participants. I invited you. This is just a hold. I have a list.
To be presented by Professor Dr. R. Harita Devi, S. Ramana Subramaniam, S. Dhanush, S. Diprasi. The title of the paper is Unpack the Surrogacy Regulation Act 2021.
Hello, am I audible, sir?
A critical analysis of.
So firstly, is our participants is Dr. R. Harshita Devi.
Yes, sir. Am I audible,
S.
sir? Am I audible, sir?
Rama Subramanya as Dhanush and Deepshri.
Hello. Am I audible, sir? Hello.
Yes,
Hello?
you are audible, ma'am.
Yes, sir. I am Dr. Harita Devi, sir. I am
also facing.
Yes, sir. I am Professor Dr. Harita Devi. I am trying. I will be presenting the paper on behalf of all the presenters. Can I share my screen, sir?
Please, you can start.
Yes, sir. So, is it visible? Is my screen visible? Hello. Is my screen visible?
Yes, yes, visible.
Yes, ma'am, your skin is visible.
1 second, ma'am. I just. One second, let me share the screen. Hello. Yes, sir. So our paper is about, I hope I'm audible. Hello. Am I
Yes, ma'am,
audible?
you're quite audible.
Yes, sir. So my paper is about unraveling the Surrogacy Regulation Act 2021. It's a critical analysis of India's newest legislation on the gestational surrogacy. So as it was pointed out right now, the human right aspect of this surrogacy aspect will be detailed in this paper. That is what we have tried to. Surrogacy, as we all know, is something referring to substituting one individual for another in a certain position. The meaning of surrogacy means that. In India, surrogacy is considered to be legalized. And recently we had this legislation of Surrogacy Regulation Act as well as all the other assisted reproductive technology regulations in 2021. But the question remains whether the rights, the human rights of both the surrogate mother, the couple who wanted the child, as well as the rights of the child are really protected under this act. This would be our discussion of this paper. So as per this act, surrogacy means a practice whereby one woman bears and gives birth to a child for an intending couple with the intention of handing over such child to the intending couple after the birth. In fact, there are 4 types of surrogacy: natural or traditional or partial surrogacy, wherein the intending father is genetically related to the child. In gestational surrogacy, the surrogate mother is merely used as an embryo carrier. She has no genetic ties to the baby. Commercial surrogacy is same thing, but the surrogate mother provides her services with exchange of money. Altruistic surrogacy is that there is no financial compensation to the mother who carries the child, and the commissioning parents only pay for her medical costs. Family and the friends frequently use this sort of surrogacy. Now, the question is, in India, which one we are allowing? If we look into the act, actually altruistic surrogacy is the one which is permitted. But before that, if we go to the Human Rights Council, the viewpoints on surrogacy is that the special rapporteur has given the view that there are sale and sexual exploitation of children on the basis of surrogacy, and the research by them has advocated against the selling of children born through surrogacy and highlighted power disparities and risks to both surrogate moms and their fetuses. So India is considered to be the surrogate mom capital. In fact, Gujarat is the place where it is very famous, and so many foreign couples are coming to India because commercial surrogacy is banned in those countries. In India also, by this act, commercial surrogacy was banned. So presently, we are allowing only altruistic surrogacy, and therefore, no money should be paid to the surrogate mother for carrying the child, except for medical and insurance costs. And it also says that one of the salient feature of this act is that the intended parents must be Indian citizen, heterosexual married couple who have been together for at least 5 years in order to qualify for surrogacy. Additionally, a government hospital certificate for infertility, which means the intending couple cannot bear a child, should be certified by the doctors. So this is how the act has been designed. And the qualifications for a surrogate mother is that Section 4 says that she should be between the age of 35 and 45, and she should be a close relative of the intending parents. And clinic registration. With regard to infertility clinics, all clinics must be required to be registered with relevant authorities, and there must be documentation with regard to that. And when it comes to the protection of surrogate mothers' rights, it stipulates that the surrogate mother must be entitled to prenatal care, financial support, and insurance coverage. So these are all protections given to the surrogate mother in this act. But when it comes to the child's rights, according to Section 8, a child born via surrogacy is entitled to enjoy the same rights and privileges as a child born naturally under any currently in effecting laws, giving it the status of the same biological children. And there are penalties for numerous infractions, such as conducting penalties under Surrogacy Act are prescribed under Chapter 7. In fact, if any money is being transacted, then it is punishable. And if the mother is exploited, then that is also punishable. And if the kid born out of surrogacy is abandoned, then that is also coming under penalties. Now, the criticisms, actually, that is our paper all about. The ability of the mother or a woman to decide whether to have children or not, or any unplanned pregnancy to have it or not, etc., is referred to as the reproductive right of a woman. In fact, these rights are broadened to include access to contraception, right to safe delivery, abortion, and to the freedom to choose one's own reproductive choices. So there cannot be any forced childbirth. But in a number of judgments also, under Article 21, the Supreme Court has made it clear that it is the reproductive autonomy also falls within right to life of a person. In B.K. Parthasarathi versus State of Andhra Pradesh and Sujita Srivatsava versus Chandigarh Administration, etc. And recently with the case, Puttasamy case, again and again, it has been stated that women's reproductive freedom also is protected under Article 21 of the Indian Constitution. It falls under right to privacy. And right to privacy is a fundamental right recognized by the Indian Constitution. In fact, in Puttasamy's case, and in the cases of Joseph Shine versus Union of India and Navtej Singh versus Union of India, the courts have established a constitutional requirement to invalidate the laws that promote discriminatory stereotypes and restrict women's sexual autonomy, which includes right to choose their own reproductive options. But despite all these rulings, the Act still bans certain groups of women from the advantages of surrogacy. All are not allowed, which is in direct violation of the bodily autonomy and reproductive rights of women, both of which have been upheld in several other nations too. And when it comes to the child discrimination against a child, the Act says that disabled children, if the parents have a disabled kid, then they are permitted to use surrogacy, even though it is illegal for other parents who do not have impaired children to do so. So, in fact, discriminating between disabled children and others is also violating the basic rights of the disabled children, and it violates the UN Convention on the Rights of Persons with Disabilities, which states that children with disabilities should have equal access to all fundamental freedoms and human rights as other children and should not be subjected to any form of discrimination on account of their disability in particular. So granting surrogacy right or a couple to use surrogate, the reproductive, the right of the mother to have a intending couple who is having disabled children to go for surrogacy, it's itself actually a violation of these rights, the disabled children's rights, because disability they have to be included within the society. Only for the sake, because they are having disabled children, if they are allowed to go for surrogacy, then I think it is not a good option, where many of them would cite many reasons to go for surrogacy, which would be again a violation of rights. And according to Surrogacy Regulation Act, only altruistic surrogacy is encouraged, leading to banning of commercial surrogacy. But again, there is a big question whether in practice, whether commercial surrogacy can be really operated well, or whether this provision can be taken forward well is a big question. Because if there are willing parents and women willing to be surrogates, arrangements will be made whether they are legal or unlawful. But the Act's restrictions on surrogacy may increase the number of illicit surrogacy contracts, which could leave surrogate women more susceptible to abuse and exploitation. The surrogacy industry will be less likely to grow in grey markets if the law is well regulated, and it will be less probable that surrogates will be misused. And also in India, if we take our family laws, all our laws are based on definitions, very clear definitions about father, mother, etc. But if we notice, there is no law defining mother so far, because it's presumed that a woman who gives birth to a child is the biological mother. But when it comes to surrogacy, whether it really, that mother also can be brought here.
Exceeded that prescribed time limit.
And, yes, ma'am, I'll finish it now. And when it comes to altruistic surrogacy, the close relative of a parent. In India, one of the very old surrogate example is that grandmother delivered twins for her own daughter, which means the daughter was unable to conceive. So her mother, that is a woman's mother, she delivered the twins for the daughter. So now under our family law,
the prescribed time limit, ma'am.
Yes, ma'am, I'm completing. And it has to be restricted. So when it comes to altruistic surrogacy, the definitions under family law has to be modified. And these are, whether there is a question whether this is a fine remedy or not. And the other rights like right to livelihood and LGBTQ women are actually prohibited under this act. These are some of the negative points in this act which need to be considered further. Then only this act will get its true meaning. Thank you. Thank you very much.
Thank you so much, ma'am.
Thank you, ma'am.
Thank you.
Our next representative
Any
participant is
questions, sir?
Arun Kumar. Arun Kumar.
Oh. Arun Kumar?
Yeah, our next.
He's a research scholar at the Faculty of Legal Studies, Motherhood University, Roorkee. His title is The Human Rights of Children and Overgame.
Am I audible?
Yes, you are, Arun.
Sir, first of all, good afternoon to all in one for giving me such opportunity so that I can present my paper. My topic is the human rights of children. Can I share my screen?
Yes, you can.
Yeah. Very good.
I have only got 5 minutes to present your paper.
Yes. First, I'm starting that who is considered to be a child. According to the article 1 of United Nations Convention on the Right of Child 1989, which says that a child means every person being below the age of 18 years unless under the law applicable to the child. I have another definition as per Child Prohibition Act of 1986, which says a person who has not attained the age of 14 years and prohibits the employment of children in the occupation. Likewise, we have a different kind of the definition regarding the child. Now I'm talking about what are the laws and the conventions we have regarding the protection of the child. First, we have the
Sorry to interrupt you, but kindly open your camera. We can't see you.
is it visible?
No, you're not still visible.
I think there is some technical glitch on a part. I think.
Continue with the presentation.
Okay, okay, ma'am, thank you. First, we have the Geneva Declaration of 1924, which define various kinds of the right which is given to the child. Like the child must be provided with the resources necessary for both material and the spiritual development. Second, the child must be feed, the sick child must be cared, and the child who's behind in education must be helped. And in times of need, the child must be free to get assistance. Another, we have another declaration, that is Universal Declaration of the Human Right, which is said to be which contain a bulk of the right regarding the all gender, but I am specifically define the rights of child according to the Article 25, which says that the motherhood and childhood are entitled to the special care and the assistance, regardless of whether they are married at a birth or not. All children should receive the same level of social protection. Now we have a temporary social commission of 1950, which is signed by the more than 192 countries at that time. It also enlisted the different kind of the rights regarding the protection, for the promotion and for the development of the child. And the child who are physically, intellectual and social challenge must get the specialized care and education and the therapies. Now we have the one of the most important convention, that is the Convention on the Rights of Child. It is said to be like a backbone for the protection of the rights of the children. As India is a signatory member, so they have passed many laws so that they can to protect the child at the national level. This convention, that less of the child race, sex, religion, political opinion, origin, ethics, and social standing. And they also give some of the basic right, that the right to name and nationality, as well as the right to know and be cared by one's parent, and all are right that every child is entitled to form. Accordingly, in India, we also have some provision regarding the protection of the child, which is also enlisted in the part third of the Indian Constitution. And we have the protection of the children from sexual abuse, that is POXO. So we have different kind of the laws, but the problem is that we are not strictly impose
Only
them in
1
a
minute
strict
left.
sense. Uh, yes, ma'am. I'm finishing it. So rather than to make these all convention treaties laws in a paper, we should like to enforce in a strict sense. Like we should make some monitoring agency, so that we can make the um, actual report what are the actually being happened with the children at a ground level. Okay, thank you, ma'am.
Thank you,
Any
Arun.
questions, sir?
We will discuss, ma'am, later on all papers, and if anybody have any queries, so we will give 5 to 6 minutes for the question answer section. So now I would like to call our next participants,
No, sir, but any question you want to ask?
Gitanjali J.
No, sir,
Ma'am, we will call,
any question you would like to ask?
we will ask all questions another section in the end of this session.
Okay, surely, sir.
Yeah.
Surely.
So can I call next participants? Yeah.
Good
Our
afternoon,
next
sir. Am I
participant is,
audible?
yes, you are audible.
Yes, sir. I'm Gitanjali, and I am the next presenter. Can I share my screen, sir?
Yeah, sure.
Thank you, sir.
And Gitanjali, this is a request to that you precise and complete your presentation within 4 to 5 minutes because we have already uh,
Sure,
10
sir.
participants. Yeah.
Sure, sir. Just a minute, sir. I'm just connecting my screen. I mean, I'm sharing my screen. Just a minute, sir.
Yeah. And meanwhile, I would inform that our next participant is Parveen and Pillai. So he should be ready for his presentation. After that,
Sir, is my screen visible?
yes, it is visible. Please continue.
Yeah. So greetings all. Ma'am, I'm really sorry, but I have very slow net. So if I switch on my camera, I don't think my voice or my presentation will be audible, visible. So if you permit me, can I switch off my camera and continue my presentation?
Yeah, sure. You have 5 minutes for your presentation.
Yeah, sure.
And your time starts now.
Yeah, thank you. So, greetings all. My presentation is on the topic human rights. Shouldn't QI plus community be seen as humans? So, to begin with, to begin with, I want to include the fact that deeply embedded homophobic and transphobic attitudes, often combined with the lack of adequate legal protection against discrimination on grounds of sexual orientation and gender identity, expose many lesbian, gay, bisexual, transgender, queer, and intersex people of all ages and in all regions of the world to be victims and to be victims for a lot of violations of their particular human rights. So there's a brief history which I wanted to talk about, which is divided into international history and Indian history, which I just wanted to give it a glimpse of it. In worldwide in 19th century, the homosexuality was actually coined and it started evolving. And one of the significant change was Stonewall riots, in which, following a police raid on the Stonewall Inn, a popular gay bar, the LGBTQ community fought back against ongoing harassment and discrimination. So that was a spark of modern LGBTQ plus right movements. And following that, there were a lot of activisms around the world. And the major milestone was to remove the homosexuality from the list of mental disorders by the American Psychiatric Association. So that was one of the milestones which had took place in 1973. That was one of the achievements in developing or in bringing LGBTQ community to light. And then following with the 20th century, which had a lot of progress and the ongoing challenges, which included discrimination, violence, and social stigma, etc. And to move on, in the Indian history, we didn't same-sex relationship or same-sex identification was not new. We had lot of scriptures and Hindu texts which depict same-sex love, gender diversity, etc. But once British colonization arose in India, we had the Indian Penal Code, which included Section 377, which criminalized unnatural offenses, including consensual homosexual acts. And following, we had LGBTQ activists in late 20th century, and one of the milestone development was the Navdat Singh Johar case 2018, in which they declared Section 377 as unconstitutional. And this was overriding the case of NAS Foundation in 2001. And following, in 2019, Transgender Person Protection of Rights Act was enacted. But even that act deemed to be inadequate and was very vague. And just to give a one-liner point of view, I also wanted to say that there was a famous research in which it was said that transgenders and people of LGBT community are not new. They are people who are there from the very beginning of human race. So they gave an example saying that at the beginning age there were 1 in 100 people who were from this community, but when you multiply it, now there are almost 7 billion people are in this world. So we can say that for 7 billion people there are 7 crores of LGBT community who have genetically who are genetically having this in their having this traits, which we consider as LGBTQ. So it is something which is genetic, and it is is brought on from generations. So now, because the population is more, earlier it was 1 in 100, but now it is 7 crores in 7 billion people. So if that is the max, then 7 crore number is not little, and to give them recognition is also very important currently. So the offenses include legal discrimination, social stigmatization, lack of protection, access of health, etc. And people suffer a lot of discrimination in employment, in schools, violence and hate crimes, which lead to murder as well, housing and homelessness, health disparities, etc. And even if they achieve something, they are not able to be represented because they are not visible in the society. So people do not see them as humans. So there are a lot of advancements which advocate their rights, which include Universal Declaration of Human Rights, International Covenant on Civil and Political Rights, Convention on the Rights of Children, Inter-American Convention on Human Rights, African Charter on Human and People's Rights, European Convention on Human Rights, etc. All these treaties, these declarations, and many international advancements have emphasized the LGBTQ's rights, their individual protection, and preventing them from being bullied and discriminated in the society. So efforts are being taken throughout the world. And there is one concept of Yogya Karta principles, which was formed by the International Human Rights Law in relation to sexual orientation and gender identity. So it was developed in November 2006 by group of human rights experts and activists. And this was a meeting held in Indonesia. And though it is not legally binding, many governments, international bodies have took it as an important source for understanding and advocating LGBTQ rights within the framework of international human rights law. And it consists of 29 principles, which ranges from all the disadvantages which I said earlier, which includes health, education, privacy, freedom of speech, protection from violence, discrimination, etc. So moving forward, I would like to state my suggestions and findings, which includes there should be a separate detailed legislation which includes all these laws. Though we have laws relating to hate crimes, non-discrimination.
Your 5 minutes are over.
Yeah, just give me 1 minute to wrap up.
No,
So all these equality, all these laws which I have mentioned, there are already laws present currently, but it is separated as male and female, and we have all laws which is separate and does not include LGBTQ community. So it is very difficult for those community to actually come and live in the society. And finally, I would like to state the most recent case of Supriya versus Union of India, which is an ongoing case. And even now, in the recent October 17, just a few days ago, even then, the Supreme Court had ruled a verdict of 3:2 against civil union of non-heterosexual couples. And they have emphasized that the Supreme Court cannot interfere.
You have already exceeded that given prescribed time limit.
Yeah, okay. So still Supreme Court has not taken much effort, and they had initiated into the legislation, and they are supposedly had to take a necessity initiative towards LGBT community rights. Thank you.
Thank you, Gitanjali. So now I would like to call our next participants, Praveen and Pillai, please.
Good afternoon, sir. This is Praveen. I am Praveen Pillai from pursuing LLM from Bharat Mata School of Legal Studies, Ernakulam, Kerala. I am grateful to IPM Law Academy that they have provided me such an opportunity. So here we are discussing on human rights. My topic is sexual and reproductive health rights of women. So could you permit me to share my screen?
Yes, sure. And like to request to that you finish your presentation within 5 to 6 minutes because we have already
Okay.
7 participants.
As we have much discussed about this human right aspect, as right from Magna Carta to Bill of Rights and French Revolution to UDHR, ICP, International Convention of Civil and Political Rights, all, and our constitutional rights under Part 3 and Protection of Human Rights Act 1993. I am just coming to my topic, which is basically women's reproductive autonomy. What women's reproductive autonomy is: have to have or not to have child. It includes right to access education and information about contraceptions and sexual health, when to have children, the right to choose the number of children, the right to access safe and legal abortion, and all these rights are come under reproductive autonomy. In Suchitra Srivastava versus Chandigarh administration, the Supreme Court has included right to abortion under Article 21. So when we move further, we see the in US, the US Supreme Court, Roy versus Wade, has permitted abortion as a fundamental right, as a legal right. Later in 2022, after 50 years, Roy versus Wade was overruled by Dobbs Jackson, and clearly, Supreme Court clearly stated that it is not the tradition of the US to go for abortion. So if you see the United Kingdom law, there is a the Abortion Act 1967 is there, which permits abortion up to 28 weeks, but later it has amended to 24 weeks. Now we come to the Indian scenario. In India, as I already said, that abortion is permitted under Suchitra Srivastava verdict. It is basically governed by the Medical Termination of Pregnancy Act 1971. But if we go to the section 3(2)(b) of MTP Act, read with Rule 3(b), there is a clear discrimination of when a non-married woman come for a abortion. The Rule 3(b) prohibit such abortion. That rule was declared not declared unconstitutional. The Supreme Court has in X versus Principal Secretary of Delhi, Family Welfare, Delhi NCT. In this case, the Supreme Court advised the central government to amend the statute and insert the unmarried woman also can go for termination of pregnancy. If we see in 11th October, the Kerala High Court, 11th October 2023, Kerala High Court permitted a 24 weeks pregnancy because some substantial fetal abnormality was there. If we see the latest judgment of Supreme Court on 16 December 2023, Supreme Court came with another landmark judgment on this field, that two judge bench allowed a 26 weeks pregnancy to abort, but three judge bench prohibited, and they have a different opinion, and that opinion is the right of abortion of child, right of an unborn child must be balanced with the woman's reproductive right. So this was the latest finding of Supreme Court. Since the medical technology has improved a lot, like IVF, ICSI, and ART, the reproductive autonomy can be handled much better. The challenges in Indian scenario is lot, when a woman go for medical termination of pregnancy, infrastructure deficiency is there in hospitals. Cost effective, private hospitals are charging enormous cost, and the Indian Penal Code is playing a chilling effect. Section 312 and 318 of IPC connected with the Medical Termination of Pregnancy Act, giving a chilling effect to medical practitioners to go for abortions. They find different way to delay and not to go for not to attend such a case. Now, I want to with this presentation, I want to conclude with two basic points. First one is, since the technology has improved a lot, so the gestation period of the gestation limitation period of termination of pregnancy must be increased from 20 weeks to 24 weeks, 24 weeks as per the legislature feel good. And second one is the Rule 3B should be amended. Supreme Court advised the legislator to amend 3B, but it should be amended in a very rampant way to include the unmarried women also. Now, at present, it is.
Praveen, can you finish? Sir, you
Yes.
exceeded the prescribed time.
Okay, madam. So,
And 5 minutes
with
are
this
over.
conclusion, I want to conclude my speech. Thank for IPM to human sector.
Thank you so much.
Our next participant is
Recording in progress.
Ravita Haron is our next participant.
I will switch off your camera. Your camera will switch.
Now is it okay?
Next we have Ravita Sharon. She is the PhD scholar in Golgotia University. Ravita, can you hear me?
And ma'am, please call next also. So he will be ready for your presentation. Dr. Abhinav Tomar.
So sir, on behalf of Ravita, Akash will be presenting the paper. He's here in IPM law.
Good morning, everyone. Myself, Akash. I would like to redraw your crucial attention towards one of the most vital issues of our contemporary modern society, and that is known as sexual and reproductive health rights of the women. By the article which is written by one of the most well-known scholar of Golgotia University, Ms. Ravita Sharon, I would like to draw your kind attention. In today's world, it is an imperative task to addressing about the women's rights, because these rights remain the crucial as ever. This article is about the sexual reproductive health and rights of women, by which we are trying to shedding the light on the importance of these rights and the challenges faced while promoting these rights. Sexual and reproductive health are the fundamental and essential for all, ensuring all the women have rights and control to make decisions about her body regarding sexual and reproductive health. Here, the major factor that I would like to redraw your attention in position towards the India. We have seen the past laws related to the sexual and reproductive health were usually focused on trying to control the population instead of protecting the sexual and reproductive rights, especially in the case of women. These laws and rights were seen to be control rights of the women, and this law even made hard for women to make choices about her reproductive health. As per the reports, 78% of abortions in India are unsafe and occurring outside the proper medical facilities. More than 30 million women in India does not get the contraception and the knowledge about the family planning services and facilities. Even more of the most the cases, female does not get, even though the India is one of the most leading countries which have been introduced rights as fundamental rights and implemented so many laws and the policies regarding the health and services and facilities. So here you can see that how much crucial the topic in India is this is, because sexual and reproductive health one of the major topic in India, or we can say in any part of the country, because it's similarly or we can directly uh, proportionate with a woman's health, which is necessary, because only a healthy mother can birth a healthy child, and healthy child is always the future of the world. Legal position of sexual and reproductive health rights of the women over the period of our courts also gave some historical judgment for the health right, for specifically women's rights. In India, as the nation is a very rich in cultural and diverse population, for women in India, sexual and the reproductive rights hold a special significance and negative by diverse culture, social and legal forces. The legal position of the sexual reproductive health rights of the women is in India direct reflection of the nation's state of genders equality and well-being of the women. So this subject is very important. There are many laws, policies, and landmark judgments that have been shaped the society over the years and shed the lights on the challenges those remains and the future possibilities of for empowering the women of India. Thank you so much to give a proper attention towards me, and I would like to end my topic by your support and thanks.
Thank you. So next our participant is Dr. Abhinav Tombar. And after that, Dr. Monica Narang.
Sir, on
So I
behalf
request
of
that
Dr.
she should
Abhinav
ready.
Tombar, so Diksha will present.
Okay.
She is a student of IGIM Mathematics. I, Ms. Sudiksha Sinha, presenting paper on behalf of Dr. Abhinav Tomar on the topic Gender Equality and Gender Discrimination in India, with special reference to approach of judiciary towards gender discrimination and gender equality. Introduction. Equality means all are equal before the law, but when it comes to rights and privilege of the women, it becomes very difficult to get. The Indian Constitution talks about protection to the women in all gray areas of the life, and not only the Indian Constitution, there are other statutes too providing protection to women. Women make up more than 2/3 of the world's 750 million adults without basic literacy skills, and women journalists are more exposed to assault, threats, or physical, verbal, or digital attack than their male counterparts. Meaning of gender equality. Gender equality is when people of all genders have equal rights, responsibilities, and opportunities. Everyone is affected by gender inequality. Women, men, trans, and gender diverse people, children, and families. It impacts people of all ages and backgrounds. We need gender equality urgently. Gender equality prevents violence against women and girls. Gender inequalities and their social causes impact India's sex ratio, women's health over their lifetimes, their educational attainment, and even the economic conditions too. It also prevents the institution of equal rate laws for men. Gender inequality in India is a multifaceted issue that primarily concerns women, but some argue that various gender equality indices place men at a disadvantage or that it affects each gender equally. However, when India's population is examined as a whole, women are at a disadvantage in several important ways. Although the Constitution of India grants men and women equal rights, gender disparities remain. To conclude the topic, it is true that women have been given several rights in the recent years. However, it is one thing passing a law and its absorption in the thinking of society is a different matter. To prove themselves, the women of Indian society still must break the shackles of superstitions and patriarchal thinking. Crimes such as domestic violence, dowry theft, sexual offences, female infanticide, honor killing are still the evils in society which women face, and until these are eradicated, we cannot in true sense say that women have been empowered. Therefore, the continuous support of the judicial institution of the country is needed for the empowerment and progress of women in Indian society. It can be concluded that although being a patriarchal country, we as a nation have been good efforts to empower the women. Our constitution and other various statutes provide protection to women and also aims to empower them. But it is reality as shown in the statutes. The answer may be no, because even today the women in many parts of our country living as subordinate gender and are not given opportunities to avail as basic right as an education. The same can be seen at higher level positions held by the women. It is definitely very less than it should be. Therefore, we have enough laws for the protection, but it's the time for its strict implementation. Thank you for everyone.
Thank you. Our next participant is Dr. Monica Naran.
Good morning, everyone. I am scholar Ashna Bhasin with Dr. Monica Narang. I will be presenting the paper on her behalf. And yesterday I shared my PPT with the coordinators. So if possible, can they play that PPT? I have an issue in my phone and the camera is a little bit. So if the PPT can be made available.
Sure, can you wait for just for 1 second?
Yeah, sure, ma'am. Can I start, ma'am?
And after that, our next participant is Privete R. Nair. So he should ready. After that.
Yes. Can I start, sir? Am I audible?
Yeah, please. Yes,
Good afternoon, everyone. Today's presentation topic of mine is the social and legal paradox relating to marital rape in India, addressing the structural inequalities. Well, a marital rape can be defined as an offense that has been witnessed by women, Indian women from like ages. And that has been because it is a male-dominated society. Men have always dominated women in order to maintain their control over them and to maintain gender inequality. And women, mostly because of their economic dependence on men, are subjected to this type of violence. This also results in other crimes like female feticide, domestic violence, rape, sexual harassment, and among them the most heinous is like marital rape, because as such in India there is no law protecting women, particular law relating to marital rape in India. So rape can be defined as an offense where there is a sexual violence against women. The definition has been defined and it has been advanced from time to time by the Indian government. But there has been no such law to protect Indian women against marital rape. The rape come with physical concerns like unplanned pregnancies, STIs, infections, and like most importantly is depression and suicidal tendencies. But the most important concept in rape is that of non-consent. So when a woman does not consent to intercourse, it amounts to rape, be it a marital or non-marital one. So uh, the Indian law deals with rape under Section 375 of IPC, and the exception 2 of Section 375 IPC provides that a married couple cannot be a husband cannot be made liable for rape unless and until the age of the wife is less than 18 years of age. And there are three parameters to it. If the age of the wife is between 12 to 15 years of age, the imprisonment is of 2 years. If it is less than 12 years, the imprisonment amounts to 7 years. And if the wife is under a period of judicial separation, the husband can be made liable for fine. But there is no recourse to women who are above 18 years of age with the concept of marital rape. To deal with this issue, the Indian government passed the Protection of Domestic Violence Act, and it defined that marital rape can be considered as a type of cruelty, and women can ask for a resolution from the court through under this act. Later on, Section 498 of the IPC was added to it, and it provided that if any husband or any male counterpart puts any kind of violence against women, he can be subjected to a fine of about 30,000 and 3 years in prison. But as such, there is no defined law. The first attempt that was made by the Indian government to make a consensus in the Indian people was done in the 42nd Law Commission in 1971, and the Law Commission report held that that since a couple is married, it is to be presumed that there is a consent to sex. And then in 172 Law Commission, it held that meddling with marriage would amount to heinous, serious consequences. So it was the question of marital rape was unattended to. There has been no response from the government from that time. But in 2012, when the Delhi gang rape case was committed, the Justice J.S. Verma committee was appointed under the retired Judge Justice J.S. Verma, and the committee was of the opinion that the offense of marital rape should be clearly defined and it should be made an offense. But as such, nothing has been done with regard to that. And then came the Criminal Law Amendment Act 2013, also called the Nirbhaya Act, but it only that came into force on February 3, 2013, but that it did not make domestic rape a crime. So as such, the law can be the Indian law can be said to be restricting itself from coming to the front to protect married women who are who are harassed by their husbands and with the offense of marital rape. It becomes violative of the international conventions also, as India is signatory to CEDAW, the Convention on Elimination of Discrimination Against Women, that provides that marital rape is a heinous offense. It is violative of Article 14, which guarantees equal protection to all the citizens at all bases, because every individual is equal. Making a distinction on the basis of gender, it becomes like a violative of Article 15, subclause 3 also. And most importantly, the soul of the Indian Constitution, like Article 21, right to life and personal liberty, is directly affected by this offense, as women being the the major counterpart of the Indian nation, and not they're not they do not have a protection to such offense. So there have been many cases in the recent cases in the past where the Indian judges have also held the view that this offense should be made a crime. Like the recent one, the K.S. Puttaswamy judgment, in which the Supreme Court held that marital rape is a heinous offense against the Golden Trinity articles, that is Article 14, Article 15, and Article 21. Then again in RIT Foundation versus Union of India, Section 375 was challenged, Section 375 of IPC was challenged, as it was discriminatory against women, and the court came to the rescue that yes, it should be avoided. Most recently, the Gujarat High Court in Nimesh Bhai Bharatbhai Desai versus State of Gujarat, it held that incompatibility with Articles 14 and 21 of the Section 375 Exception 2 makes it important that women should be protected and they should be given an equal stand along with men. So on my part, on my opinion, it should I hold the view that marital rape should be made an offense. Giving some of the suggestions to this to deal with this issue, the first thing that comes to our point is that
your time has exceeded.
Ma'am, just give me a minute. I'm just giving few suggestions and I'll wrap it off. like it should be made it should be criminalized, as most of the nation has criminalized it. It should be made a ground for divorce. The victim should be given a voice, like the section 114 of Evidence Act should be made clear that if a woman testifies that she has been raped, the court should agree to it. It should be made a ground for divorce, and the women should be made so strong and so empowered that they should come forward and speak for themselves, rather than being ashamed that their family would not accept them back or their parents would not accept them back. And rather, the government should make rehabilitation centers and shelter homes providing women vocational training. And the government, the judiciary, and I guess most importantly, our male counterparts should be educated enough today so that they understand that women, females, and girls, even of any age, are their counterpart, not their private property. Thank you so much, everyone. On behalf of Dr. Monica Naran, thank you all for hearing to me. Thank you so much.
Thank you, Shane. Our next participant is Prethe R. Nair. Prethe R. Nair. He is present. Is he present here? Our next is Guru Raj Devra Bhuli.
Yes, sir.
Yeah, please.
Audible?
Yes, you are audible, and our request is to you that you
Sure,
just
sir.
precise and concluding your paper, because we
Sure,
are
sir.
already too late.
Okay, so good afternoon, everyone. I'm Gururaj Devrubli. I'm an assistant professor at the Institute of Law, Nirma University in Ahmedabad, and I'll be presenting on my paper on the topic, a critical analysis of substantive access to rights of transgender community through the Transgender Persons Protection of Rights Act 2019. I'll be presenting it along with Ms. Sonalika Nigam, who is a student at the Parallel Institute of Law, Parallel University. But due to limitation of time, I will be presenting it on her behalf as well.
Yes.
With the passage of the Yogya Karta plus 10 principles institutionalize the inclusion of non-binary gender identities such as lesbian, gay, bisexual, transgender, intersex, and queer persons in the discussion of human rights, which was in 2017. Since then, a rapidly growing body of research and activism at regional, national, and international levels has indicated that we are in a historic moment when rights for individuals with diverse and overlapping gender identities are gaining recognition. Now, individuals who are born with basic human rights, so why there is a delayed recognition of rights among the LGBTQ communities? With this particular question, we have attempted to answer the question by pointing out the difference between human rights praxis as a mode through which human rights can be made sense or put into action, as opposed to a theory where human rights is a way of life. Now, embodying the various aspects of the practice, which serves not only as conduits and triggers, but also something much deeper, like co-constructing the process of human rights practice. With this, we adopt a right-based approach to form a community of activists who maintain and spread the practice and implementation of rights through collective action and social movements, introducing new claims and claimants, and also to form the heart and soul of human rights discourse or theory. Now, with the literature which we have relied upon in our paper, it is clear that there are significant gaps and delays which exist between the formulation of the laws and the actual practice of these laws, leading to barriers and struggles for accessing rights, even when policies favoring LGBTQ communities are increasingly accepted worldwide. And the most of the research which is done on LGBTQ communities within the human rights framework has focused on the legal side of the policies rather than analyzing the perspective of practice, access, or implementation of these policies. So with this particular gap, we have tried to understand the Transgender Persons Protection of Rights Act, which has been adopted in India by the Parliament. We have relied upon certain clauses and chapters in the particular act, like the Prohibition Against Discrimination, Chapter 2, the Right to Self-Perceived Gender Identity, Chapter 3, the Offences and Penalty, the Minor Rights, Chapter 5 and Chapter 12, and the Transgender Women and Hijra chapter, which is basically mentioned in the act. We have also discussed the details of the provision and the criticism which is levied against these provisions, but I will not be discussing that because of limitation of time. So finally, I will be giving my conclusion and suggestion based on the research which we have done in this particular topic. I would like to conclude that it is clear that there are certain major gaps which are existing with respect to the implementation of the policy at the national level. Now, the continuous activism and the struggles to claim the rights, which has led to the passage of this particular act in 2019 and the institutionalization of human rights and citizenship for communities with non-binary gender identities. The voices of the hard to reach and marginalized community members has told us a different story, because the journey from legal rights to substantively claiming rights remains unfinished, as well as even after the establishment of rights as decided by the courts. But the implementation of these rights are basically blocked by structural and institutional barriers which are set up by heteronormative norms and cultures. And this non-discrimination based on gender identity is a political right, yet that right is not substantively guaranteed for non-binary people, and they continue to encounter barriers for their economic, social, and cultural rights across institutional spaces. So based on this particular discussion, we would like to say that the fight for substantive rights involves a variety of strategic practices to normalize and publicize their presence and to claim equal treatment across institutions and spaces. And we have recommended that to implement these particular provision, to improve this, to reduce this gap, there should be improvement in the educational equity, including gender studies in the school curriculum for developing awareness of non-binary gender identities from early ages, the introduction of transgender specific training for healthcare providers, government provided inclusive and budget friendly health insurance, providing more institutional support to families, such as counseling for parents or non-binary youth, and finally to increase the adequate representation of non-binary people in positions of power to bridge the existing gap in rights access. So when political rights are achieved through legal means, the road to claims social and economic rights in public and private spaces cannot be achieved without overcoming the structural barriers of class, patriarchy, stigma, discrimination, inequality, and so other norms of heteronormative society. So with this, I conclude my presentation. Any observations or any suggestions are welcome. Thank you.
Thank you so much, Gururaz. Now I would like to call our next participant, is Prithe R. Nair. Are you ready?
Sir, myself Parvati Arnair.
Yeah. Please. So Parvati, it is a request to you that you just conclude your paper because we have lack of time.
Okay.
We will read your paper. Yeah. And next should be Ayushi Bist.
Sir, as I'm moderating the session, I will not be presenting the paper.
Oh, yeah, sure, ma'am. So next would be Parnav Pinakar. He should be ready after the Prithvi. And last is Anand Kumar.
So, can I start, sir? Am I audible?
Yeah. Yes, you are audible.
Is the screen visible?
Yes, your screen is visible.
So, good morning, everybody. Good afternoon.
Very good.
My topic is deals with international perspective and reproductive rights, a study in relation to the recent judicial trend. I would like to start by quoting Swami Vivekananda. It is impossible to think about the welfare of the world unless the condition of women is improved. So, starting with my topic, sexual and reproductive rights are fundamental rights, fundamental human rights, and the international human rights standards. The international human rights standards demand that the sexual and reproductive health services should be available, accessible, acceptable, and of good quality. Then the reproductive rights. The reproductive rights as human rights have gradually been recognized since the International Conference on Human Rights Declaration in 1968 and by the International Conference on Population and Development in 1994. Then the International Covenant on Economic, Social, and Cultural rights. Then the Convention on the Elimination of All Forms of Discrimination Against Women also foreground the focus on reproductive rights as necessary in realizing the human rights of women. Then coming to the Medical Termination of Pregnancy Act 1971, in India, the termination of pregnancy is to be done strictly in terms of the Medical Termination of Pregnancy Act 1971 and the rules framed thereunder. The NTP Act specifies the requirements to be fulfilled for terminating a pregnancy, including the persons who are competent to perform the termination procedure, circumstances when abortion is permissible, and places where the procedure may be performed. I would like to show some differences between the 1971 NTP Act and the NTP Act Amendment of 2021. The Medical Termination of Pregnancy Amendment Rule 2021, it amended the Rule 3 Clause B, then various differences include the 1971 was only applicable to the married women. Then the NTP Amendment Act 2021, it was also applicable to unmarried women. Then the gestational age limit, the Act of 1971 was for 20 weeks for all indications. Then the Act of 2021, it was for 24 weeks for rape survivors and beyond 24 weeks for substantial fetal abnormalities. Then the requirement of medical practitioners, that is registered medical practitioner. In 1971, one registered medical practitioner till 12 weeks and two registered medical practitioner till 20 weeks. Then the NTP Act NTP Amendment Act 2021, one registered medical practitioner till 20 weeks and two registered medical practitioner for 24 weeks and approval after 24 weeks from the medical board. Then the punishment, a breach of women's confidentiality. There is a fine up to ₹1,000 in Act of 1971, and in 2021 the fine and imprisonment of 1 year. Then the recent case of X versus the Principal Secretary, Health and Family Care Department, Government of NCT of Delhi and another. The decision was in 2022. The Supreme Court permitted an unmarried woman to terminate her pregnancy after 24 weeks, which resulted out of a consensual relationship. And the Honorable Court reasoned that the continuation of pregnancy would constitute grave danger to her mental health of the women, and the court gave a wider interpretation to Rule 3B of the Medical Termination of Pregnancy Rules 2003, and I would like to also quote two famous cases, that is K.S. Puttaswamy's case, which held that the privacy enables individuals to retain and exercise autonomy over the individual, over the body and mind. Then Suchita Srivastava and Suchita Srivastava's case, where the court recognized that the right of women to make reproductive choice is a dimension of personal liberty under Article 21. Then the international
can you conclude just because we lack of time? Yeah.
Sir? Yeah, I will conclude in 2 minutes.
Yeah, just you conclude. You provide your suggestion just.
Okay, sir. the global trend in abortion law was been towards liberalization, and in the last 30 years, more than 60 countries have changed their abortion laws, and all but four. They are United States, El Salvador, Nicaragua, and Poland expanded the legal grounds on which women can access abortion services. Since 2022, Argentina and Thailand legalized abortion with certain gestational limits. Then South Korea decriminalized abortion, and New Zealand raised its abortion restriction. And I would like to make a significant mention that state abortion regulation all throughout the country have gotten more complicated ever since the Supreme Court rejected the constitutional right to abortion in Hobbs versus Jackson. Women's Health Organization in June 2022, and the Supreme Court struck down the ruling of Joe versus Wade, which guaranteed the constitutional right to abortion. Then I would like to mention Kenya's High Court recent judgment, which states that the High Court of Kenya ruled that access to abortion care is guaranteed by Kenya's 2010 constitution, and that it is unlawful to arbitrarily detain and prosecute patients and medical professionals for seeking or providing abortion laws. The Kenyan parliament was also instructed by the court to pass an abortion law and establish public policy guidelines.
I think you have exceeded the time limit.
Okay, ma'am, I will end with the recommendations.
Thank you.
So it is okay. Thank you, sir.
Thank you. Thanks. And sorry. Our next participant is Parnav Pinakar and Shrav will sit.
Yeah.
And next is Anand Kumar.
Can we start sharing our screen, sir?
Yes. Yeah, please start.
One second. So is the screen visible?
Yes. It is visible.
One second. So
Yes,
good morning.
yes.
I'm here to present the topic on ensuring the reproductive autonomy and ethical dimensions of abortion as a human right. So beginning with the topic, I'd like to present what is reproductive autonomy. So the autonomy basically states about a woman's individual right to make decisions in regards to their reproductive health and future. It encompasses the right to choose whether to have a child or not, the timing of the pregnancy, and the access to necessary reproductive health care and services. So the principle of bodily autonomy is central here, and empowering the autonomy to make the individual choice with regards to the body internally and externally without any coercion. And the ethical dimensions are basically dealt with three major significant subdivisions: bodily autonomy, women's rights, and the fetal moral status. So the bodily autonomy is basically the control over the entire body, which depends the pregnancy, the mental state of the woman, and the physical state is completely upon the due of a woman, and it should be given upon her to choose it. And prescribing the circumstances of healthness that has been aborted to her, she should be given the right to take her own decision in that matter to have a child or not. And the woman's right is the ability to access the safe and legal care that is to be denied, that should not be denied to her. And the fetus moral status, as such, a child's legal right is not given to his or her until he is born. So it is up to the woman to decide what is good for our child and what is bad. So the section 312 of IPC states that causing miscarriage, even with the consent of the pregnant woman, is a crime, except in the case where she has the right of risk to her life. So in case of Roe versus Wade, they gave the right of abortion to women in the US in 1973. But as soon as the US Supreme Court even ruled out the judgment in significant years of the recent years, the governor signed the bill for the Detention of Heartbeat Act, criminalizing the act of abortion in Oklahoma, and the fetus of 6 weeks and alive cannot be terminated, which is of utter blunder that is being committed, as there is no right that is being given to the woman to choose what is right for her. Which at times of rape or in times of incest, abduction, or any sort of violence that is committed against her, when she's not in a position to end over the proper care, it should be given the right to abort the child, and it is a moral consideration of ethics. So So the medical ethics basically states three principles, that is the autonomy and beneficence and maleficence and justice, individual rights, doctor's duty, and the moral, ethical, and equitable behavior that's to be promoted towards the women. And in regards, the graphs are shown over here, and the bodily autonomy needs to be ensured. Dealing with the aspect that moral consideration and also the religious aspects of the cultural beliefs and the stigmatizing authority that has been signified with the society, that needs to be changed. People need to change about their thoughts. In regards, that is the major probability that there needs to be significant improvement in these considerations. And there are also many significant covenants and conventions that will be dealt by the co-author. And the importance is that the ethical consideration needs to be looked upon. If there is a cornerstone of the women's rights and gender equality, it enables the women to take charge of their own body and future, and it reduces the potential risk of mental and physical capability, and it would be significantly reduced. So there needs to be a lot of change that's to be brought in. In regards, the NTP Act that has been brought in 1971. Significantly, it had a change amendment in 2021, which dealt with the wider scope of women with disabilities and other minor and all considerations. So that's the widest scope that's been implemented. Significantly, there's a lot of countries that need to look upon this matter. As such, Mexico and the South America has exploited, and they have significantly understood its importance and adapted in the recent years that abortion as a right. And significantly, many countries have to still look upon to this issue and make significant decisions about it. So I like to present with my co-author.
So coming internationally, many of the international, treaties and conventions have actually approved of reproductive rights being as one of the important human rights for people. As human rights is available for all and free for all, irrespective of any discrimination, so as such is the reproductive rights of women, wherein each of them should have their own individual autonomy. It's their body, they get to choose what needs to be done. But yes, I do agree, it can't be allowed in all circumstances. But yes, with certain restrictions, abortion should still be allowed. We can see a few of the conventions that is set out, that is Convention on the Elimination of All Forms of Discrimination Against Women. You have the Universal Declaration of Human Rights. You have the United Nations Committee on Economic, Social and Cultural Rights. You have the Beijing Declaration and the United Nations Human Rights Committee, where each one of these committees, conferences and treaties specialize and focus on reproductive rights being as an essential right of every woman. Every woman, every body, it is her life, her body, wherein she gets to decide. It has recognized that reproductive health includes access to safe and legal abortion as an essential component of women's reproductive right. Everyone knows living a healthy life is a very basic human right. And in this healthcare includes reproductive rights, which further includes abortion. Thus, abortion being a very important human right for the people. So coming to some of the conclusions, sessions. Could I conclude, sir?
Yeah, Avnishi, because lack of time, you just provide your suggestion in one
Okay,
sentence.
yes, sir. Sure, sir.
Sorry
Sure, sir.
for this.
So no worries,
You
sir.
provide me a
So coming to
suggestion,
yeah. So
What would be
coming to
your
the
suggestion?
suggestions, few suggestions. As yes, a few countries have already legalized abortion. There are many that have not. So one thing I would suggest is that to make clear legal frameworks that recognize and show abortion is the fundamental human right, affirming an individual's autonomy over their reproductive choices, to give safe, legal, and accessible abortion for those living in urban areas and rural areas, and to educate them upon the various things that is applicable, to ensure that healthcare providers are trained in trauma-informed care to support the individuals after making any reproductive choices, to recognize and respect the diversity of cultural and religious and philosophical perspectives, because because each one of them have their own deep-rooted mindset, which they consider abortion as a taboo. But while respecting their thoughts, you should somehow be able you should be able to help them understand why abortion is needed, why certain people actually need abortion, and you can't just say that abortion is not needed. So you should be able to help them, and at the same time, you should protect the woman from any bias, any discrimination,
Sarah, you have exceeded the
any
time limit.
violence. Yes, ma'am. So I would just like to conclude that abortion as a human right should be implemented in countries as an important fundamental right for everyone, and countries should take steps to safeguard the women's rights. Thank you.
Thank you so much. Our last participant is Anand Kumar. Anand Kumar is
Yes.
present?
Yes,
Yeah,
yes, I'm
please.
ready.
Yeah. So as you already have seen that we have lack of time, so it is request to you that just conclude
Yes,
your
yes.
presentation. I
Yes,
understand because you did all
my
a lot.
topic is a very common topic in the sense that it is a critical analysis of protection of human rights. So I've prepared some slides regarding like what is human right, what is the legislative history, how the Protection of Human Rights Act came into force in India, different bodies, particularly the NHRC, the composition of NHRC, who are members of the NHRC, then appointment of NHRC members, who appoint the members, then removal, grounds of removal, what are the powers of the NHRC. Now, basically, what are the limitations of that? Basically, one of the limitation is that NHRC has always been called by the different bodies, even by the Supreme Court, as the toothless tiger, because it does not have any punitive power, does not have any contempt power. So again, it does not have any independent investigative agency. Its role is mainly recommendatory in nature. It is not binding on the government. It is not binding on the concerned authority. So this is one of the most glaring drawback or the important drawback what we can say about the NHRC, that its recommendations are not binding on the concerned authority, not even on the government. So that's why it is obviously called a toothless tiger. Even regarding the armed forces, the commission can simply ask for the report from the government or the recommendation. It does not. The another drawback is section 36, that NHRC shall not inquire into any matter which is before a state commission or other commission which is duly constituted by law. What happens that if the government wants to avoid any inquiry by NHRC, it deliberately forms another commission, and automatically the jurisdiction of the NHRC is excluded under that. This is another drawback of this act, that automatically if the government want to exclude the jurisdiction of NHRC, they will form a commission and the NHRC will be out of the scenario. Private scarcity of resources, all these are the drawbacks. Normal suggestions that it should be given wider power to call for explanation, proceedings, recommendations should be acceptable, binding on the competent authority, government specific time. So summing up what we have seen recently in the Manipur, coming to the point that what we have recently seen in the Manipur, the ghastly crime particularly committed against the women, clearly shown as that the NHRC as a body is not properly functioning, is not able to perform its function given by the act or this legislative duty. So it is for the time for the legislature to think about it, how to give more power to the NHRC, how it can become more effective. The State Human Rights Commission or National Human Rights Commissions may be given more power. Suo moto can punish the perpetrator of the crime so that they can think twice before committing any act which is violative of human rights. With these words, I conclude my presentation due to paucity of time. Thank you all.
Thank you so much. Thanks. So now it is time to, from my side, that I will just speak within 2 minutes because as we already too late. As we heard, all research papers were very very acceptable and very knowledgeable. We should remark these research papers. I would like to just add some points that all papers are related with the issues of gender equality and right to reproductions, and last paper is related with the mechanism which is working for the protection of the human rights. So these all research papers just in one point which is very common, that is related with the inequality. Because whenever a person claim that his or her human rights have been violating just because of the inequality, and inequality creates discrimination, and who will decide that this is the inequality and this is the discrimination? That is the duty of state. As we have various theories of related to human rights, these two theories. One is natural rights, and second is legal rights. But as I earlier spoke, that there is a contradictory among individuals' rights, state rights, and society rights. And now we are living in the era of globalization. If you look at the whole world, so there are various components which have been responsible for the discrimination and inequality, like that on the ground of firstly class, which is related with the property, as Marx stated that the whole world is divided in two parts, society, rich and poor. The second is race, also responsible for the discrimination on the ground of color, basically in Africa and America. Third is in the context of world, that is gender also. Fourth is caste. Fifth is profession, and sixth is recently is the residential area, and like that urban and rural. So these are the components which have been responsible for the discrimination. So in the perspective of human rights, if you look at that, somebody is talk about that marital rape should be criminalized. But if you go to the its research, so we will find that if we, yes, it is an issue, but if we will do it is criminalized, so it would be affect the our institution, marriage institution. Recently, the marriage institution is also facing a lot of problems in the whole world, because now coming generation is not liking to accept as an institution, marriage institution, and marriage institution is the base of family, and family base is the state, and state base is the internationalism. So these question also we should do research. Next is the right to reproduction. Yeah, we should accept that every individual have a right what she will do with her body. But recently, as our honorable chief justice stated, that there is a need to balance between autonomy of reproduction as well as unborn child. Whether medical and all technology accepted that unborn child for a limited time is not unborn, it is just a non-living. But if we will do it is openly, so it would also affect the health of women also. So these are the very critical questions, and thank you so much. From the my side, IPI Institute principals, management, Priyanka, who provided me such a wonderful opportunity, and I also apologize that I joined late, too late. It is a fantastic experience, and I would like the all research paper will be helpful for the coming generations and policy makers. Thank you so much. Thanks.
Thank you so much, sir. It was quite an enriching experience with you. I do hope the views expressed by you will be really helpful for the people who were presenting the paper in your section. Thank you, sir.
Thank you.
This was technical session 2. Now we are moving on to technical session 2. The chair of this session will be by Dr. Rahul Mishra. Sir is an associate professor in MLS Bangalore. Sir, can you hear me?
Hello, am I audible?
Yes, sir, you are audible and visible as well.
Yeah, thank you.
Thank you, sir. Shall we begin the session, sir?
Yes, ma'am. Yes, please go ahead.
Before we begin the technical session 2, a few guidelines for the people who are presenting the paper. 5 minutes will be provided to each participant for presenting their paper. Kindly present your paper during that duration only. Also, if you're having PPT, kindly change your PPT as per you progress in your paper. So shall we begin now? Shall I call on the first participant? Okay.
Yeah.
So first among us who will present the paper is you itself, Dr. Rahul Mishra.
Yes, ma'am.
So your topic is gender equality in the workplace, challenges and strategies for women advancement.
Yes. First of all, namaskar and greetings to everybody, whosoever is present out here in this August gathering. I definitely must, first of all, express my thanks to the senior leadership, IPEM Law Academy, and Dr. Meenakshi Tomar, Dr. Priyanka Gupta ji, for having given me this august opportunity to share my thoughts out here. And I believe, the title of this conference is very much topical because a lot of presentations have been made in the first session. And I believe this session is also going to be very conducive, because gender equality is a very, very important concern even today also. And therefore, so far as India is concerned, if we go through our traditional ethos, so definitely we keep revering the women, to a great extent. And there is also a shloka which goes like, Yatra Naryastu Pujyante Ramante Tatra Devata. So that is basically the philosophy which we have been carrying along with us. So definitely, now let me just come to my paper. As this paper basically is going to talk about gender equality in the workplace, challenges and strategies for women advancement. So the synopsis is the prologue. Then there is a developmental process, historical evaluation of the concepts, judicial perspective, legislative perspective, and ultimately critical evaluation of the whole thought. So initially, as we can definitely say that gender equality in the workplace is an enduring global issue at present with far-reaching social and economic implications. So we must also entertain this very fact that gender bias remains a pervasive issue of which is affecting hiring, promotions, and leadership opportunities, if you can see. And even today also, there is still this disparity which remains there in our society, even at the global level. Now, when it comes to the hardcore facts, which are like, if you see at the international stage, we have, you can say, out of 1.2 billion people, which are basically living in poverty. So this data is basically provided by the World Bank. So out of these many people, we have staggering 70%, of the section is representing women. So that is one important, I think, alarming disparity, you can say, a scenario which we have been having even today. In addition to that, if we see that despite women contributing more than 2/3 of the world total work hours, their earnings make up only a mere 10% of the world. So that is another important stat which I am trying to put forth before the August gathering here. And therefore, from the since time immemorial, I would say that there has been a lot of, you can say about this very fact that equality has to be established amongst both the sections of, our society. And therefore, a lot of initiatives have also been taken from time to time at the national and international level. Even then, I would just like to tell you some more facts about when it comes to the background of this very concept. Like if you see the income scenario, this vast income gap underscores the deeply entrenched gender biases that continues to plague workplaces around the world. Another important fact is when it comes to, therefore, you can say education scenario, or you can say ownership scenario, again, 1%, is the world wealth is there for the women section, which they are basically enjoying. Likewise, when it comes to the historical perspective, definitely we must give a proper, you can say, respect to people like Raja Ram Mohan Roy and Ishwar Chandra Vidyasagar. They basically went ahead, in the 19th century during British colonial rule. And at that point of time, there were so many social vices which were prevalent in terms of sati, for example. So that was abolished with the help of these people. Then when it comes to the time frame in between 1915 to 19, you can say 47, again, Mahatma Gandhi ji's under his leadership, definitely the scope of women's participation in public life, got better in that sense. And again, Sarojini Naidu's election as the first female president of the Indian National Congress in 1925 is another milestone or example which was set in those times. Understood. So then we have post-independent era also. So let me just try to, because time is less, so let me just try to put forth some of the legislations which were basically crafted, beautifully drafted, and which were put fourth in order to reduce this gender gap, you can say. And the first important, I believe, act was Immoral Traffic Prevention Act in 1956. Then we have Dowry Prohibition Act 1961. Then we have Equal Remuneration Act 1977. Now, if you see the rationale behind the creation of these acts, it was basically said that these acts aimed at addressing various aspects of gender-based discrimination. Then Article 15 of the Indian Constitution must also be looked into. That also tells us, something about gender disparities, which must go, which must not have any place in our society. Then we have the recant programs also, which we have launched in our nation. For example, Stand Up India is one program. Then we have Pradhan Mantri Mudra Yojana also, which has provided crucial financial support to women entrepreneurs. So these programs have basically created a conducive environment for women, thereby establishing and expanding their businesses, thereby contributing significantly to economic growth. Now, next important segment is education sector. So how this disparity gap is has been looked into when it comes to National Education Policy 2020. So I am definitely very positive in saying that this policy has come as a blessing in disguise. For example, you can see here, the priorities have been given with regard to gender equality in education also. And therefore, this policy has shifted aims to ensure that all individuals, regardless of their gender, must have equitable access to quality education. Must have equal access to quality education. What does it mean? If you are literally interpreting this particular provision, it says that it has encouraged girls to pursue higher studies, and definitely they are supposed to acquire greater skills in their lives to become part of national developmental process. Right. In addition to that, we also have the Sexual Harassment of Women at Workplace Act and the Criminal Law Amendment Act 2013. So if you see these acts, if you see the rationale, that basically says that this is a robust legal platform to empower women to report and seek redressal for cases of harassment and violence. Then we also have help desks. Women help desks at police stations, like 112 is the helpline emergency response system, which will provide immediate assistance to women who are found to be in distress. Right. In addition to that, so far as social domain is concerned, again, I must make a mention here of a very, very important legislation, that is Pradhan Mantri Matru Vandana Yojana. So that basically ensures the well-being of pregnant and lactating women, providing essential financial aid to promote mental health. So all these are basically the legal domains. Then let me just try to take you through the national perspective when it comes to this gender biases, gender inequalities, gender equality, and other dimensions. So I must make a mention of the National Policy on Empowerment of Women, which was established in 2001. And this policy is basically dedicated to addressing and eradicating all forms of violence against women, whether physical or mental, in domestic or social context. And this also includes those rooted in customs or traditions like dowry, right? So therefore, all these policies are definitely the eye-openers, I would say. So they have basically given us the legal platform, definitely, which can be used, which can be utilized for the betterment of reducing this kind of gender, issues in between the men and women. In addition to this, you can say, at present, when it comes to strengthening such kind of aims and objectives, we have institutions like women's cells in police stations. We have women police stations. We have family courts also. We have Mahila courts also. We also are having counseling centers. Even legal aid centers are also established. Then Nyaya Panchayats are also there, which are basically helping, all such women who are marginalized, who are living below poverty line, who are not supposed to be the part and parcel of mainstream processes or developmental processes. So even then, they have been provided all such kind of accesses. Now, when it comes to international perspective, how this scenario has been looked into at the international level, I would like to make a mention of a program, that is Women Empowerment Principles Program and Equal Pay International Coalition, which came into being. So 2010 onwards, you can say, this program has been instrumental, and this program has also invited international bodies like United Nations General Assembly, then G20 is also a part, G7 is also a part. Now, when it comes to the association of such people or such nations, basically they have given rise to the principles which offer a framework for mobilizing business efforts towards achieving the sustainable developmental goals. So when it comes to sustainable developmental goals, we must make a mention of sustainable developmental goal number 5, which is basically dedicated to this gender equality and women empowerment, right? So Accordingly, companies which are basically joining such communities, WEP communities, definitely signal their commitment to this agenda at the highest corporate level. And you can say their willingness to collaborate with multi-stakeholders, you can say at the national level as well as at the international level. Then you have the Equal Pay International Coalition also, which is led by ILO, International Labour, you can say, organization. Then UN Women segment is also there. OECD nations have also been a part of it. And therefore, this is another critical initiative which is dedicated to reduce the gender pay gap and thereby realizing equal pay for equal work across nations. So far as industry or you can say factory sector is concerned. So all these are basically the meaningful initiatives which have been taken at the international level, as well as they are also motivating the national forces, understood, to come out with some kind of models which will provide that equitability in between men and women, so that is what is said. Then you have judicial undertones also, though I have made a mention of few cases here, but I will just take up 2 important cases. So the first important case is US Supreme Court case Bradwell versus State of Illinois. This case is very historic, and here Justice Bradley was basically of the view, and in this case this was argued by women's supposed shyness and delicacy rendered them unfit for certain civil roles. Instead, women were often relegated to the roles of wives and mothers, and it was believed to be their inherent destiny. On the other side, you also have Indian Supreme Court, a case that is Air India versus Nargesh Mirza. I think most of you are knowing this very case. So here in this case, it was declared that Air India's policy of terminating pregnant air hostesses as arbitrary was found to be or declared as arbitrary and unconstitutional. So there, then you have, you can say, directive principles of state policy also, though they are not justiciable, but definitely they are basically the guiding principles. They are basically guiding the government in formulating the policies which promotes women empowerment. Now, when it comes to the suggestions, there are 5 to 6 pointers I have mentioned in my paper. So the first is education and awareness. There has to be a positive effort to be put in place by all concerned stakeholders, right, to first of all provide all those inputs to the, you can say, people in terms of women section concerned. Then you have transparent reporting and accountability. So organizations concerned should definitely establish transparent reporting mechanisms for gender related issues such as pay disparities and discrimination. Then you have legislative reforms. So government should also continue to enact and enforce laws that protect women's right and promote gender equality. Then you have leadership commitment, as I just made a mention when I introduced the topic, that still 1 to 2% of the women have, the you can say, access to all those top-notch positions in the private and the public, you can say, sector undertakings. Likewise, you have global collaboration. That is very important because at the international level, a lot of global initiatives are still in vogue. They are in place. So definitely the international community should collaborate on the best practices and share successful strategies for promoting gender equality, and initiatives like the Women's Empowerment Principles and the Equal Pay International Coalition, therefore, are valuable, could be valuable platforms which could be joined in a positive fashion. And accordingly, data must also be shared amongst the nations, right? So that, the nations which are coming out of developmental world or least transition economies could also see the light of it. And there, such principles could also be motivated, could also be implemented. So this was something which I wanted to share with the August gathering here. Thank you so much. Thank you so much for providing me this opportunity to share my views. Thank you so much.
Thank you so much, sir. Moving on to next paper presenter. Next we have Sanjana. Sir, she is an LLM student in Bharat Mata School of Legal Studies, Aluva. Title of her paper is An Analysis of Prisoners' Rights in India. Sanjana?
Yes, ma'am.
Am I audible to you?
Yes, ma'am.
Kindly switch on your camera.
Yes.
Okay, ma'am. I'm Sajana.
Are you?
I'm LLM student from Bharat Mata School of Legal Studies. Shall I start, ma'am?
Are you also presenting the slides?
Okay.
Kindly share your screen.
Madam, I think the rules are very much known to all the presenters, no? Like what time has to be taken by them to finish their presentation?
Audible, ma'am?
Yes, you are audible, but not like you will say it.
अभी तो सेकंड स्टार्ट ही हुआ है।
आपका ठंडा है।
हाँ
ठीक है, जल्दी आ जाओ।
आज जल्दी करना।
सभी लोग कौन जा रहा है?
Ma'am, I can't share my PPT.
ठीक है, so मैंने तो WhatsApp. Have you shared your PPT with the sister in charge?
Shall I present without PPT, ma'am?
Yes, ठीक है. But you're not visible. Can you do it?
Okay, ma'am. My presentation on the topic and analysis of prisoners' rights in India.
You're not visible. सुमित्रा ने संजना जी ने हाँ तो संजना, open your camera, please. You're not visible, dear.
Okay, ma'am.
Yeah.
The word prisoners means any person who is kept under custody in jail or prison because she committed an act prohibited by law of the land. The state is under obligation to protect and promote the human rights of the prisoners. The Prisoners Act 1894 is the main legislation dealing with prison and prisoners, but the majority provisions specify the prison discipline, prison offense, and offense for these punishment for these offense. The Prison Manual of 1970 also contains the provisions regarding the various rights of the prisoners, but the Prison Manual of 1917 was not actually implemented. Then now the position is the Prison of 1894 is only national level document presently the governing prison and prisoner. Sometimes the prisoners were denied the human rights and sometimes basic rights were neglected. After independence, the several notable change has been introduced in the prison system of India. The prisoners available the basic facilities such as follow a ticket on leave, the medical aid, education, and occupational training. Thus, the modern Indian prison is now started functioning as an institution for the treatment and reformation of inmates. All credit goes to the judicial activism. The judiciary has further extended right in favor of the prisoners by interpreting Article 19 and 21 of the Constitution. Then the prisoners' rights under international law. The first one, the UN Charter. The Charter of United Nations was signed on 26 June 1941. The basic principle for the treatment of prisoners was adopted and proclaimed by the General Assembly resolution on 14 December 1990. The important principles are as follows. The first one, prisoners shall be treated with inherent dignity and valued as a human being. The second one, no discrimination on the ground of race, sex, color, language, religion, etc. Then another important, the international law is Universal Declaration of Human Rights. It was adopted by United Nations General Assembly on 10 December 1948. The important principle is no one shall be subject to cruel and inhuman or degrading treatment and punishment. Everyone has right to liberty and security of the person. Then important international law is Standard Minimum Rules for the Treatment of the Prisoners 1955. The first one, the principle of equality should be prevail. The second one, men and women shall, so far as possible, to detain in separate institution. Then International Covenant on the Civil and Political Rights 1966. The first principle is no one shall be subject to cruel and inhuman, degrading treatment or punishment. Everyone has right to liberty and security of the person. Then we move on, rights of prisoners in Indian law. Rights of prisoners under Indian Constitution. The rights guaranteed in Part 3 of the Indian Constitution are available to prisoners because the prisoners is treated as the person in prison. Indian Constitution does not specifically mention the provision relating to rights of the prisoners, but it was determined in the case of T.V. Vadishwara versus State of Tamil Nadu. In this case, the court held that the both convict and freemen are entitled to protect Article 14 and 19 and 21 of the Constitution. Then other rights are right to live with human dignity, right to speedy trial, right to free legal aid, right against custodial torture in prison, rights of inmates of the protective home, rights against cruel and unusual punishment, rights against custodial violence and death in police lockup and encounters, then right to meet friends and consult lawyers, right against solitary confinement, handcuffing and okay, ma'am. Right to reasonable wages in prison. The important case laws are the state of Andhra Pradesh versus Chalam Ramakrishna Reddy. In this case, the court held that every citizen is entitled to the fundamental human rights to life, which can't be violated by any authority. Even while in jail, a person kept their human status and is still entitled to these rights. Then another case law, Husainara Cartoon versus Home Secretary. Then the prisoner's right under Prison Act 1894, Section 4, accommodation of the prisoners, Section 27, separation of the prisoners, Section 31, maintenance of certain prisoners from private sources. Then employment of civil prisoners mentioned Section 34 of the Prisoners Act 1894. Then the position of UK and
Sanjana,
yes,
see
sir.
the thing is, yeah, I see your time's up actually. So can you please conclude your presentation? That will be much better because other
okay,
presenters
sir.
are also lined up. Yeah.
Okay, sir. I conclude my topic. The present trends in that even after convention, the judiciary has an effective supervising role with regarding to the treatment of the prisoners inside jail. When the person is put in jail, he lost some of the fundamental rights like the freedom of movement, the freedom to form association. Then, therefore, the obligation of the state is the record to uphold and ensure that the fundamental human rights are observed and
Sanjana, thank you very much. Yeah, thank you very much. Yeah,
Thank you,
Ayush,
sir.
you can go to the next presenter, please. Thank you.
Okay, sir.
Sir, next we have Mr. Vijay Kamar, who is a research scholar in Modi University, Rajasthan. And title of his paper is Human Rights and Homeless Children, Homelessness of Women and Children in India.
Good afternoon, one and all present here. Thank you, AIPM Law Academy, for giving me this opportunity to speak here. And my topic is human rights. I have already shared the slide. Can you please?
Surely.
Can you please share the slide for me?
Surely, we are working on it.
Okay, thank you. Okay, I'm starting with my paper. So,
Yes, you can start. Vijay, you can go ahead. No problem.
Thank you, sir. Thank you. Human rights and homelessness of women and children in India. As we are already familiar to this term, human rights are those rights which are inherent to human being, entitled to everyone without distinction to race, color, sex, language, religion, political, other opinion, nationality, social original, property, birth, and other type of status. Founded on the principle of dignity and worth of each person. They are universal, inalienable, indivisible, irrelatable, and interdependent. Now, what is homelessness? The homelessness is a situational and social category of people who are in need of housing because they can't afford it or otherwise can't maintain regular, safe, and adequate shelter. A shelter is a covered place that protects the homeless from unsocial elements, store their belongings, and provide clean drinking water and sanitary restrooms. Homelessness of people in India is century-old problem. Homeless include men, women, children of different age and status. Among them, women and children are most vulnerable and marginalized group. India is second most populous nation in the world. According to UN Habitat, India is the home of 63% of all slum dwellers in South Asia. The objective of this paper is homelessness is vulnerable type of urban poverty which need to eradicate from society. The main objective of the study is to raise concern toward homeless women and children to prevent them from different abuses and exploitation by highlighting various hindrances faced by them and calling the attention of concerned homeless women and children in India.
Vijay, can you please let us know the findings of your research? That will be much better because when it comes to the introduction, I think that is very much known to I think everybody whosoever is there in this session. So, what basically have you found out of your research? Like, what are your findings? So that we would definitely like to know. So, can you please throw some light on those findings and suggestions? What you have?
Sir, actually, I have prepared my article in very less time. So, yeah.
Okay, can you see your slides now? They are shown here.
Yes, sir.
Yeah.
Yes, sir.
Yeah. Go ahead, please.
So the
Go
basic, okay. So the basic causes of homelessness are forced migration from rural areas due to emergency conditions, women bear and burnt off disasters such as floods and droughts, rural indebtedness, agrarian crisis, and extensive industrialization and infrastructure projects that displace them from habitat and forcing them to move into cities with their families looking for employment and survival. Lack of affordable houses, demolition and eviction of slum without rehabilitation, domestic violence, family and partnership, marriage breakdown, unfair planning and land use, urban space was used to maintain for benefit of majority. These are some of the causes for homelessness. Now, the constitutional provision for women and children in India. Constitutional provision relating to women and children in India, which are designed exclusively to ensure their safety, security, and guarantee them equal opportunity for development to reach their full potential like any other citizen. Thus, the provision we counter range from affirmative action in form of reservation to institutional arrangement facilitating women empowerment and children care. Every legislation in the country come from fundamental source that is constitution of a country. Constitutional provision for women. The constitution provides special guarantees to women instead of their disadvantages and discriminated position. It also takes into account the possibility the women are subjected to sexual and physical harassment and provide adequate preventive measures for this. Rights guarantees aim at protecting and promoting women's rights are as follows. Right against discrimination. Article 15 states the state shall not discriminate any citizen on the basis of sex. Adequate means of subsistence. Article 39 throws some light on this. Now, Next is right against abuse and exploitation. Women are afforded constitutional protection from forced captivity, human trafficking, and all other form of physical exploitation. It also ensures that specific needs of women are adequately taken into account in respective workplaces. Then Article 243 provides affirmative action for women empowerment that Constitution as envisaged by its framer as an instrument for social transformation also contain measures and institutional mechanism to ensure women equal participation in governance and political decision making. Next is constitutional provision for children. Indian Constitution has provided with constitutional protection of children. Article 21A provides right to free and compulsory primary education for all children age group of 6 to 14. Article 24 ensures safety and to be protected by hazardous occupation up to the age of 14. Article 39E and 39F are related for child protection.
So Vijay, have you done some critical evaluation also in your paper when it comes to you can say implement all these things which you are just showing to us in terms of fundamental rights and directive principles of state policy? Have you found any kind of mismatch in between? Like any case study have you done in your research paper which helps us understand better the modern day scenario with regard to the issues concerning women and children in our country?
No, sir, no such evaluation has been done.
Okay, so what is your conclusion, by the way? What is your conclusion in this paper?
So my conclusion is, despite of various programs and policies adopted by Government of India, it has implemented number of policies, intervention intended to provide housing facilities under the social welfare scheme to people classified as homeless by the official census. Besides government effort, the role of Indian judiciary in recognizing and sanctioning addressing homelessness concern and putting pressure on state to deliver justice to the women and children is remarkable step toward minimizing the problem of homelessness. But still, all efforts and initiative programmed by top authorities, government, and international intervention could not be able to solve the problem of homelessness of women and children, which means things are not going into right direction due to many causes. Government incapacity to provide shelter to the poor because of maladministration and widespread corruption among the concerned department. Poor implementation and monitoring is another reason for homelessness in India. Women and children are still exposed to violence and abuses. Government should build recovery homes for pregnant women, nursing women with mental illness. Regular health checkups and free distribution of medicine, rehabilitation, and other rights of women and children should be acknowledged and protected. For primary prevention, providing affordable housing, job opportunities, and eliminating discrimination are all okay, ma'am. Okay, ma'am. Thank you.
Thank you. Thank you.
So the next who will be presenting the paper will be Divya Kataria. She's a research scholar
Excuse me,
in
ma'am.
MIT.
Madam, my name is there next on the list, Dr. Brinda. I'm number 4, please. As per this.
Ma'am, I think she's fourth. Yes. Dr. Brinda is also there. She's the fourth in the list. She's the fourth.
Okay. Dr. Brinda Gobind Guru Baksni. She's a faculty in KC Law College, Churchgate, Mumbai. Her topic is gender parity in employment opportunities as a human rights for Indian women.
Right, sir. A very good afternoon to the esteemed chairperson of this technical session, Dr. Rahul Mishra, the moderator. Sir, can I continue with your performance?
Yes, madam. Yes, please go ahead.
Yes, a very good afternoon to you, sir, and the organizers. Kindly bear with my bad throat, but I'm still here to present the paper. I really congratulate the IPM Academy along with our SA that has given us this opportunity to present the paper. The paper that I present today is in line with the main theme of the conference, and Dr. Rahul Mishra himself mentioned about the international coalition that has UN has come forward in 2020. And if we are looking at the Indian scenario, the topic that I have taken today is with respect to the equal opportunities of workplace in India for the women. If we see, we just celebrated on 18 September the International Work Pay Day, and worldwide, women, which is very alarming, make only 77 cents for every dollar earned by men. As a result, at the current rate of progress, no equal pay is envisioned till the year 2069. Across the world, women still get paid 23% less than men. Looking at this issue of closing the gender gap requires a package of measures. Germany has introduced a national minimum wage to tackle its stubborn gender wage of 22.4%. And if we look at India, India currently is rated only at 135 out of 146 countries in the global gender gap. Looking at it, I thought my research will be benefit for the future generation to come because 2069 is a long way, so to go ahead. If, like you spoke about Magna Carta, UDHR, ILO, CEDAW, the various provisions of the constitutions, right from the preamble that guarantees the dignity as well as Article 42, 51, they all guarantee the right to live with dignity. So in the wake of liberalization, quickly I bring you back to my research paper and privatization and globalization, women's status has really not flourished despite of the various economic empowerment opportunities and safeguards. This research paper tries to find out whether business at all levels ensure gender parity and explore the gender-based pay gap. The research also tries to find out why women have not been able to get equal opportunities in the employment in the fast-paced, globalized era today, in spite of women earning and being educated and economically self-independent. This research paper has various objectives. At my research paper, you will be able to see, sir. Equal employment opportunity is a fundamental foundation for assuring the non-discrimination and achieving an equal socio-political setup. Particularly, my paper has dwelled into the Indian private sector, which is necessary because if we do not expand the scope to the Indian private sector, keeping in mind the public sector is getting benefits due to the state policies. But if this sector is kept behind, so today in the LPG era, we will be lagging much behind, and women will not have fair, equal policies and equal employment opportunities. We are aware that we have the Equal Remuneration Act 1976, but that is only pertaining to the state regulations. Therefore, the hypothesis is based that there are significant challenges to achieve the economic opportunities for women that are particularly equal. We are not looking here for equal pay for equal work, but we are looking for equal opportunities in the workplace if she is equally educated. So the method of this study has been quite vast, sir, because I have taken this up during my leave period, which was the method of the study has gone through exploratory, descriptive. I have adopted the questionnaire, interview, surveys, simple random sampling method, and it has ranged from the belt of industrial area in Mumbai, that is the Boisar, to Churchgate, and 100 sample size of women from 20 business units were they were interviewed, and their confidentiality has been completely maintained. The limitations, I agree, is that as you may agree, that the sample has not been the entire population, so it may reflect a kind of bias, but still, that is my limitation. And the delimitation is that I try to scope only limit my area to the objectives of my research, trying to narrow it down as far as possible. The study, if you see, has been listed right in front of you, sir, and I quickly come to the findings of the study that there has been a lot of challenges. There are various constitutional provisions which you can glance through, sir, which we are aware and have mentioned it to you in
Yes.
spite of the Maternity Benefit Act. And in fact, I would like to quote a judicial interpretation, the period leave case, where a Supreme Court actually discouraged the prospective employer that period leave will not be given to women because um, actually we need to put her up. Such kind of leaves will actually tend to discriminate her. So it was a positive judgment. There is another judgment of Andre de Costa's case where the equal remuneration was given at par with lady stenographers and male stenos. We are aware of Vishaka's case and many more other case laws. So quickly coming to the findings, yes, my study shows that there are challenges with respect to the gender pay gap, and the at least women mentioned that they have seen the discrimination at equality at workplace. There has been lack of representation in leadership. So, as I said, that every woman wants to come at the top position, but there has been discrimination. There's a difficulty for her to manage her work-life balance, which is very important, and top private companies are trying to look into this area. There has been sexual harassment in spite of the Vishaka's guidelines. There has been stereotypes, there has been problem in networking and sector-specific variations. I would like to conclude the paper by saying that this research is instrumental in raising the awareness to guide the policies and corporate strategies, whether private or public, and the need of gender equality in the workplace. There are various suggestions that I like to put forward in this paper is that we need to have strict enforcement, mandatory reporting wherever we see such discrimination in equal pay. Definitely the training and awareness to the patriarchal setup will definitely go because we were born to be equal, as you said, the Magna Carta gave us that freedom. So we are actually not asking for equality, but Article 15 E says that we should renounce practices that are derogatory to women. Definitely the government support will help. Skill development, the government is trying, but how far the private industry will adopt this needs to be seen. Self-help groups already been mentioned by you, sir, and friendly family policies need to be implemented. I like to conclude by saying that gender-based employment, equal opportunities in the private sector is not an enforceable obligation on the employer, but a social obligation as mentioned earlier by you. And the strategic imperative is aimed to enhance the profitability, competitiveness, growth, and long-term stability. If we include the marginalized gender, who is in a who needs to be brought up in an affirmative environment and allow them access for a safe and secure, clean, hygiene workplace, then definitely our businesses will empower them and they will contribute for an equitable purpose and a better society and prosperous future. Thank you, sir, for bearing up with me. There are
Thank you,
many
Dr. Vrinda.
references. Yes, there are many references that I have referred. One book that I would like to bring is that EEO Law and Personal Practices, the third edition by Arthur Goodman, Laura Cox and Stephanie, which will really help if anybody reads it.
Thank you very much. Thank you very much for this enlightenment. I believe when it comes to the implementation and enforcement, that is, I think, very important. Even in my presentation, also, I mentioned that stuff. And see, if there is something which we can definitely take in a positive way from the other nations, definitely it has to be taken. Plus, in the timely manner, things are to be processed. So that is very important. And I think issues are still pertaining with regard to the people who are marginalized, right? Who are living in the remotest corners of our nation. So they do not have even any idea as to what constitution of our countries, though they are definitely Indian citizens. So in that sense, I think the sensitization is also must to be done by all concerned stakeholders, and only those people will know. And legal service clinics, we have the concept of legal service clinics. So through them, with the help of our students and faculty, we can definitely help out, those people, who are not into the mainstream. So accordingly, you can say things could be done, things could be positively done, they could be taken forward. Thank you so much, Dr. Vrinda.
I appreciate, sir. The only drawback is that the writs are applicable only to the state.
Yes,
And if we
yes,
look at the private, we need to include them under the ambit of Article
yes,
12.
yes,
Really good
absolutely right.
coordinating with
Yeah,
you, sir.
thank you,
Really
Dr. Vrinda.
looking forward to coordinate somewhere with
Same
you.
here,
Thank you.
thank you.
Thank you very much to the IPM Law Academy for giving this opportunity, particularly to the principal, Dr. Meenakshi, as well as
Yes.
Priyanka and Sonam and Dr. Joshi, who has been there throughout. Thank you to the student participants and research papers. Thank you, esteemed sir. Thank you so much. Thank you.
So next we have Divyya Katal. She's a research scholar at Amity University, Noida. So title of her paper is the compensatory mechanism for the acquitted victim of wrongful prosecution.
Divya, are you there in the meeting? Divya, are you there? Ma'am, you can send a message also in the chat box. If she is there, then, otherwise we can go to the next presenter. Let her join in between, yeah.
Hello. Yes, Divya. Are you in the session? Okay, so we can call next one and
Yes.
you can connect, okay? After this, okay. Next. I think we should allow our base presenter and she internet connection problem है She has नेक्स्ट को कॉल कर लो So the next should be presenting a paper is Himanshu. He's in Faculty of Law, Aligarh Muslim University. The topic of your presentation is Right to Die in India with special reference to human rights.
Ma'am, am I audible?
Yes, yes, you are.
Ma'am, first of all, I would like to thank the IPEM for organizing this event, and a special thanks to Mr. Sohail Khan, who is an assistant professor in your faculty. For enlightening my mind to participate in this. So, ma'am, my topic is Right to Die in India with a special reference to human rights. Ma'am, I would like to request, and I will also send the message to kindly share my slide from your side.
You're working on it. Just give us a second.
So, shall I start?
Yes, yes, Vivanshu, you can start. You can go.
Okay, sir. So, right to die or euthanasia. Euthanasia and human rights are closely intertwined, as the decision to end one's life or assist in ending someone else's life raises ethical, legal, or moral question. The right to die with dignity is considered by many to be a fundamental human right, as it pertains to personal autonomy, bodily integrity, and the ability to make decisions about one's own life. Advocates of euthanasia argue that individuals should have the right to choose when and how they want to die, particularly in the unbearable sufferings or terminal illnesses. They believe that denying this right infringes upon an individual's dignity and autonomy, and that everyone should have the freedom to control their own lives, including the decision to end it. On the other hand, opponents of euthanasia raises concerns about potential misuse, ethical consideration, and the sanctity of life. They argue that legalizing euthanasia or providing a broader right to die could lead to vulnerable individual being coerced into making decisions against their will or undermine the value placed on human life. They believe that society has a duty to protect and preserve life even in the face of suffering. The debate on euthanasia and the right to die is complex and multifaceted, involving consideration of medical ethics, legal frameworks, and societal norms. It requires careful examination of individual rights, the role of healthcare professionals, and the responsibilities of the society as a whole. Many countries have grappled with this issue and have implemented different approaches. Some countries have legalized euthanasia or assisted suicide under specific circumstances. Like in India, the euthanasia is legalized in a passive situation when no other option has left for the treatment. Others have chosen to prohibit euthanasia outright, emphasizing the importance of preserving life and providing the palliative care for those facing end-of-life sufferings. In India, the euthanasia for the first time came into thought in 1973 when in the case of Aruna Shanbag. Aruna Shanbag case was decided in 2011, but Aruna Shanbag was a nurse who was raped by a cleaner staff, and the country has seen several prominent cases like this one. For over 4 decades, she remained in hospital bed, being cared for by her staff. In 2011, a plea was filed in the Supreme Court of India seeking permission to withdraw life support and allow her to die peacefully by Pinky Virani. The court rejected the plea. The bench of Justice Sudha and Justice Markande Karju declared that she should not be given euthanasia. She should not be allowed to end her life. But some of the points some of the points were laid down in this particular case. Then that when can a passive euthanasia be allowed? So this case is also called the first step towards passive euthanasia. Another notable case, that of Pinky Virani's pleas on behalf of euthanasia. In 2018, the Supreme Court of India delivered a landmark judgment on euthanasia in the case of Common Cause versus Union of India. The court recognized the right to die with dignity as a fundamental right under Article 21. This case is also based on the principles of human rights. The case established strict guidelines and safeguard to prevent misuse or abuse of euthanasia. It stated that euthanasia can only be performed after obtaining permissions from a medical board and with the consent of the patient of their close relative. As in the Aruna Shanbeg case, Pinky Virani was not her close relative. She was just presenting Aruna Shanbeg. That's why she was not given the right to die. And the court emphasized the importance of ensuring that the decision is voluntary, informed, and based on competent medical advice. While passive euthanasia has been legalized in India, active euthanasia, where a person actively administers lethal drug to end another's life, remains illegal because it is not on the points of the human rights. Human right does not allow active euthanasia. Only passive euthanasia is allowed by accordingly to the human rights. The debate on active euthanasia is still continuing. Euthanasia, I would like to now conclude. Euthanasia and the right to die remain contentious issues in India, with differing opinions based on culture, religion, religious and ethical beliefs. The cases mentioned above have played a significant role in shaping the legal and ethical discourse surrounding euthanasia in the country. That's all from my side.
Thank you. So I think you have raised a very important point when it comes to your presentation, Vibhanshu. So I believe a right to die is still, I think we have different facets in our country, which, because we have different segments of people in our society.
Like
so
religious.
definitely, again, mass sensitization is a must. And as you were talking about passive euthanasia, still, there have been a lot of practices even across the world also. You might have touched upon in your paper for that matter, as I can see some of the global implications of this concept. So definitely, I think it's a long way to go when it comes to the perception which we have. And I think unless the perception gets better and better, still things will be a bit perplexed for us to be understood in the right perspective. So thank you so much for your contribution, Vibhanshu. Thank you so much.
Welcome, sir. Welcome, sir. Thank you.
Next presenter, please.
Next we have Advocate Abrahami G. Nair.
Yes.
She's pursuing her LLM in commercial law from Bharat Mata School of Legal Studies.
Right.
And her topic is the gender equality and women empowerment and analytical study related to Indian scenario.
Right.
Good afternoon, sir.
Hello, good afternoon.
Let me introduce myself. I am Abrahami Chinair, and I am currently pursuing LLM Commercial Law at Bharat Mata School of Legal Studies, Ernakulam, and I am from Kerala. And I am really thankful to the IPM Law Academy for giving me such an opportunity to present my paper. And today I am here to present a topic on gender equality and women's empowerment, an analytical study related to Indian scenario. And I want to share my PPT, sir.
You can. Yes, we can see. Yeah, we can see your PPTs. Abhirami, we can see your PPTs. You can go ahead.
Okay, sir. And before moving on to my topic, I would like to say a few words by Swami Vivekanandan. And he said that our only right of interference is to provide education, and women must be given the resources they need to find alternatives on their own, and nobody should or can do this for them. And our women from India are just as capable of doing it as anyone else. And the term gender refers to the advantages and disadvantages that come with being male or female in terms of economic, social, and cultural factors. And being a man or a woman in most countries involves more than just having distinct biological and physical traits.
And being equally fair to men and women is the process of gender equality. And in order to maintain fairness, it is frequently necessary to have methods and measures to make up for historical and societal disadvantages faced by women. And the relevance of gender equality, its contribution to women's empowerment, its role in development, and its mainstreaming in development are all discussed in this article. And this paper discusses the value of gender equality in accomplishing the objective of women's empowerment. And this paper's finding and policy recommendations are presented towards the conclusion. And the next is what the society seeks in terms of gender equality and the perspective people adopt and the manner in which they approach a situation determine inequality and prejudice. And children, women, transgender people, and even males are all impacted by inequality in gender. And a vital part of achieving gender equality is the empowerment of women, and the achievement of gender equality, as well as a number of other development goals, is aided by providing women with equal opportunities and ensuring their equal share of rights. And the next is the current laws in India promote gender equality. And the gender equality for women was slightly facilitated by the Indian Constitution. And the preamble, the fundamental rights, the fundamental duties, and the derivative principles of state policy are all make a reference to gender equality in the Constitution. And the Constitution not only promotes the state to implement different measures of equality and women's empowerment, but it also guarantees the empowerment of women. And the next is the constitutional provisions. And in terms of gender equality and equality in general, the articles 14, 15, 15 clause 3, 16, 39A, 39B, and 39C, as well as Article 42 of the Constitution are particularly significant. And the next is the legal provisions. And the legal provisions are broadly classified into two groups, and the crimes mentioned in special laws and crimes listed in the Indian Penal Code. And the crimes mentioned in the special laws are the Equal Remuneration Act of 1976, the Criminal Law Amendment Act 2013, and Sexual Harassment of Women at Workplace, and the Women's Reservation Bill, and the Dowry Prohibition Act. And these all are coming under the crimes mentioned in special laws. And
Abhirami, just observation, like what are the findings in your research? Because when it comes to some of these cases, I think they have been referred to by the previous presenters also. So if there are meaningful findings which you found during this research, we will be so happy to have them here. Second thing, just a suggestion to the title of your, you can say, article. I think you can rephrase your title in this sense, like gender equality and women's empowerment in India, then a colon, and analytical study. So you should. I think it will look nice. It will look better if you rephrase your title this way: gender equality and women's empowerment in India, colon, and analytical study. That will be much better. Otherwise, this is a bit confusing. Second thing, this findings, if you have come across, then let us know, please. Any loophole which you have found while implementing all these things in terms of laws, statutes, regulations, any kind of case study which you have done, we will be so happy.
And in the case law, I mentioned is Vishaka versus state of Rajasthan. And this is the landmark case, which is the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013 was enacted as a result of the court's implementation of the Vishaka's guidelines. And the court concluded that the Indian Constitution's Articles 14, 15, 19, and 21 were clearly violated by the sexual harassment. And the another case is Lakshmi versus Union of India, and it was the case of 2015. And here in this case, the Supreme Court was requested to make orders and offer suggestions for how to stop acid attacks, acid assaults. And in light of an increase in such attacks, the court ordered the federal and state governments to prohibit the sale of acids and without a permit anywhere in the country. And these rulings clearly cleared the door for the enactment of harsher punishments for those responsible for such offenses. That's all. And the Air India versus Nargis Masra, and the another case is Vinny Sharma versus Ragesh Sharma.
Okay, so what is your conclusion? What are your concluding remarks in this presentation?
Okay, sir. In my conclusion, the gender equality is important for achieving the aim of women's empowerment, as was made abundantly obvious. And it has been noted that the woman in India has experienced a variety of forms of discrimination as well as barriers. And thus, achieving gender equality and the they must give the equal opportunities to all the women, and the following actions can be taken into consideration, and in order to achieve the gender equality for the a well population, and as also as well as the socio-economic growth also.
I hope you have done the doctoral research, right? We have gathered the data from the secondary sources while writing this paper. Is it right?
Yes, sir, yes. I'm only due to the lack of time, I'm only done the work as a doctrinal method.
Right. So these are your prospective suggestions, which the concerned stakeholders must look into, right?
Yes. Suggestions only I'll give on. Findings I am not taken in.
Okay, fine. Thank you. Thank you very much, Abhinav. Thank you.
Thank you, sir. Thank you. Thank you so much.
I think Divya is there. Ayushi, can you see Divya is, I think, there. She's there. Ayushi, can you just unmute yourself, Ayushi? Unmute yourself.
Oh.
Yes.
So now we have Divya Kataria amongst us.
Yes.
So she's a research scholar in Amity University, Noida.
Right.
Her topic is the compensatory mechanism for the acquitted victim of wrongful prosecution.
Right.
Divya,
Divya, you can go ahead. Yes.
Yeah, thank you so much, ma'am. Thank you so much, sir, for giving this opportunity to me to present my research paper in this international conference. First of all, I would like to thank IPEM in college for this organizing such a great platform where we can exchange our thoughts with each other, which can enrich our knowledge also. So I would like to go with my presentation now. I hope my PPT has been visible.
Yes, I can.
Yes,
we can
it's
see.
very visible. Quite visible.
So the topic of my paper presentation is compensation mechanism for the acquitted victim for the wrongful prosecution. I myself, Divya Kataria, the research scholar from Amity Law School, Amity University, Noida, under the co-authorship of Dr. Aditya Tomar. He's a PhD guide of mine, HOI of Amity Law School, Amity University, Noida. So as we know that we have a mechanism, there is a compensation procedure for those who have been acquitted by the court where they have been charged for malicious prosecution. So we know that we have the system, but it exactly we see in our Indian criminal system, we are not providing the appropriate compensation to the victim. So what let us understand what is the wrongful prosecution. It is basically when any person who's been kept behind the bar and has been acquitted just because he or she does not have a sufficient evidence for which he can be proved that he is guilty for that offense, will acquit that person. So just by putting him behind the bar, it is nothing. It is a violation of a human right of that accused person, and that is the accused person has to face the serious consequences as well as his family member. The losses cannot be only subject to financial, but it can be the mental trauma and the other damages, like his reputation will be gone, he will be losing his job, and he will be treating as a criminal. So which is not wrong as such. So the victim, they are not adequately compensation for the actual loss which they have suffered during this. So as I've already told you, there is a loss of the reputation also. So if we are not giving a proper compensation, it is nothing. It is a gross miscarriage of justice. So we have to find out the proper comprehensive mechanism for such kind of things. Already there are so many latest judgments are there in the support of this. I'm just going to tell the names for the cases. Like if we go with very recent case, there's a Ganga Prasad Rai versus State of Uttar Pradesh. The case judgment is of 2019, where the principle is established, which says that the victim of wrongful should be given a adequate compensation for all the losses. But the court has also said that whatever the losses been suffered by the victim, we have to compensate, as well as the state should be punished for that. So if we go with the overview of this, so it is that that is a right, it is violation of the right to be free from the wrongful conviction as well as right to free trial. So we have to ensure that justice is done, and we should have to protect the interest of the accused by providing them with a free trial. So which now if we procedure part which is there in our system, so it says we can sue for the damages, we can seek the right to victimization through the court. But
Divya, your voice is
again,
breaking.
it has nothing. Yes, sir.
Divya, your voice is breaking in between, just for a few seconds. Yeah.
Sir, now is audible?
Yeah, now it's fine. You can go ahead.
Yeah, so sorry, sir. So
No
it's
issues.
like that we include right to suit for the damages, right to seek compensation from the state, and right to seek mediation. So that is true, and it is nothing. It is a gross, serious violation of a civil as well as the human rights of the individual, which can be lead to the various kinds of losses for the accused. As I've already told you, the losses are what? So it might be they loses also the faith in the judicial system also. So individuals who have been detained shall be deprived of their right to freedom, and they have a harsh condition. So if we go for the suit for damages, we just seek the compensation by filing a petition. That is the petition. Again, one more case will be initiated. That is the case for malicious prosecution. Whereas if we see with the US and UK, there is the moment the accused got acquitted, that very moment the state provides the compensation for them. When there is a system in US, why can't we adopt the same procedure in our criminal procedure, that at the same time we would have provided the compensation to them instead of going for one more trial, that is called the case of malicious prosecution. So sorry, sir. There are various guidelines that have been provided by the various judgmentals, that we need to follow these guidelines when we are providing any kind of compensation to the victim for of a wrongful prosecution. First of all, state has to make sure that the wrongful prosecution is adequately compensated for the loss which has been suffered to them, but eventually which is not been happening. If we talk in a real life, we're just providing them monetary. What about the reputation which they have lost? They have lost their jobs also, and even when they are coming back to the society after getting acquittal, they are not having the same kind of job opportunities them. So state has to make sure that either they send back to their previous job, or they should provide a job which is equal to their previous job. Compensation should be related to the loss which has been suffered. So the compensation should be sufficient to compensate the victim loss for the reputation as well as the job, as well as he will not lose his faith in the legal system. And whatever the loss he has suffered, the compensation should be made to the victim, and state should be punished. Like because if we go with the trial procedure, the trial part, only the state is there, that is consists of police who has been conducting this prosecution proceeding like the trial. So we should punish the same police officers who have been involved in this conducting their investigation, who has wrongfully
Your time has
prosecuted.
ended.
Yes, ma'am.
Your time has ended.
Just you conclude.
Just-
Divya, just you conclude your presentation now. Yeah.
Yeah, I'm just coming to my conclusion, sir. So the conclusion is that the victim of the wrongful prosecution, we are not providing them proper. Even the law has provided that, but eventually we are not following it. So my view is that we should give them a payment of legal fee to them as well as the damages, and give their mental as well as physical whatever the losses they have suffered, psychologically also we should provide them a therapy sessions for them, so that they can renew that. We all know that the accused, those who have been behind the bar, what kind of treatment they are having in the jail. So might be the losses their psychological balance also. So we should provide them a sessions so that they can regenerate back to their normal society, and we should treat them with the dignity, with the same respect before the trial has initiated, and the
Yes.
compensation should be adequate.
Yes, Divya, I think
Thank
out
you,
of your
sir.
presentations, 2 points are important. So first, as you rightly pointed out, this compensation, I think the quantum of compensation, I think, is very important out here. That in what sense the quantum is going to be put in place, because he has had a rough time in the maybe jail itself. So when he is getting again into the mainstream, so what kind of a life he or she is supposed to live? And second thing is his acceptance into the society as a Indian citizen, as a citizen of this nation. That is also very important. So these 2 points are, I think, very much important to be taken further. So maybe you can throw some more light in this aspect also in your paper, maybe later. Thank you. Thank you so much.
Sure, sir. I will be doing that. Thank you so much, sir. Thank you,
Thank
ma'am,
you.
for giving this opportunity. Thank you.
Thank you.
Thank you so much. So next person who will be presenting the paper is Dr. Sumitra R.
Right.
She's an assistant professor in Vivekananda College of Law, Bangalore.
Right.
Good afternoon, sir. Good afternoon,
Hello, ma'am.
everybody.
Hello. Hello. Please go ahead, ma'am. Please go ahead.
Yes, sir. My topic it is titled as Realization of an Unenumerated Right under Article 21 of the Indian Constitution. Of course, Article 21 deals with right to life and personal liberty. Of course, just the reading of Article 21 implies it's only the right to life, but thanks to the constant endeavors of the judiciary, which has interpreted Article 21 to include multitude or multiple rights. And one of them is right to food, which is the point of concern or the point on which I'm going to focus. So now the question arises, what is right to food? Right to food can be explained in terms of food security. And what is food security? Food security is a situation when all of us have all of us have access, or the situation that exists when all of us at all times have physical, social, and economic access to sufficient, safe, and nutritious food that meets the dietary needs and food preferences of for an active and healthy life. Now the question arises, what is food insecurity? Food insecurity is a situation when people do not consume calories which are just adequate for a day's living, that is 2,100 calories. If they don't consume the food containing these many calories or the energy level, we call them as food insecure people, or that's called food insecurity, situation of food insecurity. Now, how do you or where did we get this right from? We have derived this right to food from the International Covenant on Economic and Social and Cultural Rights. Of course, this covenant dealt with the right to food at the international level, but of course, we do not have a mention of the same in Article 21. As I have already told you, it is the judiciary which has interpreted to mean that the right to food is also included in Article 21. And what is the first case, or what is the role of judiciary in ensuring the right to food? The first case that came up before the Supreme Court was in Kishan Patnaik versus State of Orissa. In this case, it so happened that the people in the state of Kalahandi, people were dying of starvation. People were selling their children to make both ends meet. And Kishan Patnaik, who was an activist, wrote a letter to the Supreme Court and brought the situation to the notice of the Supreme Court, and the Supreme Court directed the government of Orissa to take the remedial action or to alleviate this situation of food insecurity. And of course, in this case, the Supreme Court took pro-government approach, and the state and the Supreme Court asked the state to take measures. The state took measures only at the macro level, but it never reached the needy. It never trickled down to the needy. It did not make much of difference to the needy. Even at this juncture, a thought was not spared to expressly include right to food as a fundamental right. And the second case that was concerning right to food was in a better way articulated in PUCL versus Union of India, that is People's Union for Civil Liberties. This was in 1997. In this case, though the granaries were overflowing with the food products or the food grains, people were dying of starvation. And when the government was questioned, the government said that these food grains are stocked for under different schemes and for the famine during the time of famine. And the writ petition question, if you do not think that this is a famine, then what else is a famine? And because of which the Supreme Court directed the union government or the union to release the food products, and because of which so many welfare measures were initiated at the behest of the Supreme Court. And one among them is a midday meal scheme, and then Anna Antyodaya scheme. And it also spoke about the vulnerable section. They should also be taken care of. And the Supreme Court said that in case they do not have an access to food, only then the state government or the government should provide it. So Article 47, which falls under the directive principles of state policy, says that among other things, the state shall regard or the state shall take up raising the level of nutrition and the standard of living of its people. And then and in the light of all this, we have in 2013 National Food Security Act was passed. What is the main intention of this act? It says that for a targeted public, the food grains will be given free of cost. Of course, I think though it is a social welfare legislation, this legislation is a very short-sighted one, because we understand that 40% of the Indian agrarian sector is depending on the rains. And we have seen that due to climate change and due to other various factors, the rains have not been regular. We have faced famines, and because of which, in the long run, we may not ensure the availability of the food grains in the same manner that we have. So now the government or the state has taken over itself the responsibility of feeding the people, but that may not be possible due to various factors. And the second one is at the subsidized price. What do you mean by subsidized price? Of course, initially this act spoke about providing the grains at the subsidized price, but now we see that these food grains are being given free of cost. And the next one is food subsidy. That is for how long the food subsidy can be given, because as we have seen, the population is exploding day by day.
Your prescribed time has ended.
Pardon me?
Your prescribed time has ended.
Yeah. So these are the challenges, and it says that we have seen that in the Brazil is a best example wherein there is no physical handling of food grains, but they give the cash transfers or the food coupons. And Section 52 of the Act, okay, no, this is a force majeure clause. There is a clause, and yeah, please see this, the cartoon, which depicts the real situation in India, where people are starving and people are waiting outside the depot. But here, now that the storage facility is not proper, you can see the rodents carrying. So these warehouses managed by the Food Corporation of India are feeding the rodents than feeding the people. And It also speaks about food security allowance. That is, if a state is not able to provide the food grains at the subsidized price, then the food security allowance should be provided to the state. But the act is silent regarding what is the food security allowance.
Ma'am, your time is ended.
Yeah. So what I say is this act may not be of much use because we have a saying in English, give a man a fish and you feed him a day, but teach a man to fish and you feed him for life. So creating a dependent on government for food economy is not the answer to a problem. Creating an independent, self-sustaining one is. So instead of promising all these goodies, I think the state should make a honest endeavor to improve the infrastructure, create more employment opportunities, and prioritize the agricultural sector, because we have realized that anything can be imported, but not the food grains. Thank you so much.
Yeah. Thank you, Dr. Sumitra. I think
Thank
you have
you, sir.
raised very nice concerns when it comes to your topic. This is also very topical in a sense that even midday meal is also an issue these days.
Yes, sir.
If you see the midday meal scenario, so the kind of stuff which is basically given, to the school children, that is also having a lot of problems when it comes to its nutritious value. So the check and balance is also quite important to be put in place. In addition to that, even in some of the schools and colleges also, the food court, which we have, again, the quality food is not provided. So the students
That is
keep
a
on
bit-
raising
one
their
minute,
concerns.
sorry to interrupt you.
Yes.
My thesis, my PhD thesis is based on food safety and food
Right.
safety act. The scope of the food security act is only to make these food grains
Yes.
available to the targeted public. But
Right.
when you speak about the safety of the food, that is
Yes.
altogether the concern of Food Safety Act.
Yes,
Food
safety
Safety
means
and
yes,
Standards Act.
yes, yes,
So the
yes.
scope is different, sir.
Right,
So
right, right.
the
But these
National Food Security
concerns,
Act,
these concerns can also be definitely taken up,
yes,
and
sir.
we can
National Food
definitely provide
Security
some kind of,
Yes, sir.
the solutions to these things. Yeah, thank
Yes,
you.
National Food Security Act
Yes,
only deals
yes.
with the quantity.
Right.
Food Safety and
Security,
Security
safety,
Act
and
deals with
security.
the quality of the food.
Right. Thank you.
Yes, sir.
Thank
Thank
you,
you
ma'am.
very much, sir. Thank you.
For next presentation,
Next
we
presenter.
have Priyanka. She's a research scholar, and her topic is gender equality and women empowerment in India. Priyanka, do we have Priyanka amongst us?
Now we can go to next presenter if she's not there.
Yeah, sure. Next presenter is Miss Ekta Dwivedi. She's a student in BA LLB Honors, School of Law, Bennett University, Greater Noida, India. Her topic is Gender Justice at Work, examining the effectiveness of the prevention of sexual harassment of women at workplace, Prevention, Prohibition and Redressal, Act 2013. Ekta?
Am I audible?
Yes, you are.
Yes.
Good afternoon, everyone. I'm just sharing my screen. My name is Ekta Dwivedi. I am second year BLLB student from Bennett University. My topic is gender justice at work, examining the effectiveness of the POSH Act. Moving further, sexual harassment is pervasive. There is no industry or institution which is immune to it. It happens in companies, factories, movie sets, in restaurant kitchen, in offices, and it hurts so many people. At its core, sexual harassment is about the unequal powered relation between men and women at school, at work, and in society. In other words, gender inequality is the cause of sexual harassment and the consequences of it. With this, we mean that we will never have full equality. Women will never be full equal to men as long as this behavior continues. So, if equality is what we want, then we need to decide at this moment to change things. And in this case, the problem is to be solved. Is that why sexual harassment took place? It's been illegal for decades. It's a form of sex discrimination, and the cost to companies and individual is enormous. So why this is so pervasive?
Why we have certain laws, then also sexual harassment is keep happening. Why the numbers are increasing day by day. Our research paper revolves around this issue. It basically focuses on the analysis of the existing laws and how it has been evolved and how it is being implemented. Let's move further to what we have covered in our research paper. Women rights are human rights. What is women right? What is women empowerment in true sense? Is it just giving freedom to live their life as they want? No. It is women empowerment in true sense is giving them their rights, opportunities, safe working environment. There are certain rights given in our grand norm of our country, that is constitution, such as Article 14, Article 15, Article 51A. Now, moving further, what was the situation before the remarkable judgment Vishakha versus State of Rajasthan in 1977? What were the existing laws and why it was not effective? Why Section 509 of IPC 1860 was not sufficient enough to fight against sexual harassment? There was no proper definition of sexual harassment before Vishakha judgment. It took around 20 years after the Supreme Court judgment that gave Vishakha guidelines to make step forward to fight against the evil called sexual harassment. That is POSH Act. POSH Act is the result of the Vishakha guideline, which is based on it. We have analyzed and how the procedure is being taken place today in our research paper. Now, moving further, do you really think that sexual harassment happens with only women? No, not at all. Men are also the victim of sexual harassment. Sexual harassment took place both in formal and informal sector. Then why only formal sector is covered in this act? There is a provision of internal complaint committee, but the functioning of the internal complaint committee is ineffective. They are not functioning properly. There are certain loopholes in this act which need to be addressed for effective functioning of this act. Also, the suggestion given by Justice Verma Committee should be considered for effective functioning of this act. This article contends that it is now imperative to reject the culture of silence surrounding these cases, with victims taking a proactive stance in asserting their rights. Despite India's historical commitment to safeguarding women's rights, there is a discernible gap in practice, and this gap should be filled to make the laws effective and making changes in the laws. The power of laws and rights given to the people is powerful enough to create long-lasting change. And this is how we give voice to people who often have none. Thank you so much.
So Garima, don't you think that the act which is there in place, is neat? Yeah, Ekta. So don't you think that the act which we have in place should be revisited, by the you can say state, in a sense that to provide more and more rigorous mechanism to prevent all these dangers when it comes to women's section? Don't you think so?
Yes, sir. We think we have analyzed the laws and there are certain loopholes. Like in internal complaint committee, it is not functioning properly, and also it is gender centric. It only focuses to the women, just like Dowry Act. So all these need to be addressed, and also sexual harassment, mostly if we stick to the data, it majorly happen in informal sector, the statistics, but this act only focuses on the formal sector and formal sector. So all these loopholes should be considered.
Does it mean formal sector? Does formal sector talk about organized sector? Are you talking about organized sector? Because we have two sectors, no? Organized, unorganized.
Yeah, I'm talking about organized sector. Yeah.
Okay, thank you. Thank you.
Okay, thank you so much, sir.
Yes, Ayushi, can we have next presenter?
So the last two presenter, Mr. Mukesh Pandey and Ms. Sonam Singh will not be presenting their paper.
Okay, they will not be presenting.
Yes, they are busy in their own departmental meeting.
Right. And what about Priyanka? I think she has not reported, right?
Yes, she has not voted. Yeah.
So do I have to conclude the papers, or do I have to just share remarks with you when it comes to the presentations today? What should be done now?
So you can give remarks.
I can give remarks. Okay. So I think once again, this is really a very nice platform which I found right now, because this is how the valuable points basically were made known to everybody, and I think very nicely presentations were made. So I think credit goes to, first of all, the selectors who have selected all these papers.
Yeah.
And when I can see the questions which were basically raised by all the presenters, like Abhirami is there, Divya, for example, then we have Dr. Sumitra, Sanjana, Vijay Kumar, Vrinda. So I think all these topics definitely have given us a kind of understanding that what needs to be done, what has been done previously, and what needs to be done. So I think in terms of suggestions, if you take, in terms of recommendations, if you take, for example, in case of Divya Kataria, I think she was talking about the compensation mechanism, definitely. So when it comes to the compensation, so in terms of quantum, I think we can definitely go ahead. What kind of quantum is going to be fixed, plus the kind of acceptance of that person into the mainstream. That is also very important. Are we going to consider that person per se the way we used to consider him before he was, you can say, put behind bars? So that is the thing. Then Vijay Kumar has also made a very nice presentation when it comes to homelessness. Then Dr. Vinda also let us understand, the nitty-gritty of, you can say, gender biases and all. Then she was talking about equal opportunity, equal work, and I think very nicely sampling, some kind of samples basically she had, and accordingly she put forth a very nice, you can say, understandings about the case laws, that how we can understand that concept better. Then Sanjana also talked about prisoner rights in India, but I think DK Basu versus State of West Bengal, she must also fall back upon. That case is very important to understand the prison reforms. So that definitely could be taken further by her. Then Vibhanshu was also talking about the euthanasia. So it was also a very nice presentation. Then lastly, you have, you can say, Abhirami. So she also talked about the constitutional provisions with regard to the gender equality and all. So I believe very nicely presentations were made, but just one sort of suggestion, that the thing is, like, when it comes to the research methodology part, I think there could be possible questions which we can think of, and in terms of hypothesis, we can, you can say, approve or disapprove those questions when we are, approaching the end point. That is suggestions, conclusions, and recommendations. So that is basically, I think, the important point which I think we all must understand, and accordingly we could definitely go ahead with that research. So once again, I am thankful to the leadership of IPEM Academy, Ayushi. I am also thankful to you, Madam Tomar, and all your, you can say, co-travelers who have really, in a very, very nice manner organized this very conference. And definitely I am also happy being a part of this conference as a presenter, as a session chair. And thank you so much, and God bless. May God bless us all. Thank you so much, Ayushi.
Thank you so much, sir. Thank you.
So shall I leave the meeting now?
Yes, sir. Thank you. Dear participants and guest dignitaries in the fourth International E-Conference, we have just concluded our second technical session. Now we are heading to our third technical session. This third technical session will be chaired by Dr. Mukta Verma. Ma'am is an assistant professor, senior scale, University of Allahabad. Ma'am, am I audible to you? Ma'am, kindly unmute yourself.
Am I audible, ma'am?
Yes. Yes, ma'am. Now, kindly increase your volume, ma'am.
Now, is the volume has been increased, ma'am?
Yes, ma'am. Very much. Thank you. Welcome, ma'am, in our third technical session. You're also the chairing the session. Ma'am, due to certain technicalities, the first person who will be presenting the paper is Jafreen Shaji. She wasn't available in our technical session too, but she's available now. So she'll be presenting paper in this session.
Okay, ma'am.
Yeah.
So now,
Jafreen.
yes.
Yes, ma'am.
Yes, so the next presenter will be, as you have announced now, no, ma'am?
Yes, yes,
today.
ma'am. Jafreen Chaudhary, she's a student in Maniam University, Tamil Nadu, and the topic of her paper is the fundamental principle of India's police interrogation protocols and their nexus with human rights. Jafreen, are you there?
Yes, ma'am.
Present your paper.
Good afternoon, ma'am, and good afternoon to everyone.
Do remember, before you start your presentation, do remember that you have only 5 minutes for presenting your paper. So
Okay,
do
ma'am.
complete within the prescribed time limits.
Okay, ma'am.
Thank you.
Good afternoon. Myself, Christina. My co-authors are Jafreen Shaji, Shweta Shankar. My topic is on the fundamental principles of India's police interrogation protocols and their nexus with human rights. Introduction. Police interrogation techniques in India are an essential part of the country's legal framework for handling crimes. The goal of this procedure is to induce confessions or other cooperative behavior for suspects so that criminal activity can be investigated and prosecuted. These steps are crucial to protecting the legitimacy of the judicial system.
Jafreen, will you please show us your video? Your video is not, we can't see you.
Some technical issues, ma'am.
All right, continue. Please continue.
Sorry, ma'am. It is crucial that India's persistent human rights issues be traced back to the country police interrogation practices. The various Indian law enforcement agencies have responsibility to uphold democratic values in way they go about their daily operations. This is something that has to be done. The fact that as Indian Constitution protects fundamental freedoms emphasize the significance of law enforcement agencies acting in accordance with it. The Indian Constitution protects personal freedoms, hence, this is the case. Because of this link, striking a balance between the state's responsibility to protect law and order and rights and dignity of individuals, including those who are suspected of committing crimes, is a delicate balancing act. This requires a delicate juggling act between the state duty to maintain law and order and rights and dignity of individuals. There can be no giving ground on other side if this unity is to be achieved. During this introductory talk, we will examine the human rights implications of the ideas that guide India's police interrogation practices. In this article, we shall examine how suspects in India are integrated, or our search will focus on the legal structure and the underlying concepts that govern police interrogation in India. Particular attention will be paid to the rights of suspects and the obligations of those charged with maintaining law and order. In doing, we seek to shed light on murky interplay between India's judicial system, police and citizen constitutional guaranteed rights to be liberty and equality. It's not just India where problems and debates have arisen because of police interrogation. These issues and debates are resonant with broader global arguments about law enforcement practices and human rights. As a result, our investigation will be contribute to be a better understanding of the Indian criminal justice and shed light on the global implications of protecting human rights during police interrogation. This is because our research will shed light on the ramifications our discoveries have for other areas. This is a review of literature. The article titled Police Interrogation, Custodial Violence and Human Rights in India.
Yes, Zafrin, just come to the important aspect of your research paper.
Yes, ma'am.
What can be the problems, issues, challenges, and the suggestions, please. Zafrin, am I audible?
Yes, ma'am. Ma'am, the slide is visible?
Yes, yes. Yes, Zafrin, are you there?
Yes, ma'am.
Yes, please tell about the important point of your research paper, like you have written in this slide, like statement of problems. Just take the one or two problems and then come to the their prospect and then suggestions, so that we can conclude your research paper on a time.
Okay, ma'am. Okay, ma'am. The process of police interrogation holds significant importance within the criminal justice framework in India, as it involves the delicate task of seeking truth while also safeguarding fundamental human rights. Even so, a close study of their main ideas behind India police interrogation method and how well they work with human rights shows how badly they need to be evaluated and changed right away. The study goal is to look into the problems listed above and suggest workable solutions and change that could be made to India's police interrogation method, then more in line with international human rights standard and best practices. The study seeks to make contribution toward the establishment of fair and equitable criminal justice system that upholds and protect the right dignity of parties concerned. Ma'am,
yes, now the problem have been over. Please come to the suggestions or the important point of your research paper. Like you have written here the problems which are faced by the people, by the police. So these are the problems. These are the some issues and challenges. Now come to the your suggestion that this should be done. And what can
okay,
be
ma'am. Suggestions are comparing Indian police interrogation framework and human rights demonstrate regional difference and best practices. Research might investigate whether legislative and procedural improvements have improved police interrogation transparency and human rights. Police interrogations and witness testimony may reveal reform opportunities and issues. Efficiency impact how we well internal investigation and police discipline preserve human rights. Assessing capacity building requires studying law enforcement, training and education, including human rights and interrogations. Understanding how civil society, human rights, and attorney advocate for integration reform may indicate changes. India can meet international human rights standard by evaluating police interrogations. Ma'am.
Okay. Okay, thank you.
Conclusion, ma'am.
Yes, please.
The legislative and administrative framework that guides India's police interrogation protocols has a considerable role in shaping the nature of interaction that exists between these protocols and human rights. In other words, the legislative and administrative framework largely determines the nature of this interaction. This is due to the fact that the legislative and administrative framework determine the nature of connection between the parties. In other words, the legislative and administrative framework have significant impact on the other nature, the link that exists between the parties. And this influence is vital in shaping the connection. During the course of our investigation, we investigated the aspects of this system that are generally acknowledged to play roles of utmost significance by it constitutes. The Indian Evidence Act, the Code of Criminal Procedure, the Constitutions of India, guidelines made by Ministry of Home Affairs, and rules provided by state police departments are all
Presenter, please,
examples of.
you're stepping on the time limit. Try to conclude.
It is also ensured that the right of this individual will be safeguarded while they are in the custody of the police. In addition to this, it's lay out the criteria of the strategy that will be protect their rights in manner that is consistent with the law. During this course of inquiry, it became abundantly evident that there are still great many problems to overcome in order to guarantee the techniques utilized by police questioning conform. The absence of transparency in the questioning process, which raised questions about accountability, impartiality, and the trustworthiness of evidence in legal procedures, make this difficult a great lot more difficult to deal with they would otherwise be. Thank you.
Okay. Zafrin, you have presented a paper in very well manner. My one suggestion for you is this, that whenever you are explaining with the help of slide, try to make some point written on your slide only. There is no need to write all the things on a slide. Try to make some important point on the slide, and you have to explain with the help of this point only. Okay. Otherwise, your presentation is good.
Yeah, thank you.
Ayushi ma'am has gone for a while and she has left me in charge
Okay.
to set the pace and tone of the event. We have you as the next presenter, ma'am. And since it says that your title of the paper is Role and Effect of Technology on Human Rights in Present Social Legal Scenario, Issues and Challenges. You may go ahead, ma'am.
Yes. Okay, thank you. First of all, I thanks to all the organizers who are taking too much pain to present this international conference. And I am too much thankful to all of you for providing me such an opportunity to express my views on the important point, that is role and effect of technology on human rights in present socio-legal scenario, issues and challenges. So if we see that nowadays information technology, telecommunication technology, science and all have changed our life in positive as well as in negative manner. So if I focus on the first part of my paper is if role and effect of technology on human rights in present social legal scenario. So this will be the positive point. For example, if we can see now, we can see this seminar is going on in online mode. So this is the positive effect of science and technology. Now, if we go to the negative impact of this, sometimes we can say if we see the negative effect of this online seminar, maybe the people cannot let's say the people in the which in the real world, so that can and the interaction is very less in this online seminar. So there are 2 points if we go to the technology point of view. Now if I focus on the important aspect of this paper is that we can see this has been divided into 3 or 4 parts. For example, what is the effect and role of technology on the IPR? Second part will be what is the effect and role of the computer and the artificial intelligence on the in the present social legal scenario. And third can be there, what are the negative effect of this science, information technology on the human life? So, and after that, there will be some legal aspect, like what is the role of Indian Constitution and what are the different roles of the different act which have been focuses on the use of the this information technology in safe way. So now in very nutshell, I focus on the effect of the science and technology in IPR. For example, we can see that so many issues and challenges are there in IPR. For example, if copyright is there. Copyright infringement is taking place in much more in much more dimension in comparison to the real world copyright infringement. Now, if we focus on the use of artificial intelligence has make our life very easy because it has the capacity to do reasoning. It has the capacity to do work in very efficient way. So now, if we see the legal perspective, uh, now till now, no law has been implemented for the you can say regulation of the artificial intelligence. Again, if I see the important aspect of that, what will be the effect on the human rights of these things like science and technology and the negative impact of the cyber crimes? We can see so many things. People cannot people's mindset or their thinking and cognitive ability has been reduced, or you can say has been affected, because if we compare to the people that now we have a mobile phone number in our smartphone, but before some years we have known the numbers of the mobile phone. So these are the some negative impact that have on the minds of the people. So we my point here is that we are using the technology and we are getting the benefit of it, but somewhere the negative effect is also there, as in the form of as in the form of cybercrime is also there. We know that people who are using this technology for the doing e-commerce, people are using this you can say technology point of view for doing their online transactions and for sending their messages and doing lots of things through this information technology. But cyber crimes have been taken place with all this work. So there is a need to see that how this negative effect in the form of cyber crimes can be prevented, and the data of the people should be secure in proper way. So in this era, we all know that all the data are available in computer, and the data which is stored in the computer can be misused, can be hacked by the unauthorized person. So this is very much important. Whatever the data which is available in the form of audio, video, or image, it should be protected. And if we are going to use the social media platform, or if we are sending our messages, that should be secure. And if any other person who are not in a position to use our data, and they have manipulated it, and they have gained the undue advantage in the form of monetary benefit, then that person should be punished, and the data protection should be there, and the privacy setting of our data should be used by each and everyone. So by following some points, we can say that we should adopt the things which can be for our betterment, and if any person who is using the undue advantage with the help of some points of the which come under the category of cybercrimes, that should be that should be checked. And we all know that we should do work for the betterment of the society, and if any person is found in the we can say found in the threatening, or we can say are doing the things which are not in the which are not appropriate to anybody, that thing should be uh, discarded. So this is very much important, that we should use the technology for the betterment and the welfare of the society. That is from my side.
Thank you so much, ma'am. Let us now call upon our next presenter, which is Shireen Nazar, a research scholar from School of Legal Studies, CUSAT, and they'll be presenting their paper on the topic Scope of Attribution of State Responsibility in Cyberspace for the Actions of Non-State Actors.
Hello.
Yes, please go ahead.
Am I audible? Okay.
Yes, you are perfectly audible. You can go ahead now. You have 5 minutes.
Thank you.
Please try to conclude in 5 minutes.
Okay, myself, Sharon K. Nasa. I'm a research scholar from Cochin University of Science and Technology. Okay, my research paper is titled Scope of Attribution of State Responsibility in Cyberspace for the Actions of Non-State Actors. So, as ma'am said, with the advancement of technology, criminals are encouraged and traditional crimes have mostly been paved way for crimes and unlawful activities using computers, laptops, mobile phones, etc. So, cybercrime is a different form of crime which is happening in our society. In simple terms, cybercrimes can be understood as any criminal activity that involves computer network, or any other computer devices. So they are illegal activities carried out in cyberspace, both by the state and the non-state actors, which causes damage and destruction in pursuit of various political, economic, and personal goals. We all know that cybercrimes are not limited to geographical boundaries, and the identity of the criminals is difficult to trace, unlike in the case of traditional crimes. These two peculiar features of cybercrimes make it an attractive domain for states as well as non-state actors. So even though the cybercrimes are of recent origin, it has a potential to have a wide impact on the society. Cybercrimes is an all-encompassing term that covers a wide range of crimes and behaviors, and there are a large number of persons using the internet on a daily basis, and therefore the potential number of victims and the offenders is too much more than our imagination. So as I said, cybercrime is one of the fastest growing criminal activity in the world today, and hence the human rights in relation to cybercrimes and cyberspace are also being contested very openly today. Day in and day out, we find human rights, especially the privacy of an individual, are at stake with the recent advancement in cyberspace. Also, human rights such as the right to privacy, the right to secrecy, right to be free from any kind of blackmailing and torture has been violated with this cybercrimes. With the proliferation of different crimes of cybercrimes, an individual often suffers various loss. As far as an individual is concerned, a financial loss is the most common effect of cybercrime. Also, cybercrime can cause emotional trauma. Victims of cybercrime often feel violated and vulnerable, leading to fear and anxiety. This can have a long-lasting impact on an individual's mental health. Also, as far as business entities are concerned, hackers usually lock secret data of the user or any of the company and demand ransom to unlock them. They also steal data to misuse them. These are the common challenges which are possessed by
Yes.
these cyber crimes.
Yes, Ms. Shireen.
Yes.
Please focus on the 2 points. First will be that what are the
Yes.
legislation
Yes.
which are you can say curbing the cyber crimes, and second will be what are your suggestions?
Yes, ma'am. So my main concern is non-state actors are the main perpetrators behind this cyber crimes, and the actions of non-state actors are actually going unregulated. Okay, many countries have come up with several legislations which curb cyber crimes, but actually the cyber crimes are happening mostly cross-border, which calls for a solution under the international law. So as far as the international law is concerned, I would suggest state responsibility as a solution to regulate the actions of non-state actors in cyberspace. Okay, ma'am, state responsibility, as we all know, implicates the entirety of a nation's duty to respect the international law rights of other countries, and when it has violated those rights, to make proper amends and reparations. So under the international law, the articles on responsibility of states for internationally wrongful acts is a codified piece of law which regulates state responsibility, and it has been drafted by the International Law Commission in the year 2001. According to these articles, a state is responsible for an internationally wrongful act if an action or omission is attributable to the state under the international law, and also it constitutes a breach of an international obligation of the state. But here, the problem is that the articles of responsibility of states for internationally wrongful acts is not at all concerned with the issues of responsibility of non-state entities. But it is important today to notice the activities of non-state actors in cyberspace. So here, the researcher, that means I would try to examine how far this articles on state responsibility can be applied in cyberspace, and whether the actions of non-state actors can be attributed to the state. For this, the presenter has examined Article 8 of the articles, which mentions 3 criteria which attributes the state responsibility.
What are your
Yes, ma'am.
suggestions? What are your suggestions?
So, ma'am, my suggestion is that the actions of non-state actors is not at
Please
all
try to
regulated.
conclude within this minute. You are actually stepping on the time limit. Please try to conclude within this minute, right?
Okay, ma'am.
Yeah.
I was trying to point out the human rights challenges possessed by the cybercrime issues, and my suggestion to those challenges is the attribution of state responsibility for those cybercrimes. But actually, it is even though it is a very important area, but nothing has been done towards that. So my humble request is to make more. My humble suggestion is to make laws, like more laws with many countries, to make laws through which we can hold state responsible for the non-state actors, and that is not actually an easy task.
Okay.
But
okay. Thank you.
Okay,
thank you, Shireen. Thank you, Shireen. Can I ask one question?
Sure, ma'am. Sure.
Yes. Is there any act or law which is applicable in India for the prevention of cybercrime?
Actually, we only have an IT Act which deals with this cyber crimes and all. There is no other specific legislation which punishes or which regulates the cyber crimes.
Have you mentioned this act in your research paper?
No, ma'am. Actually, I haven't mentioned this legislation in my paper, because I was trying to go an international. I was trying to write it in an international perspective. That's why I omitted to mention that legislation.
Okay. But you cannot skip that point now. You should mention.
Sure.
Okay.
Okay,
Thank you.
sure, ma'am. Okay. Thank you.
Yes, who is next?
Thank you so much. So
Okay, thank you.
the next presenter is going to be Maiditi Sant, a student from Government Law College, Ernakulam, and the topic would be the conundrum of securing privacy and freedom of speech in the digital world, with special emphasis on Draft Data Protection Bill and IT Rules 2021. You may please go ahead. You have 5 minutes. Try to conclude within 5 minutes.
Sure, sir. Thank you. Am I audible?
Yes,
Yes, you're perfectly audible. Yeah.
Okay, I'll just quickly share my screen. Just a moment, my screen is loading.
Yes, you can start.
Sure. Is the presentation visible?
Yes, absolutely.
Just a moment, ma'am. I'm going to get to the presentation. Is the presentation visible, ma'am?
Yes. Please go ahead.
Okay, thank you. Sure. So warm greetings to all. Let me just quickly begin by introducing myself. I'm Maithili Asan, third year BCom LLB student from Government Law College, Ernakulam, Kerala. So my paper is titled The Conundrum of Securing Privacy and Freedom of Speech in the Digital World, with special emphasis on Draft Data Protection Bill 2022 and IT Rules 2021. So let me just quickly start by this quotation of Justice Tole Madela. Privacy, liberty, and dignity are the key constitutional rights which construct our understanding of what it means to be a human being. So now, I hope all of us here are well aware of the fact that the importance of right to privacy. The rights regarding privacy had always been there in the legal domain, but from an Indian perspective, it gained significant. It gained much significance through the SE's judgment of the making right to privacy a fundamental human right through the Puttasamy judgment of 2017. Now, the concept of data privacy, however, burgeoned as technology advanced and the OECD guidelines, the EU directives, as well as the Malibu Convention, all just emphasized its importance. And further, along with the GDPR, the General Data Protection Regulation of the EU, here it came into effect in 2018, and it really boosted the conversations regarding the importance of data protection and data privacy. So even including countries like India, further went on to develop their own data protection legislation, influenced greatly by the GDPR. Now, privacy and freedom of speech both are interconnected and, let's say, are mutually reinforcing rights. So when our privacy of communication is hindered, automatically our freedom of speech is hindered as well. Now, I'd like to bring your attention to certain provisions of two important legislations. One is an important act, and the other one a rule, which is released, in the recent times. Firstly, the Digital Data Protection Act of 2023, and secondly, the IT Intermediary Guidelines and Digital Media Ethics Code Rules of 2021. So, firstly, the IT Rules 2021. The rule 4 close to of the IT Rules 2021 is in order to just quickly give you an idea regarding the rule 4 close to, it is a rule that mandates additional due diligence to be observed by the significant social media intermediaries, primarily which are engaged in messaging services. So it mandates them to enable identification of the first originator of a message. So now the biggest threat to privacy that comes along with this is that now, even to trace the originator of one message, the intermediary will have to break the privacy feature
that is provided using the privacy feature that is provided using end-to-end encryption feature. See, in order to understand this, we need to understand how end-to-end encryption works. Now, how does end-to-end encryption work? It is a security feature, privacy security feature, and it uses a two-key system. One, when a message is sent, it is encrypted using a public key, and then the corresponding private key is used to decrypt it, and it is only available to the receiver. Now, this ensures added privacy to our conversations happening in the digital space. Now, the issue with traceability is that now, in order to even trace one message, the service provider will have to trace all the messages and how to store and retain this. Now, this essentially breaks end-to-end feature, and therefore a high amount of data will have to be stored and retained. Now, at a time when we need data storage and data retention to be minimized as much as possible, here the data storage and data retention is going to be enlarged. Now, the possible threats of these include data leakage, misuse of misuse, and even governmental illegal surveillances. Now, I'd just like to quickly go through certain provisions of the the Digital Personal Data Protection Act of 2023. Now, certain provisions of this involve certain skepticisms. Firstly, the non-consensual data processing clause. The Section 8 of the DPDP Bill 2022 had a deemed consent clause, which gives data fiduciaries the power to obtain data of a data principal non-consensually. Now, under certain grounds, which are very vague and arbitrary. Now, the DPDP Act of 2023 does not contain this deemed consent clause, but however, it is masked under a different clause of certain legitimate uses, which is elaborated in Section 7. Now, some of these grounds for deemed consent include any breakdown of public order or for purposes related to employment, recruitment, termination, assessment of performance, etc. Now, these are very vague and wide. Now, secondly,
yes, Ms. Medhali, please try to conclude your paper.
Sure, ma'am. Sure, ma'am. Just two more
Focus
points.
on the
Just two more
important
concerns.
highlights only.
Sure. Now, the second one is regarding the wide exemptions granted to the government instrumentalities. In the 2022 bill, the Section 18+2 exempts the central government from the application of the provisions of the Act. Now, this could lead the government to arbitrarily use the provisions of the Act and still have an immunity for doing it. Further, these exceptions provided in the section are very vague and subject to wide interpretation because the DP Bill of 2021, if we take a closer look at that, we had a comparable clause, but it used terms like expedient and necessity, etc., to bring in more reasoning. However, this is not seen in the 2022 bill or in the 2023 Act in Section 18+3. Further, through Section 18+3, it further extends it to certain data fiduciaries as well, thereby expanding its scope of expanding the scope of exceptions. So, lastly, there is loophole in the notice requirements as well. The Section 6 of the DPDP Bill 2022 mandates giving notice in clear and plain language. However, providing description of the data intended to be collected for the purposes of the processing it. However, on comparison to the past data protection bills like the Bill of 2018 and 2019, it can be observed that here it is not mandated in the notice to give information regarding three things. Firstly, the transfer of data to third parties. Secondly, the period of storage and retention of the data collected. And thirdly, the transfer of data to other countries. Now, through this, the data fiduciaries could now make use of these provisions and continue to obtain consent from the data principal to use our data and then use this information maliciously in ways like storing it for a longer period or like giving or transferring this data to another country without our permission, etc. Now, therefore, I'd like to quickly conclude by saying that India's attempts to bring in data protection law and other such legislations are highly commendable. However, it remains paramount that such endeavors do not entail inadvertent compromises on some of our basic rights, including data, including our privacy rights and freedom of speech. Thank you, ma'am. Thank you.
Okay, thank you.
I'd also like to thank IPM Law Academy for giving this opportunity for presentation. It is a great experience. Thank you.
Thank you, Maithili. Thank you. Next, we have ma'am Darshana Devi. She's a research scholar in Guru Kashi University, Talwandi Sabo, Bhatinda, Punjab.
Okay.
Darshana?
Yes, ma'am.
All right. Can you please increase your volume?
Good afternoon, everyone. Myself, Darshana Devi. I am research scholar, Guru Kashi University, Talwandi Sabo.
Yes, Ms. Darshana, your voice is very low. Please
You're not
increase
really
the
audible.
volume.
Just increase your volume a bit.
my topic name is relationship between intellectual property and human rights in international law. Human rights are very most important.
Yes, Darshana, again, your voice is very less. We are not listening to you.
Darshana, kindly increase the volume of your system. Please, you're not clearly audible.
Now,
No, no, no. Are you using the phone?
yes, ma'am.
I,
Now, ma'am. Now,
no, dear, your voice is quite low. You're not clearly audible. I am supposing you must know that this is a very formal event and you're supposed to use your laptop.
at the time, ma'am. Now,
You can do one thing if it is possible. Please remove your earphone and trying to speak without this earphone. That may
Yeah.
be.
Atika. Start, ma'am.
Yeah, you may start, ma'am. Shall we
Yes,
start?
yes, please. Yes, please.
Okay. Start, Peter.
Relationship between intellectual property and human rights in international law. Human rights are most important rights. These rights available to every person just because by birth. These rights include the constitutions of India, part 3rd, fundamental rights. At the 1215, this name of Magna Carta and 1689 Bill of Rights. Human rights and intellectual property protection are two distinct areas that have grown substantially and independently. For a variety of reasons, there are consensus bills should be reconsidered to bring the effects of intellectual property rights on achievement of human rights, such as the right to health, have been considered more ambitious. Since the TRIPS of agreement passes, second, the growing relevance of intellectual property rights has necessity a clarifications of the extent of human rights, legislation safeguarding individual contributions to knowledge in the concept of medical patent. Third, a number of medical patents. Third, the number of new concerns affecting the contributions to knowledge that cannot be property secured under the present intellectual property rights. Regimes must be addressed. This article discusses the many facts of the link between intellectual property rights, human rights, and science technology related to clause in human rights. Treaties within focus on the right to health, a human right. It examines current protection provisions in human right, any treaties and convention related to knowledge of the protection. It also investigates some of the effects of existing and intellectual property rights. Regimes in the human rights fulfillment. Further, it examined two General Convent of 17 and clause of 15, one part of.
Yes, Darshana. Darshana, are you listening?
Yes, ma'am.
Yes, your paper is relationship between intellectual property and human rights in international law. Am I right?
Yes, ma'am.
Yes. Can you explain your paper in 3 points only? That this is the issues and challenges, and these are the legislative aspect on this issues and challenges, and third will be the suggestions.
Ma'am, conclusion and suggestion my this topic.
No. First of all, please explain the problems because you have chosen this topic for your research paper. No? Then what are the issues and challenges, or we can say what are the problems of your this topic, and then what are the legislative aspect on this paper and on this topic, and then what can be the your suggestion that this will be the suggestion so that the problems which on which you are focusing and the remedy can be provided to this particular concern things.
Ma'am, only presentation, not publications my paper.
Okay, you please explain the conclusion only. Please explain the conclusion. What are your conclusion?
Yes, ma'am. intellectual property regimes to human rights fulfillment further in 15 and clause of the International Convention of Economic, Social and Cultural Rights and recommended a border of the interpretations of the clause before the best of knowledge.
Okay, now only one question to you because your voice is very less. That what are the relation between IPR and human rights? Okay, thank you, Darshana. Ma'am, we can take the another participant.
Ma'am, the last two participants, Jitendra Kumar Gautam and Neeraj Nagar, are busy with a NAC meeting, so they wouldn't be available for this technical session 3.
Okay. So now we can wind up this technical session.
Just a second, ma'am.
Okay.
Research scholar in Department of Education, CMP College, University of Allahabad, Prayagraj.
Okay.
Sohan Singh, are you there? Okay, okay. Okay, you will be presenting on his behalf. All right, ma'am. His topic is human rights and technology, new challenges for justice and accountability. I think there is somebody who has kindly mute yourself. I can hear my own voice. Accountability in perspective of India.
Greetings everyone. Myself, Himanshu Sharma. Currently, I am in my second year of my law school, which is IPM Law Academy.
Sir,
Today,
मुझे ऐसी screen
I will present the research titles Human Rights and Technology, New Challenges of Justice and Accountability in Perspective of India. On behalf of the research scholar, Mr. Sohan, as Mr. Sohan is not available for the team. Starting up, in the contemporary world, the intersection of human rights and technology has presented both opportunities and challenges, particularly concerning justice and accountability. As technology rapidly transforms society, India finds itself as the crossroad of harnessing the potential of technology while safeguarding human rights in its pursuit of justice and accountability. This research delves into the crucial role of human rights in leveraging technology for advancing justice and accountability in the Indian context. As technology permeates every aspect of our life, its impact on human rights in the context of justice and accountability has become a pressing concern. Human rights serve as the foundational principle that protect the inherent dignity, freedoms, and liberties of individuals. They create a framework for a just and equitable society, demanding that every person be treated with fairness, equality, and respect. When applied to the domain of technology, human rights become instrumental in shaping the manner in which technology is developed. What exactly is human rights? Human rights refer to the inalienable rights and freedom that all individual possesses by virtue of being human. These rights are universal, indivisible, and interrelated, and they are recognized and protected by national and international laws, treaties, and conventions. Human rights encompass a broad spectrum of civil, political, economic, social, and cultural rights, which are essential for the human dignity, equality, and well-being. They serve as a moral and legal framework, ensuring that every individual is entitled to basic right and protection without discrimination. Human rights are fundamental and universally recognized idea that asserts the inherent value and dignity of every individual simply by virtue of being human. Let's just quickly discuss some key elements of the common set of human rights. Its universality, as it is applicable in all around the world, it's universal, and its inalienability. Human rights cannot be taken away or transferred. Indivisibility, human rights are interconnected and interdependent. Equality and non-discrimination. Human rights uphold the principle of equality, meaning that all individuals are entitled to the same rights and protection without discrimination of any kind. Human dignity. Human rights are founded on the belief that every person possesses inherent dignity and should be treated with respect and consideration. State responsibilities. Now, who are actually involved to safeguard these? The government and authorities have primary responsibility to respect, protect, and fulfill human rights with their territories and jurisdiction. Last but not least, international frameworks. Human rights are protected and promoted through international agreements, treaties, and conventions. Notably, the Universal Declaration of Human Rights, UDHR, is a milestone document adopted by the United Nations General Assembly in 10 December 1948. This contains around 30 articles. It was a response to the atrocities that took place in World War II. Some important provisions that constitute in the Indian Constitution related to human rights, which are Article 40, which describes the right to equality, which guarantees equality before the law and equal protection to the law to all individuals. Article 15, prohibition to discrimination. 17, 19, 21, which talks about abolishes the practice of untouchability, right to freedom, right to life and personal liberty, respectively. There are certain more, which are Article 22, Article 23, Article 29, and 30. What is the importance of human rights in human technology? In the context of using technology for justice and accountability in India, human rights play a crucial role in ensuring that technological advancements are utilized ethically and responsibly, as technology has both diversities and opportunities. The following points highlight the value and importance of human rights in this context.
Yes, dear
Safeguarding
presenter.
privacy and data protection.
Yes. Yes, dear presenter. Am I audible? Am I audible? Yes. Can you explain? Yes. Can you explain the interrelationship between the human rights and the technology? Because your topic is human rights and technology are new challenges for justice and accountability in perspective of India. I think you are a law student.
Yes.
Yes. So can you please explain only one point only, because you have explained the human rights, its international perspective and its national constitution perspective in very well manner. But because if you are presenting on this title, then you should need you should do emphasis on this topic, like what are the relationship between human rights and the technology, and how there will be a challenge for the justice and accountability in the perspective of India. Can you explain these lines on this topic?
The relevance of it, the technology and its relevance in human
Okay,
rights.
okay.
That's
I'm giving you only two points. On that point, you have to explain. First is a role of human rights in technology. Okay, and second will be that what are the challenges for the justice and accountability in perspectives of India if we focus on the human rights and technological point of view. Only 2 points you have to focus.
So I have to explain it right away. So as you talk about the relevance of both the things, the human rights and the technology plays a very crucial role, first of all. So we just talk about something called privacy and data protection. As we all know, technology, we all use technology, we all are on the digital platform. It's very easy to actually bring someone down and infringe their right of equality. We can talk anything like bad about someone and getting away with it. So we need some stringent actions for that. That is what we are talking about. If we'll discuss, I have something in mind.
Okay. Thank you. And you have presented very well. And now it's my turn to wind up and conclude this technical session. May I conclude?
Yeah. Yes, ma'am.
Yes. This topic was, technical session was very fruitful, and it was very enlightening to all of us and for me also, because I have learned a lot. So now if I focus on the each and every participant, the presenter were very well in their subject, and they have chosen a very important and relevant topics, and they have explained in very well manner. Some technical points, some technical glitches were there, but we can exclude them. But now if I focus, yes, but they have tried to do research and they have presented in very well manner. As I have say that you have to wind up, and they have tried to follow that point in very well manner. So now if I importantly, if I focus on the crux of this technical session is that the technology is very much fruitful for all us, and it has been change our life. And if we see some presenter has focused on the important point that what will be the data protection bill and what will be the important highlights on these rules and regulations. Some have focused on the IPR and the human rights. Some have focused on the role of the justice and the delivery system, why the use of the artificial intelligence, or we can say by the use of technology. And some has focused on the important aspect on the human rights for all our we can say all over area of this technology. So this was the very important and very fruitful, because nowadays we cannot exclude the use of computer in the daily life. And I wish and I wish, and my wishes are also there, that this seminar will be very fruitful for all of us. And I thanks to all of you, and my very warm wishes and greetings to all of you. Thank you, ma'am.
Thank you so much, ma'am. It was really a great technical session. Thank you, ma'am.
Thank you.
We have just concluded with technical session 3. Now moving on to technical session 4, which will be chaired by Professor Dr. Harpreet Kaur. Ma'am is a principal MSc of South Asian University. For this session, she'll be chairing the session. Good afternoon, ma'am.
Yes, good afternoon, all. This technical session 4, there are 3 presentations, and specifically we are talking about COVID and human rights. COVID has been unprecedented, and the reflection of the thing what we say is that, women are neglected and also so on, and they are marginalized, they are facing a lot of problems. So in the crisis, this particular problem enhances, and this is all what we have seen during the times of COVID. So various aspects will be presented by the presenters. Like the first presentation is by Akriti Daksh and Priya Singh. The topic is sexual harassment of women at workplace, human rights violation of women in healthcare institutions during COVID-19 pandemic. So if I call upon them to present there, and in very brief, you can present your presentation.
Thank you, ma'am.
I would like to add, you will be given only 5 minutes for presenting your paper.
Sure, ma'am. Sure.
All right. Let's begin.
Oh, thank you, ma'am. My warm greetings to the chair and all the audience. I am going to present my screen right now. Ma'am, is the presentation visible? Hello?
Yes, it is very much visible.
Yes, your presentation is visible.
Okay, thank you, ma'am. So my the title of my research paper was sexual harassment of women at workplace, as the ma'am said. Now, as we all know, as the ma'am has summarized already, that the violation of basic human rights of women to dignified life was already in a question while they face sexual harassment at workplace. Now, the COVID-19 pandemic gave men a reason to exhibit force and violence within a confined walls. So that becomes very necessary to know whether the COVID-19 pandemic has increased the workplace harassment or not. So coming directly to what violation was in regard to human rights. First, when we talk about right to dignified life, which is also enshrined under Article 21, then right to equal gender, right to personal security and privacy, right to work with dignity, right to freedom of expression, and all the rights these are the rights which we talk about when we talk about human rights violation as with reference to sexual harassment of women at workplace. Now, coming to the healthcare institution and their situation, the healthcare institutions, they have a very wide gathering for patients, staff, doctors, and nurses, and the patients. So to establish a very secure environment is very necessary for the well-being and safety of them. They are legally obligated to establish internal complaints committee to handle the complaints of sexual harassment. And we have seen that there are numerous cases during COVID-19 pandemic, as reported under the newspapers. The National Commission for Women published a report saying that the sexual assault in India has increased 5 times through virtual medium. Charity Rights of Women revealed that the 23% of women who had subjected to sexual harassment during pandemic said that the misconduct of men had been worsened during the pandemic. So we come to the examples and instances of sexual harassment which were observed during the COVID-19 pandemic. As you can see the list of numerous cases, the COVID-19 patients were sexually assaulted, raped, and they died of those injuries too. So coming to the findings of the research that we have conducted during the COVID-19 pandemic in 2020, we have taken a total number of 106 respondents from the Delhi NCR region, from various departments of the hospitals, clinics, and private hospitals also, which admitted that they have been subjected to sexual harassment. 61 people admitted that there is prevalence of acts of amounting to sexual harassment, whereas 45 denied such thing. And amongst those who were subjected to sexual harassment said that medical practitioners also faces sexual harassments. So the table as follows: colleagues 21.7%, patients 13.2%, senior doctor 52.8%. Says a lot about what kind of treatment had been towards women in sexual harassment of at workplace or in a secure environment like hospitals, which were very go-to place to someone or which is a patient which is subjected to such a cruel treatment dies within. Okay, so the hospital management committees are responsible to make them aware about the sexual harassment and the policies and all the complaint mechanism. But 65% of the respondents were not aware about such a committee about sexual harassment in their hospital itself. So that talks a lot about what is the level of awareness in the healthcare institutions. Lastly, all the respondents were asked whether there was any change in number of cases, and few of them, or 24 of them, said that they have seen a rise in the situation of acts amounting to sexual harassment. Not as such, all the acts comprises of them, and they were not aware of that. They have been cases when they have reported and they have not been treated right by the committees. And that's all. I would like to conclude that the state of women medical professionals in sectors like healthcare institution is very much in grave danger. So we need to make them aware of the grievance their grievance redressal so that that can end completely. Now, my co-author would talk about the other part of the paper. Please. Hello.
Good evening, teachers. Continuing with this, current position of law is that there is UDHR, Universal Declaration on Human Rights, and Equal Opportunity Resolution and Equal Treatment of Men and Women, International Covenant on Economic, Social, and Cultural Rights, 1966, and then there is ratification of CEDAW, that is in 1993. All these international conventions uh, talked about prohibition related to gender-based violence, which harms or diminishes enjoyment of fundamental freedoms and human rights of women. Then cases in India. Uh, Firstly, talking about Vishakha versus State of Rajasthan, certain guidelines were issued for preventing cases of sexual harassment of women at workplace.
Priya, I suppose you are exceeding your time limit.
Okay, ma'am, I will try to conclude it. So then there are two legislations, that is POXO and POSHA. Then there are two mechanisms, formal mechanism and informal mechanism. Firstly, on the behest of agreed individual, conciliation will arise. After conciliation, no further investigations are made. However, the claimant may appeal to committee that will result into an inquiry. Then inquiry under the
Priya, you
Post
have
Act.
exceeded your time limit.
You can just conclude.
Okay, ma'am. So, my conclusion would be that the state parties must implement appropriate measures to eradicate discrimination against women across various domains, including but not limited to employment, legal equality, administration and politics, governance, education, healthcare, and other facets of public and society. And for this, the suggestion would be that inclusion of sexual harassment laws as a part of compulsory education should be there. And there must be conduction of workshops, webinars, and awareness campaigns for this so that the cases won't come up so quickly, frequently.
Yes, thank you. Your presentation was very well presented. It has two aspects. One aspect is the human rights and the COVID and the women. And of course, where you suggested all the acts and all, where the women should know about it. We see, society is gendered. That gendered approach is there in the society. We are seeing war in Gaza. We are seeing war in Syria. There also gendered implications are there during the war also. And pandemic, if I say, is also gendered. The impact of COVID on women was much more than what it was there on men. So, and these are a lot of problems you have mentioned. The health workers were facing threats from the society. They were not allowed to go back home. We all read about the instances. Also bullying, verbal abuse, and physical problems also. But mental problems, that mental burnout and that mental well-being also was at distress. So and COVID impacted women quite negatively, and of course you suggested very well that women should know about the laws and regulations which are there for them, so that if they feel there is something wrong which is going on, for that they must speak and take recourse on the law. So very well presented. So thank you very much. And the next presentation is by Mr. Amit Prakash, student from IMS, and Ms. Harshita. And their topic is Impact of COVID-19 on Human Rights and the Way Forward.
Yeah, good afternoon, ma'am. Am I audible?
Yes, you are audible.
Yeah, I'm sorry, ma'am, but I'm not able to switch on my video because I'm facing some technical issue. And it's
all right.
Yeah. Okay. Thank you, ma'am. Ma'am, my co-author is Harshita, and she will share her screen.
Okay.
Okay. Harshita, will you? Uh, Today, I want to talk about a topic that has affected all of us deeply, the impact of COVID-19 on human rights and what lies ahead. The COVID-19 pandemic has had far-reaching effects on human rights worldwide, and from restriction on freedom of movement and assembly to the challenges in accessing healthcare and education. The pandemic has posed significant challenges to the protection and promotion of human rights. It has also exposed pre-existing inequalities and vulnerabilities within the societies. We all know that the COVID-19 pandemic has brought about the immense changes in our lives, and it has also had a profound impact on our human rights. The measures taken to control the spread of the virus, such as lockdowns and restriction, have sometimes clashed with our individual freedoms. We have seen limitation on our freedom of movement, assembly, and privacy. It's important to acknowledge that while these measures are necessary for public health, we also must also find a balance that respects our rights. On the second part, but it's not just our physical well-being that has been affected, and the pandemic has taken a toll on our mental health as well. The stress, anxiety, and the feelings of isolation have become all common. The main topic on which I want to talk is the mental health disorder. In this, the mental health disorders like depression and anxiety have been a significant rise during this time. And during this COVID-19 pandemic, the protection of the fundamental right to health and medical care emerged as pressing concern on a global scale. Governments around the world were compelled to implement a range of measures, including lockdowns, travel restrictions, and quarantine protocols, in a concrete effort to curb the spread of virus. But it's crucial to recognize the interconnect between the human rights and the mental health. Now, I will not take that much time and want to, in the conclusion part of this, ma'am, the COVID-19 pandemic has left an indelible mark on our world, affecting very facet of our lives and exposing vulnerabilities in our societies. It has not only been a global health crisis, but has also raised profound human rights concerns. The mental distress become a widespread issue, emphasizing the importance of addressing mental health stigma and ensuring accessible resources for all. The pandemic has tested the right to health and medical care, revealing disparities and the need of the resistance healthcare system. Thank you, ma'am. That's it
Yes.
from my side.
That's good. You were precise, and precisely you have explained various things. I think we all were talking about the economic impact of COVID immediately, and a lot of things were in disarray. But you have very well pointed out that mental well-being, which was being affected adversely, a lot of problems came on later on. Now we can see the statistics, and we can see that how many divorce cases had increased not only in India but also abroad. Physical and mental abuses which went on all through the global world. So all these things were there affecting the mental health. So and it came so suddenly that we did not know how to pass our time. So idly you were working, and you were sitting idle, and that impacted quite a lot. So that is why mental well-being is largely very important. And just to think about it, because pandemic like situation is once in, of course, lifetime, and it might not be there, but this mental well-being is such a thing that we must preserve and channelize the energies of the youth, especially in a positive manner. And so the cost of a pandemic, which was also the impact on mental well-being, because till date some people have not emerged out of that disarray. And so that is why we have to work on this and be positive. That is what is important. And so third presentation in this session is a study of COVID-19 pandemic and human rights in India by Ms. Shilpa Tyagi. She's assistant professor, IPM Law Academy.
Yes, ma'am, but she has a meeting scheduled for the time. She will not be available for this technical session.
Right. So I'll just conclude. Both the papers show the impact on the human rights and COVID. And COVID-like situation is a kind of a rare thing. But we must be prepared, because COVID was just reflection of what is going on in the society at present. In the present also we see human rights violation, but we have to understand that women have to come out of it. They have to have confidence to bear all this, because especially because we talk about women in this. So domestic work, which is invisible and which increased in COVID, and those things are became more pervasive. So we have to understand that we have to empower our girls, and we have to come out of this patriarchal construction of the society and gain momentum through education. And if education is there, if health is there, if challenges of workplace are overcome, and the family bonds are very, very deep, then gender equality and work family supportiveness, all these things are there, then a strong sense of entitlement would be there, and the human rights issues which we are seeing normally in the society and in the crisis situation would not be there. So this sense of entitlement and gender equality is very important. So strategic importance or strategic focus should be there in progress of mental well-being of women. And so I thank IPM for inviting me to chair this session. And I must appreciate your principal, Dr. Meenakshi, who is taking personal interest in all these in organizing the conference, Dr. Priyanka and all others who are here as conveners, and all the participants. You have given a platform to the young scholars to present their views, and I'm sure out of these scholars, there will be good intellectuals who will come out, academicians who will be churned out. So thank you very much for inviting me and inviting them. Thank you so much.
Thank you, ma'am. Thank you for such a nice concluding remark. We highly appreciate your presence. Thank you, ma'am. Respected dignitaries, participants, we have just concluded with technical session 4. Now we are heading to last session of this conference, technical session 5. For this session, the chair of the session will be held by Dr. Chola Raja Murdimanan. Sir is an assistant professor, senior scale, Campus Law Center, University of Delhi. Welcome, sir, for the 4th International E-Conference of Human Rights.
Thank you, ma'am. Thank you so much, ma'am.
Yeah. Sir, the first person who will be presenting paper is Sahana Ramesh. She is a student of St. Joseph's College of Law. The topic of her paper is Wheeling Liberty, an examination of repressive governance in Iran and its impact on women's rights under the mandatory hijab law. Do we have Sahana? Sahana, are you available? Peter, you're not audible.
Am I audible now, ma'am?
Yes, you are now.
Shall I share my screen?
Yeah, surely.
Is the screen visible?
Just keep in mind that only 5 minutes will be provided to you for presenting your paper. Sana? Sana, can you hear me?
She's tried to sharing the screen.
Okay.
Yes, ma'am.
Oh, all right, Peter. Thank you.
Please,
okay, shall I?
please be ready to share the screen. Before that, ask to ma'am, and she will also help.
Right. Good afternoon, Anna Ramesh, and it's an honor to be able to present our paper in front of you. Both my co-authors, Sanjana Ramesh, are able to present our paper, Whaling Liberty, an exam. And to begin with, I'm having issues with my PPT. Can somebody else share it, as it's taking a lot of net? Okay, I have it. To begin with, it was the Islamic Revolution of 1979 that made hijab wearing mandatory. But before that, what is hijab? Hijab has been used multiple times in the Quran, and its literal sense means curtain or barrier, which differs from khumur and jalabib. These two words give the closest meaning to a piece of cloth or veil that women can use to cover their heads. The Islamic Revolution was a protest of the society against the state for the abolition of monarchy and for an Islamic republic, which was a series of events, as mentioned, dated from 7th January 1978 to 11th February 1979, which ultimately resulted in the overthrow of the pro-Western regime of the Pahlavi dynasty, replacing the same with an anti-Western totalitarian theocracy. The triggering factor to overthrow the monarchy and the Western interest was the economic collapse of Iran in 1977, which caused high employment and rising inflation. The movement saw the end of 2,500 years of Persian monarchy. And thinkers like Michael Foucault even declared that it was the first great insurrection against the global system. Coming to the reason for the protest, a protest was basically a reaction to the frequent human rights violation and the abuse of power. The case that mainly triggered the people of Iran was the case of Mahsa Amini. That is, a woman on 13th September 2022 was detained by the Morality Police or the Gasht-e-Irshad, a unit of Iran's police force that established under the former president Mr. Mahmoud for wearing a hijab improperly, and she was traveling to Tehran and she died in police custody 3 days later. It was alleged that the reason for her death was police brutality, while it was reported that she had died from a heart attack. As per the reports from the BBC News, it was stated that she was hit on the head by a baton by the officers while taking her to a re-education center. As a result, the protest persisted all over the country against the excessive penalties imposed on women due to the mandatory hijab. And Article 638 of the Islam's Penal Code 1996 states that women who appear in public places and roads without wearing any hijab shall be sentenced to 10 days or 2 months' imprisonment or a fine of 50,000 to 500,000 riyals. Coming to the next one, there are other such incidents as well. Dehradun, the capital of Sistan and Balochistan province, became one of the highest death counts since the protest began. Protesters, including the worshippers and the bystanders there, were victims of excessive force by the government, who used live ammunition and deployed metal pellets, etc. And there were even tear gas that were used on people after the prayer in front of the mosque itself, which was called the Bloody Friday by the Amnesty International. There was another unfortunate incident where a 16-year-old protester was allegedly murdered by the security forces, which is said to be one of the highest profile cases of a young person dying in a protest. The 16-year-old Nika Shikarami went missing after sending a message to her friend that the police were following her. However, authorities claim that she might have been pushed by the construction workers from the top. There were even instances where deliberate poisoning of more than 1,200 schoolgirls in major cities of Iran were poisoned, and which resulted in many young girls discontinuing their education due to the fear of being attacked. As you can see on the left side of the slide, there are these are the demonstration of women protesting by cutting their hairs and burning their hijab as a form of protest and to make better political and economical reforms. Coming to the next part of it, the response of the state. The state basically, in simple words, they just defended themselves. Iran's deputy foreign minister, Ali Bakeri, blamed the Western countries for building a baseless and fallacious atmosphere, and they said that the rights of the nation were violated by these Western powers. And while protesters in Iran were only demanding accountability for the death of Mahsa Amini and to call an end for an ongoing protest, the government in turn continuously used live ammunition, metal pellets, etc. And there have not only been reports of physical violence, but also sexual. The Iranian authorities have denied public institutions like schools, colleges to all those who are not willing to wear their hijab. And Iran, ignoring all their pleas from the protest, have even sought to enact a bill concerning hijab that has harsher penalties for women who refuse to wear a veil. And the draft is said to contain 70 articles, and there's also presence of AI to identify women who are not willing to wear a veil. The UN, in turn, by Mr. Javed Rahman, the special reporter on this case, said that the investigation that was done on the case of Mahsa Amini were neither credible nor transparent. And in the UN took a step. The United Nations Economic and Social Council voted to remove Iran from the Commission on the Status of Women, CSW, for the remainder of its 4-year term, which ends in 2026. There are certain laws, few of the many systematic violations of human rights, among this, and Iran ranked 5th worst in political empowerment of women among 146 countries covered in the World Economic Forum. In the Global Gender Gap Report, these are the few of them, like divorce, child custody, and etc. Divorce, for example, only a man is allowed to pronounce the divorce verbally without citing a reason, while a woman has to take the judge's assent. Same with the child custody as well. Under the age of 7, only the women are given preferential custody. Coming to the inheritance, the husband, according to the Islamic inheritance law,
Sahana,
yes,
you have exceeded your prescribed time limit.
Okay, I'll conclude then. So these are the laws I've mentioned among the very few of the systematic violations, gross violations against the women in Iran. As a conclusion, I want to make it clear that our paper does not dwell on the aspect whether women should be wearing hijab or not. It only focuses on the excessive regressive response by the Iranian government through gender-based persecutions and through unacceptable gross violations of women, as already said before. And hijab, that was once a religious symbol, has now become a political agenda. And international actors do play a significant role for there is a chance for opportunity. And as ma'am also rightly said, during the beginning of this conference, she quoted Sir Nelson Mandela's words. It was to deny people their human rights is to challenge their very humanity. And that is what I would like to conclude with. Thank you.
Thank you so much, Sahana. You took such a controversial area that, the judgment also in Karnataka High Court also it was there that we might be knowing the 2 different judgment also available there. But what exactly you missed that UN, United Nations role on human rights. So in that part, try to add it that because the theme itself says some of the things related there. So try to add it and try to find out some international judgment, also some solutions also. Try to give some valuable suggestions also. Then try to publish it also. Thank you. Thank you so much.
Thank you so much, sir.
So next we have Dr. Rita Bansal. Ma'am is an assistant professor in BTSS College of Law. Her topic for today is Balancing Act, exploring global challenges and strategies in implementing human rights from an international perspective. Ma'am, you will be given only 5 minutes to for presenting your paper. Ma'am, you are not audible. Kindly unmute yourself. Dr. Rita, kindly unmute yourself. Yeah.
Am I audible, ma'am?
Yes, very much. Thank you.
Is my PPT visible?
Yes.
Yes.
Good evening, sir. Good evening, ma'am. So my topic is from international perspective, what are the global challenges and the strategies in implementing human rights? The very first thing that comes to our mind is the UDHR, which had actually laid the foundation for subsequent international treaties and conventions. Basically, what we need to look at it is the significance of human rights in international arena. Then it comes to our mind that it is regarding protection of dignity and equality, international peace and security, development and well-being, global norms and standards, economic and social progress, progressive development. Basically, human rights, they play a pivotal role in shaping international landscape. And the evolution of human rights norms and mechanisms, they continue to shape global interactions and efforts to create a just and equitable world for present as well as future generations. Another thing that comes to our mind is regarding cultural relativism and universality. Different cultures have varying interpretations of human rights, which leads to debates about universality versus cultural relativism. Like some governments argue that certain rights might conflict with their cultural or religious beliefs, making implementation indeed challenging. Say, for example, freedom of expression might be understood differently in societies where certain topics are considered taboo. In some cultures, collective rights might be given more emphasis than individual rights due to cultural norms that basically prioritize community over individualism. So, in overall, we can say that the enforcement of human rights treaties and agreements, they can be impeded by various legal and political obstacles. Say, for example, many countries fail to inculcate international human rights obligations into domestic laws and policies. Because the impact is then what? Without local legal framework, individuals lack mechanisms to seek remedies for human rights violations. This creates a gap between international commitments and on-the-ground protection. Say, for example, even some governments resist external scrutiny and intervention, citing concerns about their sovereignty. Impact is that states may reject international oversight, impeding efforts to address human rights violations through international mechanisms. Say, for example, weak international cooperation or conflicts between states can hinder effective implementation of human rights treaties. Impact is that there is cross-border issues like migration, human trafficking, environmental degradation, which indeed requires collaborative efforts. But political disputes can impede cooperation. So addressing these obstacles require a combination of efforts, including raising awareness, strengthening domestic legal system, enhancing accountability mechanisms, and of course, promoting transparency and encouraging international cooperation. I've covered some case studies. I'll just come to the very fact how government feels. Say, for example, in case of Myanmar and the Rohingyas crisis, Myanmar has been resistant to international intervention, asserting that situation is an internal matter. And government's denial of allegations and its reluctance to allow international investigations or, say, humanitarian access indeed highlight challenges in addressing such crises when state sovereignty is prioritized. Say, for example, another case study which is on Venezuela and political repression. I'll just come to what government feels. So in case of Venezuelan government, it has labeled international criticism as interference in its internal affairs and has withdrawn from international human rights mechanisms. So this stance has indeed hindered efforts to address the crisis. These case studies, in fact, demonstrate how state sovereignty, while a foundational principle of international relations, can at times challenge the effective implementation of international human rights norms. Coming to the suggestions for strengthening international legal mechanisms, then according to me, when I went through these doctrinal research, I found that we need to encourage states to submit comprehensive...
Dr. Rita?
Yes, madam.
Ma'am, you have just exceeded your prescribed time.
Ma'am, I'll wind up in 2 minutes.
Ma'am, 2 minutes will be more. Just try to wind up as soon as possible.
Sure, ma'am. Sure, ma'am. Thank you very much. Sir, I will directly come to the suggestions and recommendations. Implementing human rights on a global scale is a complex challenge that requires indeed international cooperation and multifaceted approach, such as like different countries have different diverse legal systems, cultural norms, interpretation of human rights, making universal implementation indeed challenging. At the end, what I can say is that ultimately implementing human rights on a global scale, though it is an ongoing process that requires the commitment of states, international organizations, civil society, and individuals, it also involves both long-term strategic changes and targeted efforts to address specific human rights violations. Ultimately, the pursuit of human rights is a shared responsibility that transcends borders and ideologies, and it is through collective action that we can build a more equitable, and humane world for future generations.
Dr. Rita, your time limit has been exceeded.
Ma'am, I have concluded.
Yeah.
Thank you very much.
Thank you so much, ma'am. I saw your work, it's very endeavor, lot of places. For example, in the international perspective, lot of case studies, Russia, China, and Tibet issues. Then even the conclusion also, because the global inequality, then technological related productions also.
Right, sir.
And really you should try to publish this paper, ma'am. That's the time limit. We know that we cannot do some of the things, even though when we have 5 minutes, we want to try to conclude that. Really
Right,
excellent.
sir.
I saw that while you were delivering also. Try to make it along with the proper citation and reference.
Sure.
Try to publish this article. Because
Humble,
now I
sir.
saw the PPT itself, for example, when we want to eat the chawal, just to thoda cha khata na, toast malum hai na. So through that
Right,
work,
sir.
this 5 minutes itself, I found this is a good work. Please try to
Right.
publish it. Very good.
Thank you very
Thank
much, sir. Thank you, IPM
Thank you.
University. Thank you very much.
Thank you. Sir, next we have Dr. Akida Khan. Sir is a professor, law school, Noida, but on his behalf, Sarah, who is a student of BLLB 5th year, will be presenting the paper. The title of a paper is Forced Displacement and Human Rights, a study of international law and case law. Sarah.
Good afternoon, sir. Good afternoon, ma'am. I would like to
Very
present
good
my
afternoon.
screen to you now, as I'm presenting my phone screen. So sorry for the problems. Just a minute, I'll just share the screen.
Yeah. Sarah, you will be given only 5 minutes to present your paper. So do
Okay,
keep
ma'am.
while presenting the paper, do remember the time clock.
Okay, ma'am. Just a minute. Okay, there is some problem with the screen sharing right now. I don't know what it is. It was working a minute before that. Can I just like without sharing the screen, can I just read the presentation? Would it work?
Yeah, you can.
I'm sorry for that. Like,
But since you're a student of law, just do remember it's a very formal event.
sorry, ma'am. Just I had the laptop, just some technical issues with that one. That's why the problems like that, right? Okay. So my topic is forced displacement and human rights, and I am speaking on behalf of Shweta, and I am speaking on behalf of ma'am, and I am a third year law student. So, the causes of forced displacement. Forced displacement refers to the situation where individuals or groups are forced to leave their homes or places of habitual residence due to a range of factors, including conflict, persecution, human rights violation, environmental disasters, and development projects. Forced displacements can take various forms, including internal displacement within a country's border, cross-border displacement, and refugee movement. Forced displacement law, international human rights and forced displacement, international refugee law, other relevant international legal instruments, the International Convention on Economic, Social and Cultural Rights, the Convention on Rights of the Child, protection of human rights in case of forced displacement, right to life and security, right to freedom and movement and residence, right to work and education, and right to non-discrimination and equality. So, ma'am, forced displacement has become a global issue right now, and these are the rights that the person can use if they are forcibly displaced from their places of habitual residence and are having problems. There are several case studies in which which involves the cases of forced displacement and human rights violation. These are Syrian refugee crisis, the Palestinian displacement and occupation, the Colombian displacement due to armed conflicts, and the Rohingya crisis in Myanmar. The gaps in the legal framework and possible solutions. In the inadequate protection of economic, social, and cultural rights, international application of the principle of non-reinforcement, limited access to justice and remedies, need for a comprehensive legal framework for internal displaced persons, proposal for a new legal instrument with forced displacement and human rights, inadequate protection of economic, social, and cultural rights, inconsistent application of the principle of non-refoulement, limited access to justice and remedies, need for a comprehensive legal framework for the IPTs, proposal for a new legal instrument on forced displacement and human rights. A new legal instrument on forced displacement and human rights would provide a comprehensive framework for the protection and promotion of the right of refugees and IDPs. The instrument could build on existing international human rights instrument and refugee law and address the specific challenges faced by those who are forcibly displaced. The new legal instrument could include provisions on protection from forced displacement, responsibility sharing, monitoring and reporting, role of media and prevention of domestic violences. I would like to conclude that the study has highlighted several key findings related to forced displacement and human rights. Forced displacement is a major human rights issue that affects millions of people around the world. The legal framework governing issues and IDPs is inadequate in many aspects, leaving them vulnerable to human rights violation. There are significant gaps in the protection of economic, social, and cultural rights for refugees and IDPs. The principle of non-refoulement is not always applied consistently, leaving refugees at the risk of forced returns. Across Access to justice and remedies for human rights violation is limited for refugees and IDPs. A strict action should be taken against the culprits, and crimes increasing in the society should not be unseen and unjustified. Strict actions must be taken against the offender, and rising crime rate in society cannot be excused. There should be a swift trial and an urgent appeal to the court. Women's rights should be promoted by the campaigns and demonstration, and every woman should be encouraged to speak for herself in any circumstances. The findings of the study, the implications of the study. The findings of the study have significant implications for policy and practice related to the forced displacement and human rights. They highlight the need for greater attention to be paid to the protection of economic, social, and cultural rights for refugees and IDPs, as well as the need for more consistent implementation of principle of non-refoulement. The study also emphasizes the importance of providing refugee and IDPs with access to justice and effective remedies for human rights violation, and the need for comprehensive legal framework to address the full range of human rights challenges associated with forced displacement. The study has also revealed several areas for future research related to forced displacement and human rights. These include further exploration of challenges faced by refugees and IDPs in accessing economic, social, and cultural rights.
Sarah, your time is ended, beta.
Just a second, ma'am. Just. And the development of strategies for addressing these challenges. Examination of the factors that contribute to inconsistent implementation of the principle of non-refoulement, and the development of strategies for improving implementation.
Sarah, your time is ended.
Yes, ma'am. Just a point that is left.
No, beta. There are other participants as well. Thank you.
Okay, ma'am. Thank you, ma'am.
Yeah.
Yeah, thank you, Sarah. Thank you so much.
So, next participant is Anand Patient, School of Law, Sushant University, Gurgaon. Title of his paper is Unlawful Killing in Israel-Palestine Conflicts, an Overview. A paper of supreme importance in the current scenario, I guess.
Good afternoon, everyone.
Good afternoon.
Am I audible?
Yes, very much.
Good afternoon, everyone. I am Anant, a PhD research scholar from Sushant University, Gurugram, Haryana. I would firstly thank the panel members and the prestigious IPEM Law Academy for providing me an opportunity to present my research work. The title of my presentation is Unlawful Killings in Israel-Palestine Conflict, an Overview. So, firstly, in my today's presentation, I will begin with the introduction to the concept of unlawful killings. I will be also covering the issue of conflict between Israel and Palestine, as well as unlawful killings according to the provisions of the Rome Statute and the various recent developments that have taken place in the conflict. And then I would like to move on to the conclusion. So, can I start with the presentation, because it's just opening. My PPT is just opening. So, can I speak?
Yeah, sure.
So, in my today's presentation, as I said, about the topics which I will be covering, and firstly, by giving a brief introduction to the concept of unlawful killings, I would like to say that unlawful killings are the war crimes under Rome Statute. They pose a threat to the humanity across the globe, and human beings, we all are expected to have minimum basic rights and liberties, and which are to be ensured by the government, and the government can do that through its law and its constitution. The unlawful killings are extrajudicial killings with innumerable instances that are taking place in West Bank, where the Palestinians are targeted regularly by the forces of Israel. So, as I was speaking about the introduction, now can you see the PPT? Is it visible?
No, we can't see the PPT, but what we can see is you're sharing your screen.
Yeah. Is it not visible?
No, not at all.
Okay. Now is it visible now?
No.
Okay, so I would like to continue then. So as I was saying about as I gave the introduction right now about the concept of unlawful killings, and these are basically the extrajudicial killings with innumerable instances which are happening in West Bank, where the Palestinians are targeted regularly by the forces of Israel. These killings have unfortunately assumed a very dangerous form in Middle East, especially in the Arab-Israeli conflict, and the authority of the state must promote the protection and promotion of the basic human rights, as well as it is their duty to ensure the safety and security of its citizens. There are in this conflict of Arab-Israeli conflict, which is happening in Middle East, there are the components of the state authority, which include the security department, that are unfortunately involved in the violation of the basic rights of the victims, and the victims are the Palestinian civilians of the state of Israel. Now, moving on to the concept of unlawful killings, I would like to say that these dangerous activities which are prevalent in Middle East, especially in the scenario between Israel and Palestine, they pose a threat to the humanity, and the war crimes, which is a broad term, and it includes those type of particular crimes that create an individual accountability for their commission. And the war crimes are defined under Article 8, Clause 2, Subclause 8, to Article 8, Clause 2, Subclause E of the Rome Statute. The Rome Statute is the governing body of the International Criminal Court. So basically, there is the creation of an accountability for the commission of these sort of extrajudicial killings. Now, moving on to the concept of what is the main bone of contention between Israel and Palestine, and why they are fighting. It is a political conflict between the Jews of Israel and the Palestinian Muslim Arabs over the land which was historically known as the British Mandate of Palestine. And the roots of this conflict can be seen back to the 19th century, when there was the growth of a movement called Jewish Zionism. It started in the 20th century when a Jew named Theodor Herzl had started that movement. And according to this movement, a Jew from any part of the world could come and settle in Palestine. The Arab nationalism, which was prevalent over there in that historical British Mandate of Palestine, had opposed this movement. The United Nations in 1947 tried to partition Palestine, and they were successfully able to do that. And they did that with the resolution, which is known as the Resolution 181. And it partitioned that British Mandate of Palestine into a Jewish state, which is now known as Israel, and the Arab state. Now, defining the unlawful killings according to the provisions of Rome Statute, I would like to say that Rome Statute is the governing body of the International Criminal Court, which was established in 1998, and it describes those who are accused of war crimes, and they must be tried by this court.
Anand, your prescribed time has ended.
Ma'am, I just need one more minute, please.
I am, sir, what would you suggest?
Only 1 minute. I'm just very close to finishing it.
Sir?
Yes, please.
Only 1 minute. So Article 8 Clause 2 Subclause B Part 1 and 8 Clause 2 Subclause B Part 2 of the Rome Statute deal with the unlawful killings, which is a war crime. And there are many instances that are taking place, especially in between the years 2015 to 2021. Now, defining the elements of unlawful killings, I would like to say that there are only 3 elements: objective, subjective, and the legal. The objective element is to kill the person. Subjective element is the intention of the perpetrator to kill or even cause serious injury to the victim. The legal element is that what the law considers that the perpetrator is liable for the unlawful death of the victim. It creates a liability because it is a legal element. Now, moving on to the recent developments that are happening in this conflict, I would like to say that Palestine became a party.
Anand, you have ended your prescribed time limit, please.
Okay, ma'am. I was very close to the conclusion now.
You have already exhausted 1 extra minute. 6 minutes was given to you.
Okay, ma'am.
Thank you, Anand.
Thank you, everyone, for the patient hearing.
Thank you, Anand. So next we have Richie
What
Mini
about his
Proma.
hypothesis? Ma'am, what about the hypothesis of his argument, that presentation? Anand.
Yes, sir. Hypothesis, I would like to say that what is the role of International Criminal Court, that it is supposed to try the authorities of Israel who are liable for committing extrajudicial killings in Palestine. And Palestine had become a party to ICC on 2nd January 2015, and it entered into force for Palestine on 1st April 2015.
You are not understanding first. You are a PhD scholar. Please learn first hypothesis.
Sir, the hypothesis of my problem is that how effective International Criminal Court has been in sorting out the conflict between Israel and Palestine, and what are the possible ways by which the unlawful killings can be stopped in this conflict, because it has assumed a very dangerous form. It has to be stopped at any context, at any point,
Anand,
and how it can be effective.
Anand,
Yes,
I'm not asking about what are the issues involved. I'm asking simply hypothesis. Please update it for the future.
Yes, sir.
Next time.
The role of the International Criminal Court in sorting out the war crimes and crimes against humanity in the Arab-Israeli conflict. This is the main hypothesis problem. And secondly, how the United Nations Security Council can play an important role in ensuring the peace to be maintained in this conflict, and how quickly the International Criminal Court can conduct the trial of the war criminals in this conflict. How effective it can be.
Yes.
Yes.
Thank you. The next.
Thanks. Thank you, everyone, for the patient hearing.
Thank you, Anand.
Thank you.
How many of them left?
Yes, sir. So the next one we have is Richie Mini Proma. She's a lecturer law in Bangladesh Open University, Bangladesh. On her behalf, Anusha, who is a student of BLLB third year, IPM Law Academy, will be presenting the paper. The title of her paper is The Paradox of Just ad bellum and Just in bello in Modern World, Justification of Just War versus Forced Intervention. Anusha, please.
Greetings, everyone. Myself, Anusha Verma. Currently, I am in second year of my law school, which is IPM Law Academy. Today, to put on the table, I will present the research on behalf of the researcher, scholar Richimoni Proma, which titled The Paradox of Just ad bellum and Just in bellum in Modern World, Justification of Just War versus Forced Intervention. As Richimoni Proma is not available for this. The paradox of just ad bellum and just in bello in modern world, justifications of just war versus post invention. Just ad bellum, principles of waging just war, conditions of just war are, the points are here. Just cause, legitimate authority, right intention, probability of success, proportionality, last resort. Modern day just in bello 10. Discrimination. Military personal versus civilians, military objects versus civilian objects, proportionality, reconstructions of the frameworks, reforming just cause and legitimate authority principle, strengthening conflict resolution measures worldwide, adherence to principle of discrimination and proportionality, human security and safety over state sovereignty, rethinking the probability to succeed principle by improving security council's effectiveness. Thank you.
Please call the next presenter, ma'am.
All right. Next we have Trishala. She's an assistant professor of law, Maharashtra National Law University, Maharashtra. Her title of the paper is Biodiversity and Human Rights, Ascertaining the Linkage for Effective Implementation of Access and Benefit Sharing in India.
Thank you so much, ma'am, and the chair for giving me this opportunity to present my paper. As the ma'am has already told, the title of my paper is Biodiversity and Human Rights, Ascertaining the Linkages for Effective Implementation of Access and Benefit Sharing Mechanism in India. So I've started the paper by explaining what are the positive and negative linkages between biodiversity and human rights. There are plenty of positive linkages that we can think of, especially from the perspective of access and benefit sharing mechanism. I have analyzed the UDHR articles which are there and how relevant they are in this particular context. So when we are talking about access and benefit sharing, it is the benefit sharing with the indigenous people that we are talking about. And these indigenous people, they are wholly dependent upon biodiversity for the realization of a whole lot of their basic rights, which are there, like right to life, right to health, food, livelihood, and also cultural dependence, habitat support. For all of these things, the indigenous people are dependent, especially talking from the ABS point of view, access and benefit sharing point of view. But at the same time, there is one negative linkage that I could pinpoint over here. The main negative linkage is this only, that excessive conservation of biodiversity by creating protected areas, which are plenty of in situ conservation method protected areas, which are there, like national parks, wildlife sanctuaries, or maybe if we are going for the strict classification of forests that we are having in the Indian Forest Act 1927, then it might lead to the exclusion of these people, and the rights which they were previously enjoying, they won't be in a position to enjoy the same as such. So there are plenty of cases also which I have mentioned. Animal and Environmental Legal Defense Fund case, Pradeep Krishnan case, Tarun Bharat Sangh case, where the rights of tribal people were discussed in a protected area, in an area where the intervention is somehow...
The case class, ma'am, the case class, it's not visible, only the linkage only showing there. The slide is not moving.
Sir, is my slide not visible still? I mean,
No, visible, but you presented something, after that you went to positive and negative, then you mentioned the case class, but it is showing positive linkage and negative linkage slides.
Yes, sir.
You
So I have mentioned in the second point only, sir, in the negative linkages, the second point which I've mentioned, creation of protected areas, there I've mentioned the names of the cases that are there. Where
you mentioned some judgment there. I'm asking that.
Yes, sir. Yes, sir. It's the judgment only. Animal and Environmental Legal Defense Fund case, Pradeep Krishnan case, which is there, and Tarun Bharat Sangh case. So these are the judgments which are there where this very issue was discussed. Means the rights of the tribal people in the protected areas. Then I've gone into explaining the framework on ABS that we are having. So starting with the UN Convention on Biodiversity that we got as an outcome of Rio Summit in 1992. Then in 2002, we had our own act which talks about the access and benefit sharing mechanism, which is very much in line of the UN CBD only. The third objective deals with access and benefit sharing. In both of these frameworks, international and national. In 2010, we got Nagoya Protocol on Access and Benefit Sharing, which further explains on how access and benefit sharing is supposed to be implemented, as it is one of the core objectives of the UN CBD, which is there. And finally, on those lines only, 2014, we have got Indian ABS guidelines. So the moot point that I have made in this entire paper is this, that when it comes to the implementation of access and benefit sharing mechanism in India, We are having proper framework and everything, but there are systematic loopholes which are there, which is actually preventing us from properly implementing this framework in our country. So why not link it with the human rights framework, so we'll be able to conserve biodiversity, at the same time we'll be able to share the benefits with the local people, with the indigenous people. But whenever this call is being made, whenever benefit sharing agreements are being signed under ABS, at that point of time, it is not only the rights of the tribal people which should be borne in mind from the Forest Rights Act that we are having in our country, but at the same time, if we are linking it with the human rights which are there, then we'll elevate the status, and that will help in proper implementation and further strengthening the human rights laws as well as biodiversity laws in our country. So that is the main core argument that I've made in my paper, and that's all, sir, from my side. If you have any questions that I could answer.
But due to time limit, already madam requested that just suggestion only. But really, great area, biodiversity, and lot of postdoctorate available, lot of funds also available. If you have time to that, you can look at my LinkedIn page. I updated even last 15 days ago also some postdoctorate project also regarding that biodiversity and the human rights related. In particularly Denmark, according to my knowledge, if I'm right. So
Yes.
try that also. When we are in national university, it's easy to get the postdoctorate permission, other things. So please try it. It's my suggestion.
Yes, sir. Yes, sir. I will. Thank you so much, sir.
Yes.
So next we have, and the last presenter for this session, Abhay K. Win, student, Institute of Integrated Learning Management. Title of his paper is Refugee Crisis and its Current Trend Across the Globe. Abhay.
Good morning, sir. Good morning, ma'am.
Good evening.
Good evening, sorry.
Yeah. Also, you will be prescribed only 5 minutes for presenting your paper.
Yes, ma'am. Sure. So, as ma'am has already mentioned, my topic is refugee crisis and its current trends across the globe. I wanted to do a research paper on this because, as we all know, the current global wars happening. First, it was before Palestine war, it was Russia and Ukraine, and people who suffered have no answers yet except from UN. So, understanding what is world refugee crisis is that the hunger of power between countries have put a lot of people homeless. So more than 100 million people are currently forcibly displaced globally, facing life-threatening situations such as advancing armies, gang violence, etc. And these displaced individuals often struggle to access essential necessities like food, clean water, housing, personal security, and medical care in the pursuit of safety. So, imagining being in their position, people don't want to go back to their homeland itself is a very big sad reality for us to face. And so I also wanted to sort out a basic common questions among people, because we know what refugee is, who is a refugee, but I wanted to detailedly explain everything just in case if anyone wants to know. So refugees are people who are one second, who are fleeing violence or persecution due to race, religion, or their any kind of identity. And internally displaced refugees are internally displaced people are who were forcibly uprooted from their country of origin but are still residing there, much like refugees. And migrants are who are willing to or voluntarily relocating to another nation for economic or their work or any kind of reason. So here are some facts about countries with the most refugees, which is Syria, Ukraine, and Afghanistan. this is according to the current trends also, because Ukraine is facing a lot of still facing a lot of tension from Russia. Afghanistan is still going through a lot of crisis. So next is that how India has considered protecting refugees. Now, for India has formally registered the refugees by giving them Aadhaar cards or any kind of identity, so that they are economically involved in Indian economy. So India also makes sure that refugees have access to the same safety net as their native hosts. Like Constitution does not ignore any refugees to claim Article 21, which is right to life and personal liberty. And one of the concerned treaties is that 1951 convention. So millions of people fled their homes after World War I and during World War II, leading to development of international agreements to protect refugees. The 1951 convention relating to the status of refugees, along with the 1967 protocol, provided a comprehensive framework for refugee rights. The UNHCR is the key protector of these documents, assisting governments in translating them into national laws. So there's another interesting tripartite agreement between Sudan, Democratic Republic, Congo, and UN. So the UN Refugee Agency has signed two trilateral agreement with the Democratic Republic of the Congo and Sudan. The first tripartite agreement.
Abhay, your prescribed time has ended.
Oh, okay, ma'am. Okay. Can I conclude?
Yeah, sure.
Yeah, so I just wanted to conclude by saying that this is not a very commonly spoken about topic in any of our legal background or by any legal people. I want to encourage people talking about this topic because it is more concerned in current state of our world.
Is the refugee everybody getting the Aadhaar card in India?
Sir, no, they're not everyone. It's like they're trying to consider them to involve them in the economic
What is trying
policy.
to consider? Who is trying to consider?
The government of India, sir.
Read it. Do some research.
Okay, sir. Thank you. Okay.
Thank you so much, ma'am, and thank you so much for all the participants and the presenters. And some of them greatest level of the research, and some of them ordinary level of the research. If I want to say that, really some presentation is really good, and they're knowing the time management, other things also. But we need to some further updation related that for what exactly the UN role that human rights and the United Nations, the title was there in the theme. But what exactly they're doing that is the biggest question. And in this particular part, most of them they try to touch. Maybe the time may be the concern, but even though the very limited time we want to consider about that, what exactly the UN role of Palestine war? What exactly the Ukraine war? What exactly the Georgian war? What exactly is Sri Lanka? And that Tamilian and Sri Lanka Singla related the war, and what can I say? Some other things also. So many things happened that day. But what exactly at the time of war crime? What exactly the developed countries when they're doing war with the I think Iraq, and what happened that what exactly the role? The role is something written. It is there. The word it is there. When the weaker countries, for example, developing countries and developed countries only they want to follow it. This is the reality and necessity. The conditions really the truth is going there. But when countries developed, it's really not up to the much of they are not working. The words, particularly UN organization regarding the human rights, they're making a lot of treaties and they're making a lot of laws and very less for the penal action against who the violating the human rights. It concluded truth that if they're developed country, then there is no even action, only for the speech, only for the delivering lecturer. You can go to deliver, you could raise the voice in the United Nations Assembly, but there is no enforcement agency kind of powerful. When they're using the word sovereignty or internal matter. In the CASA today, what exactly happened that there is no network, there is no news reader, you cannot get anything connected between the UN nation also, and all the other countries news reader and collecting the common people also. What exactly the UN role? What exactly the Security Council doing? Became a question mark.
Yeah,
It's not
sure,
only
sir. Very true.
Israel. Even someday, if India and Pakistan war happen and India-Chinese war will be happen, who will go to bothered about that? What exactly the action? We made a democratic country. We are very, possibility way, we are positive manner we are approaching. That's why we are not like the war. But external aggression when it is happen, what we will do? So that's why we Bokran that we know that that exercise what exactly happened, that world is not ready to accept that. They said economic ban against India. Uranium and plutonium, only Russia only provided that. So we want to consider all those things also. And really the good theme, and particularly the currently, the needed topic, they made it the IBM university. It's really, great and thankful to them. And, especially inviting to me that ma'am and Aishi ma'am and Silky ma'am. And, special thanks to Gitanjali ma'am and the entire institution and, the opportunity provided by me. And I hope so. We will meet again also. If anything regarding my guidelines or some other things, if they needed, I'm always welcome. Thank you so much for the great opportunity to me. And thank you so much
Thank
to
you so
everyone.
much, sir. Thank you so much. We have really enriched with your concluding remarks. And I do hope next time when there are papers who cover the topics which you just mentioned.
Thank you.
Thank you, sir. Thank you, sir.
Thank you.
Thank you, everyone. And with the ending of technical session 4, we have just concluded our 4th International E-Conference on Human Rights. I would like to announce once again, with the conclusion of technical session 4, we have just technical session 5, we have just concluded our 4th International E-Conference. Thank you everyone for presenting your papers and making this conference a success. We are now looking forward to valedictory session, and we'll be beginning with valedictory session soon. Kindly keep up with us. Thank you. A very good evening, everyone. As we come to the conclusion of our 4th International E-Conference on Emerging Issues of Legal Aspect 2023, Implementation of Human Rights, International Perspective, Issues and Solution. For this conference, we were in collaboration with Indian Research Scholar Association, respected dignitaries, dear participants, respected technical session chairs. What an eventful day it has been. When I started the conference, I already mentioned that conferences are used to bring people together, having common interest. For today, all of us' interest was in human rights, their place in our society, the important role that they play, court perspective, and perspective of various research scholar faculty members of various universities. We discusses various issues relating to human rights and their implementation. A conference in itself, as the word itself suggests, requires intensive time, planning, and resources and brainstorming. And I'm sure this must have taken toll on the faculty members of IPM Law Academy. The main purpose of a conference is to provide a network of platform for networking, education, and collaboration among individuals. And last but not the least, we all know what an eventful day it has been. In this conference, there were a total of 43 papers which were submitted, and today 37 people presented the paper. Human rights are the basic rights which are available to individuals by the matter of the fact one is a human being. After listening to various views, seeing human rights from different perspectives, I am sure we must have gained a little different point of view what we already think about or know about human rights. As we come to the validity session, I would now like to invite Dr. Vikas to please give their validatory address.
Okay. Thank you, ma'am. ये one minute, ma'am.
Sir, Dr. Vikas.
Yes, ma'am. So, I
Yourself.
think,
Kindly
madam,
unmute yourself and
I think you have.
give your validatory address. We all are
Okay.
waiting for you.
Yes, ma'am. I can listen you. But I think you have share your screen. So due to this reason, my screen is not sharing.
So now you may share your screen. Us shortly. Sir, am I audible to you?
Yeah. Yes, ma'am. Can you see my PPT?
So we are waiting for your validatory address.
Yeah. Yes, ma'am. Ma'am, you can see my PPT. My PPT is visual, ma'am?
So yes, your PPT is very much visible. Thank you.
Okay. Thank you, ma'am. Thank you. So, first of all, I would like to congratulate the IPM Law Academy, who has taken a very good initiative and selected a wonderful topic. Not This topic is very relevant in the contemporary scenario, and it's not only relevant for the in the global perspective, but it's also relevant in the regional perspective, in the Indian perspective, in the third world countries perspective. So I would congratulate to the IPM Law Academy, and I would like to thanks and congratulate to Dr. Minakshi Tomar Madam, the principal of this institution, who has given me this wonderful opportunity, and she has contacted us and collaborated with our association, and it's also a great opportunity not for me and also for the Indian Research Scholars Association, because we have collaborated in this seminar. I would like to thank co-convener of this international e-conference, Priyanka Gupta ji, Purnima ji, Mukesh Pandey ji, and all the staffs and the faculty members, teacher, non-teaching staffs of these institutions. So today I will deliver my lecture in this. I have selected for the plenary session, implication of civil society in the contemporary perspectives of human rights in the democratic world. So today we can see the lot violation of the human rights in the not only the in the Israel and Palestine and Ukraine and Russia, but we can see in the also in India and in our region, because I belong from the remote areas, and my university is located in the tribal remote areas, and so I have written some research paper regarding the consciousness and awareness of the human rights of the tribal women, of the tribal people. So they all have very lack awareness and very lack informations regarding this. They have nothing information, and they have also never used these types of the rights. So it's also relevant for that types of the people. So today I will deliver my lecture on these points. First introduction, historical background, human rights before the World War II and after the World War II, development of the human rights and the role of the United Nations Universal Declaration of the Human Rights, global perspective and contemporary scenarios of the civil society. So first of all, I would discuss the what is the significant role, because I can think that I have a few minutes for deliver the lecture. So just I will give the some findings of this lecture and the suggestions. So role of the, what is the role of the civil society on the human rights? So the term of civil society was mainly developed by the European thinkers, which was defined by the different thinkers according to their country, time, and situation. Some thinkers had given the names, different names of the civil society. So civil society is a group of the people who had worked for non-benefits, and who has organized association, organizations, and unions, and work for the common people, for welfare the people. So it also known by the various name, such we can, I have already discussed in the previous. So women's organizations, group religions associations, group farmers as organizations, or various non-profit organizations. So they attack to attend attentions of the government and the general public on the prevent social issues and fulfill the objectives by increasing the participation of the activism of their community and the special interest which the capacity of the particular community develops in the political terminology. They are also known by the names of the social organization, independent support, and the groups, social movement, voluntary organizations, non-governmental organizations, third-party sector, and non-profit organizations. So they all are working for the common people, and they all are working for the welfare of the people. So there are the a lot of the definitions, and they have given by the different thinkers of the civil society. So it's a different way, but what's the interrelation of the civil society and the human rights? So the such kinds of the, like the you can see the this PPT. These all are the international organizations, international association, and it's also a part of the civil society. They all are working for the human rights, and they all are spreading the values of the human rights in the different countries, not only the Europe and America, and also the third world and the Asian countries. So these all are the groups, and these all are the associations which is a part of the civil society. So there's many these organizations work in the fields of the human rights and provided a legal education, awareness, and advice, as well as run different types of the protest and protect the right to individual and right to individual groups. So contribution of the civil society organizations can be seen in various activities, ranging from the financial assistance to various people and support in to the legal actions. So this is the reason that in the civil society an attempt has been made to include their suggestion along with the role of the civil society organizations, because the most of their activities are non-profit, which are implemented in the backward areas, remote areas, and also in the tribal areas. So in previous year, I have written a research paper, and I have read the report of the some agencies. So these all agencies have given the suggestions, and these all agencies have yes, madam. Okay, madam. Okay. So these all agencies have given that in India has a lack awareness, legal awareness in the remote areas and village areas. So along with conducting various types of the human rights activities in such areas, work is also done for free education, material education, awareness campaigns, healthcare facilities, and right to information, environmental protections, various types of the human rights concern. So they implemented there the policies and work accordance with the prevailing law in the particular country. But there is an anomaly that sometimes they oppose the law enacted by the law itself, and the government have to modify or withdraw it. So it's a general assumptions of the pupils, not the common pupils. It's the general assumptions of the some intellectuals, and some we can say that some volunteers, government volunteers who is work in the remote area, that the human rights associations and groups and organizations always works against the government and government policies, but I'm not agree. This is such kinds of the ideas, such kinds of the thinking, because some civil society organizations uh, uh, do your work very good, and some is exceptional who are not fulfill their objectives. So this is the role of the civil society to spread the values of the human rights in the different areas. And civil society organizations and associations is not only in the work in the India, but it's they all are working in the different areas. That uh, very a few minutes. So these all are the challenges, and these all are the roles of the civil societies. And again, I would like to congratulate to the IPM Academy and the convener of this international e-conference. And they have given me opportunity to deliver lecture. And so again, thank you so much. Thank you so much. Thank you. हर्षेक जी, इसका बंद कैसे?
कर देते हैं साथ साथ कर देते हैं साथ साथ कर देते हैं साथ साथ करना बेटा
Thank you so much, sir, for such an enlightening and enriching session. I'm very sure the audience must have really enriched from the information provided by you. For next, we have Dr. Monica Naral. Ma'am, kindly come online to give your valedictory speech. Ma'am, kindly unmute yourself. We are not able to hear you out.
Hello, am I audible now? Hello.
Yes, ma'am, you are audible.
Thanks a lot. So I congratulate all of you without taking much of your time. So I was given time for 4 o'clock for 15. Now it's more than 5 o'clock, and I'm not in my town. I'm in Shimla right now. So I decided to present online from here only. So uh, it's a very wonderful thing that you have convened this conference in a uh, very nice topic. That's on the focus is on human rights, national as well as international. So I'll be having my this valedictory speech on combating gender inequality, especially women in India, in the wake of this human rights scenario. My this not yes. So I will not be just elaborating on this gender inequality, as we all know what do you mean by this gender inequality, but I have tried to correlate this gender inequality with the human rights scenario. So India has been suffering from this menace since long, now from the ancient timing. My focus especially is on the women, that they have been their rights have been violated since long. So what is the aim? That we all know what is the aim of this gender inequality, that as per the concept of human rights, where men and women, they should enjoy the same rights and they should be treated equally. This is the right which is for everyone, for without any discrimination. So I have tried to correlate this gender with human rights concept, where it is I have also tried to make a focus on this socially learned behavior of the, as how the society expect from a woman, because what type of mindset the people are carrying regarding that how should be a woman, and how she should behave in the society. So this is my expectation of society regarding women and men. I will be just taking note of it in a very crisp manner, that women is considered to be homely, caring, patient, obedient, loving, giving, selfless, dedicated, no desires. Whereas the men, they are the bread earner. They are considered to be bread earner, master, boss, dominating, centrifugal, demanding, then delegating jobs to wife, careless, independent. So this is just the expectation of society from what they conceive as a mindset for regarding a woman. So this is the gender, how we relate with this inequality. Then the how the people, they perceive the girls and boys, and how should they should behave and live their lives. There, and I've also tried to relate these social evils with the human rights perspectives. In our society, there are many social evils like sati, child marriage, rape, dowry system, female infanticide, female feticide, female trafficking, denial of education, child widow, slavery, teenage pregnancy, exploitation, voyeurism, marital rape. My scholar presented paper in the morning that was on the this marital rape, then forced abortion, sexual harassment, obscenity, and pornography. But to talk about our constitutional perspective, we have the provisions in the Constitutional Law of India as per Article 14, 15, which is prohibiting discrimination on grounds of religion, race, sex, or place of birth. Article 17, abolition of untouchability. 21, protection of life and personal liberty. Article 21A, free and compulsory education to children up from the age group 6 to 14 years. 39D, equal pay for equal work. So these are the legislative attempts in India, like child marriage, regarding medical termination of pregnancy, preconception and prenatal diagnostic techniques, dowry deaths, and there are the dowry laws, sexual harassment, equal remuneration. So I've also related with the Prohibition of Child Marriage Act, that's of 2006, then Medical Termination of Pregnancy Act, then the what do we have in this MTPA Act, and the Preconception and Prenatal Diagnostic Techniques Act of 1994. Then what is there in this PNDT Act, then the dowry prohibition laws, then Protection of Women from the Domestic Violence Act of 2005, then Equal Remuneration Act of 1976, how the human rights have been restored with this with these kind of enactments and the acts. Then the Indian Constitution also recognized the principle of this equal pay for equal work for both men and women, and also recognized the right to work under Article 39D of the Constitutional Law of India. Then I think in this I have attended some of the presentations since morning. So they have talked about the sexual harassment also, and there's an act of sexual harassment of women at workplace of 2013, which deals with the prevention, prohibition, and the redressal. Then it's an Indian law which is created to make the workplace for women as safer and secure by preventing, forbidding, and remedying acts of the sexual harassment against women in the workplace. So how do we understand this definition of sexual harassment? I think all the legal luminaries, they know about the definition. What does it include? That I've also shown it in a graphic manner. That what do we have? There's a flow chart, I must say. And then what is the objective for of this particular act? That is redressal of complaints of sexual harassment to ensure safety of women from within the workplace, safeguards against false or malicious charges. And this act also covers the quid pro quo harassment. That's a very important thing here, which creates the hostile work environment. I think you all must know with this that this for that is the quid pro quo harassment. So women have been the victims of this domestic violence, sexual assault, rape, tutelage, etc. But with the recent breakthroughs in science and technology, women have also been the victims of a new type of crime, which is known as the cyber voyeurism. So it is actually from the voyeurism that one of the most severe and extensively practiced sexual behaviors of the others. where the void has gotten much easier and more widespread as video and image capture technology have been advanced. So it's an act that flagrantly violates all reasonable expectations of privacy in a person's life. So moving on, I have also come to know about a new, let's say, change in that. The Supreme Court has released a handbook on this gender stereotypes. So in a quest for equal rights for men and women, the Supreme Court of India has taken an important step that by releasing a guidelines to take on harmful gender stereotypes that perpetuate the inequalities. So laying down a set of do's and don'ts for judicial decision making and writing, where at the in the pleadings or the drafting also, the words like that house where we call she's a housewife, but now actually she's a homemaker. So there's a where it's a handbook on combating this gender stereotypes, which is helping judges to identify language that promotes incorrect ideas about women in particular and offers alternative words and phrases. So voyeurism, I have already talked about that. So where there is a hidden camera which is placed, and it's like a peep tom. It's a since long this has been into practice, but the cyber voyeurism is a upcoming area where it leads to the violation of the rights of the women also. So, as per the Criminal Law Amendment Act 2013, it has inserted after that Nirbhaya Act several new provisions in the code as a means to bring such culpable acts under the ambit of potential offenses. So, to talk about the national perspective, we have the Protection of Human Rights Act of 1993, wherein we have the facility of National Human Rights Commission and the State Human Rights Commission. And we all know India is a member of United Nations organization, and the very first written this international human rights document, that the Universal Declaration of Human Rights of 1948, then the Covenants of Civil and Political Rights 1966, and International Covenant on Economic, Social and the Cultural Rights, and the Declaration on the Elimination of Discrimination Against Women 1967. So the protection against sexual harassment and right to work with dignity are universally recognized human rights by the International Convention and instruments such as Convention on the Elimination of All Forms of Discrimination Against Women, 1979, which has been ratified in India on 25th June 1993. So, as per Universal Declaration of Human Rights, I have already talked. Another thing which I wanted to project, that was the Indian policies aiming this women emancipation and empowerment. So there are basic schemes like Beti Bachao Beti Padhao scheme is there, One Stop Center scheme, then Women Helpline scheme, then Ujjwala scheme, then Working Women Hostel scheme, and Swadhar Grass scheme is there, Sport to Training and Employment program for women. So these are the various steps by the government where it is helping for the restoration of the women human rights. Then the Mahila Shakti Kendras are there, Nirbhaya 2012, then Mahila Heart, Mahila Police Volunteers. So there are many facilities are there as per the restoration of the rights to women, where we can combat with this gender inequality also. But in spite of various provisions at national as well as international level regarding awareness as well as to curb the menace of gender inequalities, every now and then a new case occurs. So there should be effective implementation of the provisions that we've already related in nutshell, and acts which are not only require creating an environment where women can speak up about their grievances without fear and get justice, but the sensitization of men towards treatment of women is equally necessary. So there has been instances of various crimes against women which are occurring in India because of the inherent defects in the existing law of India that has led to the gross violation of human rights. So one of the biggest tragedies as far as the legislations in independent India is concerned is that India does not have a dedicated system to protect the privacy of its citizens. So there's lack of express provisions for dealing with the offense like stalking and voyeurism, and there is a need to improve the laws to make it effective, as these offenses are very common these days. And most importantly, that people, they don't file cases against the accused person, and the people are still not aware of the existence of these laws, and for those who are aware are doubtful for the success rate in instituting such cases. So the government should pass the more effective laws which can help the victims in getting justice. So mental harassment is mostly more violent than the physical harassment. So these can cannot be seen by others but last forever and keep affecting the sufferer. So that's all from my side. Otherwise, there are so many things to discuss, but I just focused on women. We could talk of children, we could talk of the others, LGBTs also, but my focus was on women as per the gender inequality. Thanks a lot for giving me this opportunity. Thank you so much.
Thank you so much, ma'am. It was quite an interesting session with you. I assure you on behalf of IPM Law Academy, as one of the faculty members, that we have highly gained knowledge from your session. The knowledge shared by you is invaluable experience for all of us. Thank you
Thanks
so
a
much.
lot. Thanks a lot, ma'am. Thanks. I can stop sharing now.
Now, as all the good things come to an end, come to a conclusion, our fourth International E-Conference on Human Rights also has come to the conclusion. But for every conference, there has been a lot of hard work and a lot of people to be thanks to. For doing this duty, I have my capable faculty colleague, Ms. Priyanka Gupta. I would request her to kindly come on stage and give her valuable vote of thanks and thank everybody. Thank you, ma'am.
Good evening, everyone. It is with immense pleasure and gratitude that I, Priyanka Gupta, an assistant professor at IPM Law Academy and coordinator of International E-Conference, stand here to deliver a vote of thanks on our enlightening topic of the Conference on Human Rights, the International E-Conference on the Implementation of Human Rights, International Perspectives, Issues and Solutions, marks the witnessing of a wealth of knowledge and insights shared by 6 remarkable speakers and 37 presenters who have dedicated their time and expertise to contribute to the success of this conference. First and foremost, I want to extend our deepest appreciation to our keynote speakers whose thought-provoking presentation enlightened us on a wide range of issues related to human rights. Your dedication to your fields of study and your willingness to share your knowledge have been invaluable to all of us. Your commitment to the cause of human rights is truly commendable. We would also like to thank all the participants who submitted their research paper and actively engaged in the discussion. Your commitment to advancing human rights perspectives and your diverse conviction enrich our discourse and help us to have a better understanding of the complex challenges and potential solution in this crucial domain. I also extend my sincere gratitude to our principal ma'am, Dean Academics, and Executive Director for their valuable guidance and support. I thank all the attendees for their active participation and also for engaging in the session by asking questions and initiating thought-provoking discussions. Last but not least, I would like to extend our appreciation to the organizing committee, volunteers, and technical support team to ensure the seamless execution of this conference. I want to acknowledge each and every one of you as your collective presence here signifies your shared commitment to promoting and safeguarding human rights. It is through such collaborative efforts that we can aspire to make the world a better place for all. As we conclude this conference, to continue our pursuit of excellence and improvement, we kindly request all the participants to fill out the feedback form that has already been shared with you. Your feedback is crucial in helping us to enhance the quality of our future events. Thank you once again to all of you for your active participation and support. This conference would not have been a success without your dedication, enthusiasm, and expertise. We look forward to future collaboration and endeavors in the pursuit of human rights on a global scale. Thank you and have a wonderful day.